All right, good afternoon, everyone. Today is Wednesday, February 8th. Welcome to the Judicial Proceedings Committee. We have 12 bills on the docket. So I'm going to go in the order. The first bill we have is Senate Bill 220. So we'll invite the judiciary up. But before that, I'm going to kind of announce the order. We're going to have a slight change. After Senate Bill 220, we'll have Senate Bill 15 as number 2. And then we'll go to Senate Bill 115, 203, 227, 229, 87, 98, 192, 190, 211, and we'll end with Senator Carter at Senate Bill 33. So with that, we'll start off with Senate Bill 220, which is the Judicial Conference Bill. We have 2 folks on Zoom to testify. Welcome.
Hello.
Do you all want to play the video first and then start your testimony? That's what okay, I'm seeing a nod. Yes, we're going to go ahead and play the video, which is about 4 minutes, I think, and then we'll transfer over to your virtual testimony. All right.
I just literally stopped going to school. Like, I was going through so much that it was just like, what could be worse? So I just stopped going to school for a long time.
I think the alarm bells and the red flags went off when she stopped coming to school. Those were the actions that were different than they had been in previous years.
I hated school. Like, I hated everything about it. I was always in drama. The work was hard. I didn't have little to no motivation. I went through a lot of stuff at home. So it made me want to just give it all up. Like, school was just another stress to me.
We knew we were going to need that extra partnership and support with the court system and the Truancy Court and Judge Jensen.
Having the court kind of be a partner with the school system was a huge deal, and it was a huge opportunity for her to take advantage of those extra supports and finish out what she needed to do to get that diploma.
When she heard for the first time that she wasn't going to walk with her class, her whole countenance, it was like her whole body just sort of like sunk in on itself.
I didn't want to go on Snapchat, none of that, no social media, see everybody having fun and they cap and gown. I was sad because I went through a lot all 4 years of high school, and that was the biggest thing I was looking forward to, being the fact that I had made it because I wanted to drop out since my 9th grade year.
Maybe you didn't walk with your class, but to me, being here in court today and sticking this thing out to graduate is an enormously incredible thing that you've done. Today, you should know that you are successful.
I want to recommend to the Kent County Board of Education this member of the class of 2018 as a qualified candidate for the state of Maryland diploma.
You're probably the first high school graduate that's ever come through the circuit court for Kent County.
You wanted to give up, but I could still see through all the words you said that you didn't want to give up.
What it goes down to, if you put your mind to it, you can accomplish anything. I'm proud of you and I love you.
We judges don't get to do a lot of happy, feel-good types of cases, and to see that the court's efforts in collaboration with the Board of Education and with Kendra's family achieved a goal gave me just personally great satisfaction.
At first, I didn't want any help from anybody. Now that I see it actually paid off and helped me, it felt like I actually had people on my side. Like, I didn't think none of this would come my way.
I think for the first time today, she held her head up and she looked me square in the face. And I love that, because that just says a lot, that she's got some confidence now that I didn't see 2.5 months ago.
All right, excellent. It's a tremendously uplifting video. Okay, so we'll start off with do you want to start off with the in-person folks first, and then we'll go to the virtual first? Okay, yes, Judge, welcome.
Yes, hi. Yes, I was not the star of that video. Kendra was.
It's great.
I want to tell you that a couple of days ago, the coordinator for our program actually spoke to Kendra, and she is doing great. She's a mom now of a 3-year-old. After high school, she did go to work, loves fashion and cooking, but right now is concentrating on being a mom. And she was just thrilled to hear from our coordinator. So when I watch that video, I remind myself why I'm still doing this 5 months or 5 years later. But to be a little bit more formal, my name is Karen Murphy Jensen. I am a member of Maryland's judiciary. I have been for 23 years. The first 16, I was the circuit as well as administrative judge and only judge in Caroline County. And the last 7 years, I have been a senior judge, and I have elected to focus my time on the bench in the area of domestic, family, and juvenile cases. I've had the immense privilege the past 5 years to work alongside with Judge Harris Murphy in Kent County Circuit, no relation. He asked me to preside over the truancy reduction program there, which was started back in 2014 by Judge Paul Bowman. And it was established again by state statute and has been operating as a pilot truancy reduction program with the blessing of our Supreme Court. See, I can say that now. I've said it a couple of times. Our Supreme Court, and with the guidance of the Office of Problem Solving Courts. Kent County is one of, I believe, 7 current truancy reduction programs established under the present statute, which does enable each county as well as Baltimore City to seek a legislative authorization to set up a pilot program in their courts. The proposed legislation in front of you, SB 220, if passed, will make it easier to establish these truancy reduction courts. It will enable each county administrative judge to establish the program, complying with court rules on how to establish problem-solving courts. It specifies the actions which the court can take to assist students in the program. And finally, it requires the judiciary to submit an annual report to the General Assembly on the progress of the courts and proposals for improvement. Briefly, a problem-solving court is a specialty court in the genre of therapeutic jurisprudence. And the hallmarks of these courts are really identification of a problem or issue that brings a person in contact with the justice system. It involves collaboration between the court and community partners to work with a participant to sort of have an individualized approach to solving problems that, again, bring them in contact with the system. You're probably familiar with drug courts or drug treatment courts, where substance abuse is the focus, but there are many other. We've got mental health courts, reentry courts, folks coming out of incarceration, being on probation or parole and working with the courts to make sure their reentry into society is successful. We've got veterans courts. We even have child dependency courts, where families whose children are at risk of out-of-home placement and foster care work with the courts. So with the truancy program, our aim is to work with students and their families to re-engage students with school and school attendance, identifying the reason or reasons why a child is not attending school, and then working together with community partners to develop an action plan to remove or at least minimize the barriers for school attendance. So when a student comes into the Kent County program or to any of the existing programs, it is the Board of Education of that county that files the petition, and the Board of Education is responsible for proving whether a child or a student meets the definition of truancy, which by state law means 8 unexcused absences in a quarter, 15 in a semester, or total of 20 days in any given school year. The case is assigned a juvenile case number. The student is afforded due process by way of notice, opportunity to be heard, participation with the parent, hearing on the record. The proceeding is civil and is not a delinquency proceeding. There is no right to counsel, but families are entitled to have legal counsel if they wish and are encouraged to do so. I want to emphasize what the program is not. And I do emphasize this with the families that come into the program. First, since this is not a juvenile delinquency proceeding, the court has no authority to place a child in out-of-home detention, community detention, or otherwise place the child in a juvenile facility. As a civil proceeding, the Department of Juvenile Services is not a party. Secondly, it is not a criminal proceeding. So once in the program, a parent cannot be incarcerated if they do not cooperate with the program. Third, it is not a child in need of assistance proceeding, and Department of Social Services is not a party. The court cannot remove a child from his or her home and place in shelter, foster care, or any other out-of-home placement for failure to attend school or otherwise engage with the program. And finally, participation in the program, whether successful or not, does not lead to negative consequences for the student. The student cannot be suspended or expelled for failure to attend school, and thus they cannot be suspended or expelled for failure to engage with the program. But by not taking advantage of the program, a student may be more likely not to graduate. By not taking advantage of the program, students in elementary school, and yes, I've had kids as young as kindergarten in the program, they run the real risk of not being prepared for middle school. Failure to attend middle school puts the child at risk for not being prepared for high school, all leading for the very real possibility that that child will never get a diploma or a GED. More likely that we judges will meet that child in a delinquency proceeding or after 18 in other court venues. In my role as a judge in one county, and there's only 7 of us left in the state, we have the unique perspective of really intersecting with every case type: criminal, juvenile, SINA, domestic violence, domestic, non-domestic. I can't tell you how many dispositional reports I've read in juvenile proceedings, reports from the Department of Social Services, custody evaluations, and pre-sentence investigation reports that talk about that individual that the reports focus on having dropped out of school or otherwise have had truancy in the family. It may sound a little bit dramatic, but I really truly believe, like, when you look into a child that is truant, you are looking into the soul of a family, and you are able to identify so many factors that cause a child to miss school, not want to go to school, or otherwise disengage with school. These programs, our goal is to re-engage kids with school. And after 5 years of working with the Kent County program, I still want to do it. And I think that says something, because really at any time I could say, I don't want to do this anymore, but I don't, because it really and truly changes these kids' perspective on school. And I am proud to be the first one to present on this bill on behalf of the judiciary. So I'll yield the rest of my time to the rest of the presenters. Thank you all very much.
Well, Judge, thank you very much for that, and thank you for your service on the bench, and thank you for this program. This is a great video, great program, and we'll save some questions for after the entire panel. But just want to say thank you for that, and thank you for your presentation. Do you want to go to the other virtual? Or you want to? Yes.
Yes.
Okay.
Thank
excellent.
you. My name is Althea Stewart-Jones, and I've been a family magistrate in the Circuit Court for Prince George's County for almost 16 years. This is my 13th school year presiding over our Truancy Reduction Court program, and I am in full support of passage of Senate Bill 220. In addition to presiding over our Truancy Reduction Court, I preside over our child in need of assistance cases, which are child abuse and neglect foster care cases, and some delinquency cases. I believe that my dockets in those 2 areas especially in the delinquency docket, would increase if we did not have our truancy reduction court program in our county. Our students and our families are referred to us from the Board of Education, specifically our education liaison. These students and families come to us with the same issues, the same difficulties as my center and delinquency youth and families. However, the approach in our truancy reduction court with working with these families is different. Problem-solving courts focus on understanding and getting to the root of the problems that causes our truancy kids not to go to school. They often don't go to school because of different issues. It could be issues at home with a sick parent and caring for them, undetected and undiagnosed mental health, physical health disabilities or impairments. Our truancy court coordinators and our case managers are in weekly contact with the youth and families and provide support and referrals to address their issues. Due to the growing population of Latino families in our communities, we have a bilingual case manager that helps facilitate communication and makes our Latino families feel more at ease. The research shows that students who are at risk, truant students are at risk of substance abuse, high school dropouts, delinquent behavior, pregnancies, etc. We provide this information to our families upfront as part of our handbook so that they are aware of the risk. Most of the students make the connection right away because most of them are engaging in these types of behaviors. Our program has helped turn these behaviors around. Not only has it gotten their attendance to improve, but they are connecting and re-engaging with their teachers, their pupil personnel workers, their guidance counselors. Truancy court is not a school to prison pipeline. It is just the opposite. I've had plenty of cases where there have been pending delinquency petitions, but through the efforts of our court putting those services in place, when it came time for the delinquency adjudication, those petitions have been dismissed because our students have been making progress and the delinquency judge did not see a need to get involved, nor did the Department of Juvenile Services. So we are making those connections. Since the inception of our truancy reduction court program, we have had 153 graduates. We are proud of that accomplishment, but that doesn't fully tell the story. Many students who have not been able to meet the rigorous graduation requirements of our program have still benefited greatly from the court program. Their attendance and their GPAs have greatly improved. They have better relationships with their parents and school personnel. The parents have learned to better parent. We have provided workshops, parenting one-on-one. A lot of parents don't know certain things about discipline. The first thing they may think of is corporal punishment, but we have shown in different ways to make sure that they provide the right structure and the right discipline to help their children instead of harming their children. These families come to us, they're dealing with homelessness or food insecurities. Our case managers pretty much work 24/7 to make sure that they are getting the resources that they need. And this was really evident during the pandemic. I hope that my testimony has provided a glimpse of our truancy reduction court program and the positive impact that it has had on our community. I sincerely hope that all jurisdictions in the state of Maryland are afforded this opportunity as well. Thank you.
I think I'm supposed to go next. I hope so. My name is Joni Raymond Brubaker. I am a family magistrate in the Circuit Court for Frederick County. I've presided over juvenile delinquency as well as the child welfare court and the family court here in Frederick for over 6 years. I also see the youth who have entered the delinquency or the child welfare system, many of whom we've heard and we know will go on to enter the adult criminal justice system unless we can break that cycle and change the path of where their life is headed. Most of the youth that we see in delinquency in Senate court have had a lack of support in their family life, substance issues, either themselves or family members, early trauma, and attendance and behavior issues at school. And they've had those well before coming into the delinquency system. Truancy has been identified as one of the early warning signs for delinquency, social isolation, or educational failure. Without a high school diploma or GED, these youth we know are not as employable, and they earn less than their graduate counterparts. And we know that keeping kids physically in school increases their chances of graduation, and it increases their chance of success, giving them a solid foundation to go on from that point. And the courts have the unique perspective and ability to be able to coordinate and oversee delivery of these services to the families. This truancy court allows us to intervene earlier and identify these youth earlier. And then the court can be the convener and bring these services to the youth and the families who are identified early on and help to get them to re-engage in the educational process before coming into the juvenile delinquency system. So breaking those patterns earlier. We want to address those root causes, whatever's going on in the family or with that youth before they become ingrained family patterns, because often what we'll see is we see a truancy issue with an older student, and then we see the same pattern with the younger siblings. We've already in Frederick started partnerships with organizations in preparation for having a truancy reduction court. We've partnered up with the Boys and Girls Club, the Health Department, the Spanish-speaking community of Maryland, mentoring services, in order to be able to provide all the services we can to families. Currently, what Frederick County has is we have an informal council. We are not one that's been approved under the pilot program to have a problem-solving court. So at this point, we cannot meet all of what these family needs. We need to have that structural support that a problem-solving court provides. What we're doing now really isn't sustainable. We've been in operation for about 1.5 years and are kind of just hanging on at this point. Having a truancy reduction court will allow us to have a coordinator to manage everything, provide transportation for these youth. Right now, we're meeting out at a location that is outside of the city bus system. So we have transportation that we can provide for students. Fund family assessments, which are much needed to try to get a little more information about these families and what's going on with the dynamics, and be able to provide incentives for students and families, which is one of the things that everybody's been focused on, that this is a therapeutic model. It's not a punitive model. It's all about helping families, wrapping them in services, giving them every opportunity to remove those barriers to education. It is truly a preventative service, a preventative type court, not a punitive one. I truly believe that allowing these courts to operate in all of the jurisdictions that want them will result in seeing fewer of these youth in our delinquency courts, our child welfare courts, and our family courts. And just as importantly, in our adult criminal courts. So I have great support for Senate Bill 220. I hope that you will consider it, that you'll ask any questions you need that to understand the program. And I thank you for your time and your service.
Good afternoon. My name is Jamie Townsend, and I have 2 daughters which have been in the truancy reduction program for a few years now. In the very beginning, what initially got us in truancy, I had relapsed. I'm a recovering addict. But starting the truancy reduction program, I was referred for mental health and substance abuse treatment, which helped me tremendously to become the mother that my children need and deserve. And ultimately, as a result, the children were attending school regularly as they should have been doing. More recently, there was another issue at hand as we had mold in our home last year as the result of a leaking roof within the home in both bedrooms. Truancy reduction program, once again, found resources that were available, got me in touch with them, and they offered to pay all repair costs, even the estimate as to get that fixed, to eliminate the sickness within the household, which again prevented the children from attending school on a daily basis. Overall, this experience with truancy reduction program has been very beneficial. It's really more like a family, very supportive. Anything that we need, it doesn't matter. If they can't help, they put us in touch with someone who can. Transportation, anytime that I've had issues with transportation to court, even someone has been there to pick my children up as well as myself, transport us there and transport us back home. And honestly, we actually look forward to attending each hearing now. It's very rewarding, and I do believe that it would be beneficial to other families, no matter what their circumstances are and what is preventing their children from attending school. Thank you.
So as to not repeat too much of what the other witnesses have said, I can share a unique perspective. As teams working in Maryland's truancy problem-solving courts, we have a great opportunity to independently evaluate the needs of our participant families and hear their stories and evaluate the actions available to be taken in our schools and our communities to meet those needs. No matter the county or the court involved, we share the common mission of increasing the youth's consistent access to their education and ultimately the future that they deserve. I'm a regional program manager, court coordinator for the First Judicial Circuit's Truancy Reduction Program in Dorchester, Wycomico, Worcester, and Somerset counties. I've been working in that space for the past 6 years. And to be honest, over those 6 years, I have fielded many phone calls and emails from families around the state, from as far away from me as Washington County to Baltimore City, and all the way out to our friends in the great state of Hawaii, asking how they can have access to the program supports and structure that we have in the lower 4 counties of Maryland's Eastern Shore. The families that have reached out to me are seeking support and answers that they have not found or have not had a connection to within their own counties. Too often, I have had to explain to them the limits of the reach of my program and the statute as it exists today, while working to try to help them identify at least one appropriate and available resource in a county that I'm pretty much unfamiliar with and find someone to create a soft handoff to. That unfortunately that family is going to have to share their story. They're going to have to tell it all over again, but hopefully will be the person that's able to help them. We're here today because, like us, you have a great opportunity. The opportunity to ensure that those families, the families living in some of your very counties and the rest of our state, have the same access to the supports of problem-solving courts rather than relying solely on punitive actions to create lasting change. I cannot thank you enough for the opportunity to be here, for your consideration of this bill and your favorable vote for SB 220. Thank you.
Thank you, Mr. Chairman, committee members. My name is Gray Barton. I'm the director for the Office of Problem Solving Courts. In my role, I oversee the planning, implementation, and sustainability of problem solving courts for the judiciary. And I've done that for over 20 years now. I don't think, like Kendall said, I don't think I need to repeat anything that the judges, magistrate, and definitely the parents said here. I wanted to point out in my testimony that for any new truancy court, like any proposed problem solving court per Judiciary Rule 16207, they must complete an application submitted by the county administrative judge that spells out the type of program, the target population, what issues are being addressed, the tenets of the program proposed, and the partnerships that will be supporting the program. These applications are vetted first by my office, then through a committee of problem solving court judges and magistrates, and then ultimately to the Chief Justice. Once approved by the Chief Justice, funding and other resources can be provided to the local courts. We also monitor best practices and promising practices while providing training and technical assistance to those programs that need it. The Truancy Reduction Court is but one part of continuum of options for students who are absent and disengaged from our schools. By the time the child enters this Truancy Reduction Court program, the school has been unsuccessful in implementing multiple non-court options. Doing nothing for these students is allowing them to give up on their education, and that is not an option. This program is beneficial because it gets students back to school, identifies barriers to school re-engagement, and provides these children and their families needed services. I understand that there will be people that will who are actually not working directly with the truant students who will argue that these courts are essentially a pipeline to prison. I argue by listening to a parent who is here today, by the judges and magistrates, by the written testimony from school employees that, okay, thank you. that is demonstrated without question that the needs of these children and their families are what's at stake for the jurisdictions who will not be able to participate in these sound problem-solving court programs without the passage of Senate Bill 220. Thank you very much.
All right, thank you all very much. We have a couple questions from the committee. So we'll start off with Senator Washington.
Thank you, Mr. Chairman, and good afternoon, everyone. Thank you for presenting this bill today. I do think it's a well-intentioned bill. I do think that there are some things that are great within the bill itself, but I do have a few questions on it. In the bill on page 6, it has the collection of potential data pieces in here that we want to see moving forward for all jurisdictions to collect. It says the number of programs established, the number of children participating in each program, information on outcomes. What I haven't heard is that data from this group about participation of how many students have been in some of them. I'm also looked at some of the written documentation that has been sent. If you have that information, can you provide that to me? If you have that information of how many students applied to the program or went into the program, and then the outcomes for those two, I think it'd be great to either hear or have. And this is only in 6 jurisdictions, is that right? 7. Thank you.
Operational in 7. Operational in 7.
And you don't have to read the whole thing to me. I just want to know.
Yeah, I'll just give you a few highlights, and we will definitely follow up with you.
Thanks,
Senator. But last fiscal year, there were 387 students that were served and families that were served by the truancy courts in Maryland in those 7 jurisdictions. Those jurisdictions, obviously, the Lower Eastern Shore, Harford County, Prince George's County. Yeah, I'm missing one. Oh, Kent County. Sorry, Judge Jensen. In those, I want to point out one stat that we definitely have is that there were 641 referrals to services for those children and family. The number 1 referral for all those students was for mental health services, followed by transportation and then by housing. So I will definitely get you stats on this, sir.
Got it. No, thank you for that. I mean, that makes a lot of sense. What about the age, race, disability, the truancy rate of the student itself? Do you have the averages for those or the numbers for each student by race, by age, by grade?
I can get you those.
Is that available?
I don't have that with me, but yes.
Okay. No, I think that'd be good to have because we know that a lot of Black and brown students are most times overly referred to a lot of these programs and for different reasons. But it'd be good to know where that stands currently throughout the state, throughout these 7 jurisdictions, right? So
yes, throughout the 7, I'll give you those.
Okay, no, that'd be great. And I wondered about from Prince George's County. I don't know if the gentle lady is still here. Hey,
Yes.
how are you?
Fine, thank you.
Yeah, in Prince George's County, you mentioned that the referrals come from the school system or initiated by the school system. Is that
Yes.
correct? Great. Is that true for all 7? Do you know if that's true for all 7 jurisdictions? Okay, because it seems like in the bill, it doesn't say that. It says that it comes from the judge, the administrative judge.
That's how the programs are actually created.
Correct.
Right, but the referrals themselves come from the Board of Education.
Okay, I think you'll have to point that out to me where that is in the bill. Because I don't see that in the bill of how that's, because I want to make sure that it does come from our Board of Education.
Mhm.
You can answer it when you come up and speak to. You can speak to that when you come up and speak, but I wanted to make sure that it does come from the Board of Education and not
Okay.
from the judges themselves. And I think my last question is about training for judges that oversee these programs. What type of training dealing with students or truancy or family matters that judges go through? What type of training is there that's available that these judges go through that oversee the programs currently? And is there continual training and updated training for these judges that oversee these programs?
Yes, well, in all juvenile cases, judges, the administrative judge has to choose the person, magistrate or judge, who has the temperament, the qualifications to preside over juvenile period. And then all judges and magistrates throughout the state, they are required to attend 2 full days of training each year. For our juvenile judges and magistrates, we generally participate more because we have a separate conference as well. That's 2 days. We also have training through our problem-solving courts. So a lot of those trainings are trauma-informed training so that we know how to deal with those families and youth who have suffered some type of trauma, so that we know how to engage them and work with them. It's totally different. We have to be able to pick it up, identify their traumas, and be able to work with them. So we do it's a continuing education, 2 days, mandatory across the board, 2 days with our juvenile, and then problem solving court has a day as well.
You know, I sat on the Concurrent Commission for 4 years, and we talked about truancy, we talked about the school to prison pipeline, we talked about helping poor, underserved kids and developing more community schools. I led the effort in developing more community schools. And it seems like what the gentleman said was that mental health, housing, transportation was an issue. Under the Blueprint for Maryland's Future, that's what we focus on. Mental health, making sure that there's additional housing for family, or identifying it through community schools, making sure that the community schools coordinator can identify those resources for families. And I wonder why we are sending kids to court, truancy court, because it's not necessarily a court, instead of to the community schools coordinator. Why do you think that's the case?
I think it's not one or the other. It's some may be referred there, but the ones that come into court, they meet that definition of truancy. And so they can either send the parents to the state's attorney's office for a criminal prosecution, or in a lot of our cases, especially with the younger kids, they send them to our truancy reduction court program. We are more hands-on. I could say, because our staff, number one, they are trained in being trauma informed, and they work with all the providers within the county and the jurisdictions. When we talk about homelessness, a lot of the parents don't know that they can still get transportation from the school system, even though they may be displaced. But in addition to that, our case managers refer them to services. We had one of our families who lost everything in a fire Christmas Eve, but all during the holiday, our case managers were working with them, making sure they had a roof over their head, food to eat, clothes. And so I don't know when they're referred to the community. I know a lot of them do come into the home and they work with them. But again, when my work with even the child welfare cases can be fragmented.
Got it. You know, the last piece of data I would like to have is the number of participants or students that participated in the program that went into the juvenile justice system again afterwards, and ones that actually graduated, because I haven't heard that either. Ones that graduated from this program, but also graduated from high school, and then also ones that went into the criminal justice system. If that's possible, if someone is tracking that information, I think that would be helpful.
I can't.
Yeah,
they graduate.
I can chime in here. I think the data is easy to get with respect to kids in the program and who graduated, because that data is coming from the school. I think in order to get the information about juvenile delinquency, and I guess I would refer to Gray, whether the judicial information system that collects data is able to do a cross-check. I think you can, but it's not as readily accessible, at least by us program managers. Gray, is that right?
That's correct.
Thank you. Yeah, I think the Maryland Longitudinal Data System, which also looks at a lot of this data and information, recently is going to look at the school to prison pipeline data. And I think these programs should be in contact with not only in this, if we're developing or expanding this program, Mr. Chairman, I think we should look at adding community school coordinators to this conversation, ensuring that we're collecting the adequate data to make sure this program is actually working in a positive way for our students. And so that's the reason for my questions here. And I would like to see more data on how this is actually working and benefiting our students. Thank you, Mr. Chair.
Thank you.
My question is really, you'll figure this out, but it's not really a question. I just want to say this program should be commended. This is an excellent framework to help reduce this type of truancy and keep kids in school. Especially when I look at like the fiscal note, if we're talking about adding in the other 16 jurisdictions, that's such a nominal amount to invest in trying to keep these kids in school and give them that structure and discipline that they so desire. So I just wanted to say, I think this is great. I'm glad you guys set up the framework and are willing to expand this and the bill moving forward. So isn't that true? Thank you.
No, I appreciate it, both comments, and Senator Washington definitely. I mean, I'd be interested in seeing the same data. But I do, we've got opposition testimony coming up from the Office of Public Defender, and they're going to talk about that the school to prison pipeline. And so just want to give you an opportunity to, this is not a SINA or SINS process, is not a delinquency process. So, Judge, you touched on this. Can you just speak a little bit more, to the process, that this is not something that will lead you into the criminal justice system? Your interaction in this program, you don't have that jurisdiction to do that through this program. Is that correct? Can you just
right? That's right. If you look at the juvenile causes statute, the ability of a court to remove a child from their home, put them in detention, it's all within the juvenile delinquency framework, or in the case of a child in need of supervision within that framework. Truancy courts are not juvenile delinquency courts, and as such, we do not have the authority to exercise those extreme options, because it's a civil non-delinquency proceeding. I don't know how else to say it any stronger. We just don't have the statutory authority. It doesn't exist. People often say, well, why would anybody want to come into this program if you don't have any authority? And I've thought about that, and I really believe these programs succeed, hopefully because of the respect that the court brings into the process and the collaborative nature of the court, because we are partnering with the family and we are partnering with other agencies that intersect the family, governmental or not. And I think that is where the success comes. I've had also people say, well, what happens if a child doesn't complete the program? I like to say this: it's not a failure if you don't complete the program. Every case that I can think of where a child has not been able to graduate, we have had a positive impact on that child and on the family because we've engaged with them, and they do go back to school. So swinging back around to this concern that any impact, any intersection by a child with this justice system is a negative, all I can do is rebut that by the stories that I can tell and by what I have seen. And I am a juvenile court judge. I am a child dependency judge. I've been there, I've done that. And this program is not any of those things. And if you feel like you need to write it into the legislation, write it into the legislation that no judge shall remove a child, put him in community detention. I mean, and I think that would be fine because we can't now. But if there is a need of reinforcement for that, I would just spell it out in the statute.
Excellent. Well, thank you very much, Judge. Thank you for that. We have one more witness, Ms. Davis, who's testifying virtually. So we'll bring her in and then we'll move on to the opposition panel. Okay, Ms. Davis, we're ready for you. If you could just turn your camera on, we are ready for you. There you go.
All right. Thank you. I appreciate the opportunity. Frederick County's instituted an informal truancy reduction council, and we've had varying degrees of success with that in helping our students improve their attendance and their engagement in school. We strongly believe that the formal structure of a truancy court is going to help us more effectively connect with more of our students and get them more of the supports they need to keep them from falling further and further behind. From a school district perspective, what we've seen is that when our families do engage with the process and see our schools and communities working together, we have seen an uptick in attendance and an uptick in engagement, along with student pride and self-confidence. However, not enough of our families are willing to engage in the process. This pilot program would give us the infrastructure support we need to provide the outreach, case management, and incentives that we know are effective. Right now, we just don't have the funding and the staff power to accomplish what's needed. Also, a court process gives structure and legitimacy to what we're trying to offer as we're trying to connect children to the education and services that they need to have to be successful now and also as adults. This bill will create the formal structure that we seek. A court setting will convey the importance of school attendance, and fiscal support will offer the opportunity for a position dedicated to identifying and monitoring and supporting the growth of these students through case management. Our goal is for every child to succeed. Our superintendent often says, every child, every day. We've seen that when we're able to bring students and their caregivers to our informal counsel, those that engage often are reporting to us mental health concerns, and we're able to them in so we can serve more children. I'm a trauma therapist, and I spent my career devoted to the well-being of children, youth, and families. This bill doesn't put our children at risk of prison. It gives us an opportunity to get them the supports that will keep them out of it. Thank you.
Excellent. Thank you very much, Ms. Davis. All right. Questions from the committee for the panel? Seeing none, thank you all very much. Thank you. All right, so that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. We'll hear from Frank Penton. Frank, are you here? Here we go. Mr. Bradford, or even Bradford, and then we have two virtual witnesses. Go ahead. If you could come to the podium, that'd be great. Cool.
Can you hear me? Yes, thank you. Mr. Chairman, members of the committee, thank you for the opportunity to speak. My name is Frank Petnella. I'm a senior education advocate for the ACLU of Maryland. Please note that my written testimony states favorable, but I checked the unfavorable on the website. So to be clear, we're urging an unfavorable report. I want to thank the supporters of this bill because we agree on the intent to provide supports and services to families to maximize attendance at school. We're definitely aligned there. However, we strongly believe that expanding truancy courts now and the overall strategy to address truancy is premature. As OPD noted in its testimony last year, the 2011 report from the Maryland Judiciary recommended that the expansion of truancy courts should be predicated on more definitive evidence. I agree with the questions that Senator Washington posed in this hearing. There's just a lot that we don't know. That report was 10 years ago, and to our knowledge, there has not been a deep dive into the data and evaluation of these programs since then. And perhaps doing that work, we'll learn about programs that are more effective in dealing with truancy. Secondly, in a report cited in my testimony, Rhode Island's truancy courts became another disciplinary device that triggered more family involvement with the justice system, which in turn led to threats of fines and imprisonment for minor issues such as failure to complete homework and classroom disruption. There's no guarantee in Senate Bill 220 that truancy courts in Maryland will not become another failed punitive measure that will unfairly punish students of color and continue to feed into the school to prison pipeline. My last point is about the blueprint and how much time and funding is being invested in this $4 billion major education reform initiative. One of the big pillars of the blueprint is about providing a comprehensive, evidence-based, and culturally responsive approach to struggling learners and their families to address barriers to learning. Truancy falls into this category. The blueprint established a new consortium of community supports to help schools address the myriad of challenges that families face through community-based providers and wraparound services. So I end by saying the blueprint is just getting off the ground. This is a new structure, a new system of community supports. Let's give that a chance. So for those reasons, we ask for an unfavorable report. Thank you.
Good afternoon. If I can proceed. Chairman Smith and members of the committee. My name is Levi Bradford. I'm an attorney at the Public Justice Center. We represent students facing suspension, expulsion, and other forms of school pushout. The Public Justice Center is opposed to Senate Bill 220, which would significantly expand the truancy court program's jurisdiction and power statewide. Although we agree and we recognize the importance of supporting children's regular attendance in class, and that we would like to note the truancy court program is harmful to students and children because it uses courts and the threats of penal consequences rather than family and school-based supports to achieve its goal. The bill gives courts new authority that should remain with schools and parents. For example, it authorizes a court to remove a child in their program out of the normal school and place them in virtual school or a GED program. Additionally, judges will be able to refer the child to any agency, including potentially Child Protective Services, and issue any order they deem appropriate to achieve the purposes of the program. This is a blanket grant of discretionary power, which would seem to authorize courts to use schools to use court orders to transfer a student to another school or change their educational services. These are decisions that only families and educators, rather than courts, have the expertise and child-specific knowledge to make. I'm an education attorney, and I'm particularly concerned that this bill gives judges the power to change a child's educational placement. Senate Bill 220, with this new grant of power to the truancy court, would create a mechanism by which school administrators could circumvent due process protections for suspension or expulsions, which are included in forcible transfer of an educational placement. If schools were to use the program this way to get around those due process protections, their actions would raise serious constitutional concerns and risk potential challenge from the Federal Department of Education. If we as a state truly want to support school attendance in a non-punitive way, then we can do that. Leave the courtroom behind to connect children back to school through community-based solutions. A judge is not a social worker, and issuing a child a court order is an inappropriate avenue for connecting students and families to support services. For these reasons, the Public Justice Center strongly opposes Senate Bill 220. Thank you.
All right, Miss Fio, Alyssa, you're up, Miss Fio.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Alyssa Fio. I'm an education attorney with the Maryland Office of the Public Defender. I come with 25 years of experience representing students in school-related matters. Based on the experience representing youth around the state of Maryland, OPD opposes SB 220 and urges the committee to issue an unfavorable report. The committee has OPD's written testimony. I won't go through it at length here, but I do want to highlight just a few points. Truancy, as we know, is due to a complex array of factors. But some of the factors that have not been mentioned in the testimony so far today are the unmet and unidentified academic needs, student discipline, and lack of appropriate social and emotional behavior supports. OPD represents students with a wide range of academic and mental health needs. Many of our clients have experienced years of school failure and yet have never been referred for an evaluation to determine if they have a disability that's impacting their educational performance. The relationship between school attendance and school achievement, academic achievement, is well documented, and students with disabilities are at a greater risk for absenteeism. According to the Maryland report card on MSD's website, Black students with disabilities represented the highest chronic absenteeism rate at 48.4% in 2022. IEP teams and special education services are the appropriate forums to address these student needs, along with community supports. Rather than expanding court involvement, OPD urges the state and school systems to focus on evidence-based interventions that are non-punitive, that are based on prevention, that have school-wide strategies to improve school climate and school engagement, as well as the individually focused interventions like special education and student support services. Rather than pulling young people into court, we need to figure out how to bring the services to students. That's why the informal programs, the community school programs is what we support, and we appreciate your consideration of these comments. Thank you.
Excellent. Thank you very much. All right, that completes the testimony for the opposition. We'll turn to the committee for questions. Seeing none, thank you very much, Ms. Theo. Thank you very much.
Thank you.
All right, with that, that'll conclude the hearing for Senate Bill 220. We'll now switch to Senator Carter with Senate Bill 15, and then we'll get back on track with Senate Bill 115. So Senate Bill 15, Senator Carter, you're up.
Good afternoon, or is it afternoon? Yes. It's hard to tell with the hours that we keep, Mr. Chair. Good afternoon, members of the committee, gladiator members of the Judicial Proceedings Committee. I'd like to call up my panel, Mr. Renard Parks, Ms. Donyette McCray, Mr. Daniel Jarvis, and Nick Maroney from the Maryland Juvenile Justice Monitoring Unit. If there's any other family members that are here for this bill, you can stand and be acknowledged or come up to the front, even if you're not testifying, if you'd like to. Mr. Chairman and members of the committee, some of you that are newer to this committee may not be familiar with the work that was done for the Juvenile Justice Reform Council for 2 years. It resulted in recommendations for a Juvenile Reform Act that we passed last year. That act was really born out of the fact that Maryland had a pretty horrific history of overly incarcerating children and violating human rights of children. That council sat for 2 years and looked at best practices and consulted with some of the best minds across this country and what are the best practices for how to treat children in the juvenile and criminal justice systems. And we came up with some recommendations, and among those recommendations were to curtail the detention for children that commit petty offenses, to limit the periods of probation for children that commit petty offenses, to expand what's called informal adjustment, or some know that as diversion in the adult system, and also to create a floor for what age a child could be prosecuted in the juvenile justice system. At the time that we created that legislation, we made a decision as a policy, as a state, that a child under 10 years old could not be prosecuted for any reason, because often those children are not competent to stand trial, and that those children should be able to avail themselves of programs and services to meet their needs. Quite shockingly, right after we passed that law, right in Baltimore City, in my own district, a 15-year-old child, Michaela Struder, whose family joins me today, was horrifically shot and killed at the hands of a 9-year-old child. It was a tragic that really, really hit the core of our district and of our city. And there's no one that could know about this and feel anything other than complete pain and sorry for the family. So as a result of that, I had occasion to meet with the Struder family, and much to their credit, while they grieved the loss of Michaela, they didn't have hate in their hearts or, want to see injustice done to the child, but they did want to ensure that something was done. And so I have to say this part too. So these kinds of issues always kind of are breeding grounds that attract media and people that want to condemn the work that we do. And so much of the media has focused on this idea, this concept that law enforcement says, oh, well, because of the General Assembly law, they can't do anything with the child. Well, that's not the truth. Law enforcement absolutely has at its disposal something they've always had, which is the ability to file what's called a child in need of supervision petition, which will result in the Department of Juvenile Justice conducting an evaluation of this 9-year-old and even an assessment of the 9-year-old in the context of the 9-year-old's family and providing any programmatic needs, therapeutic needs, treatment needs that are required. But some law enforcement has chosen to take the approach that they can't do anything. And so in response to that, this piece of legislation that's called the Michaela Struder Memorial Act would require that law enforcement would take an action in a case such as this. And I'm not going to talk too long because I want you all to hear from the Struder family. I also really thank this committee for not turning this into an issue of where you fall on what should happen to children or a partisan issue, but just understanding the need to embrace this idea that when a tragedy such as this happens and it results in the death, then some action should be required to be taken, and it shouldn't be left up to the discretion of the authorities, but it should be mandated. And all this bill does is say, with this, something like this happens, we're not leaving it up to the discretion of law enforcement and juvenile justice. We're going to make sure that they take the right action to make sure that the needs of the family are met and the child are met. And that includes accountability. That includes any other things that are needed to ensure that this child's probably going to be living with the horror of his actions for the rest of his life and is going to need therapy regardless. And so the Department of Juvenile Services has all of the wraparound services that should be required to meet the needs. And all this bill does is make it not discretionary, but mandatory. I'm happy to take any questions, but I'd like for you to hear from the Struder family first. Thank you. So who would like to? Yeah, come on. You gotta come on.
Good afternoon. I'm the great aunt of Michaela Struder, who was her caregiver. Although I know that the law, they can't bring her back, but just surfacing the area and talking to a lot of kids, it could make a change and it can help somebody else's kids so they wouldn't have to go through what we went through. Kayla was just 15 and starting to embrace being a teenager and was so excited about getting her permit and learning how to drive. In May, she went to her first prom and was so happy and was talking about how she felt like the most beautiful girl in the world and was just excited about what 16 was going to be and getting her license and finishing school and becoming an artist. She would have been 16 next month, February the 15th. And although I can't have her back, I just want to make sure that I can help the next kid and family and get the services and stuff that they need, because the kids that were with her, her friends, the mental health, they really need the services. And that's all I have to say.
Thank you very much, and we're sorry for your loss.
Peace, everybody. My name is Renard Parks, and I am Michaela's big cousin. And I wanted to speak a little bit to the memory of her as well. Last time I was with her was May 30th. We were all at our family's estate in Virginia, where we do bury other family members. But it's a beautiful moment to get to see the young kids and the elders of our family learn about not just the past family members, but also younger people that have died. And the young people learn the reality of death at that moment. But it's also a beautiful thing to see them all take care of each other. So I'm here because she took care of me as well. And it's upsetting to see what the other little kids are going through of my family. And they're not getting any proper services, but this actual mandating will allow not only just the kid who went and committed this crime, but 45 days later, we should be able to get a plan, an active plan. And we're here to testify that that has not happened for our family. So granted, we've been able to do all the things civically as citizens that we need to do to go to the active places and to ask for the help. We've even started programming with kids at that age, right? But now we're here to ask you all to step across that line on the same team and vote for this bill and mandate it, because these kids really need these services. Since Michaela has passed, essentially 151 kids in the nation have passed, essentially what this article has alluded to today. And what we're asking is that we're here today in front of the issue, right? And we should be one team of humanity, that we could step forward and provide these kids a service that they really need. I want to end on, I serve as the Director of Food Insecurity and Justice in West Baltimore. And what I find is I have about kids from ranging from 9 to 15. These kids always speak about their hunger. They always speak about the mental issues, and they understand murder. They understand these crimes. And the biggest issue that I find is that they want the help early. And I see a major change in these kids when we integrate with them early, before they continue to do the issues and before they get out of school. And they light up when we're there early. So today, I just would like you all to, just see the family and see that we need some of these services ourselves. And this will mandate it and get that process started for us. And then we'll be able to start and move forward in peace. Thank you.
Good afternoon, panel. My name is Daniel Jarvis. I am, Michaela was my great niece, actually. And so, again, thank you for allowing us to be before you today. Just not to reiterate what my sister and my son has stated, but this bill is perhaps not great, but it's a great start, right? It's a great start because what we know and what research has showed us is that adverse childhood experiences in which this youngster in this situation have now experienced, right? The trajectory that it puts them on as an adult. And it's important that youngsters get the services that they need and not be at the discretion of an intake officer or police officer or the state's attorney's office. I tell you that we have gone through quite a bit with being told that they're not obligated to do it. There's nothing they can do and it's not about penalizing young children, but more so really addressing the needs of the youngsters. And what we need to really be focusing on is holding adults accountable, right? Holding adults accountable that allow a youngster to actually obtain a firearm. When you look at the 6-year-old child in Newport News, Virginia, the 9-year-old child in this case, and the 12-year-old child in Arundel County recently, one thing that all three have in common is a fascination with firearms. So hence that tells us that we have a larger issue as a society. And it's not so much the young child, but more so society and the adults that they're assimilating the behavior and what they've seen as acceptable. And so I think that it's important for you all to act, right? To act on this bill, for us to get some movement. And again, it's just a start. But we certainly appreciate the collaboration that Senator Carter has shown the family as well. Thank you.
Good afternoon, Chair, members of the committee. My name is Nick Maroney. I'm here as the Director of the Juvenile Justice Monitoring Unit, independent monitor working out of the Attorney General's office to oversee or provide oversight to the Department of Juvenile Services, detention facilities for kids and placement facilities, the equivalent of prison for kids. The first thing I'd like to say is I'm ever so incredibly sorry for your incalculable loss. So I think the best that I can do is to draw your attention to the very short change that this bill involves. The few words it says, if a complaint is filed that alleges the commission of an act by a child under the age of 10 years that results in the death of a victim, the intake officer shall file a petition alleging that the child is in need of supervision. This then would be the trigger for the possibility of services. So I'm sorry, but for a police officer on the scene to say there's nothing I can do is, as the senator said, strictly just not true. And this would mandate that you don't just have two options. I can arrest the 9-year-old child and potentially put that child behind bars without services, or certainly in the case of the Department of Juvenile Services, which is a pretty targeted agency, not the services that are going to be required or appropriate for a 9-year-old child. The officers don't have to arrest or just ignore the situation. The officers involved can petition for sins. And in this particular situation, if this bill passes, the officers will be mandated to do that. And so then, therefore, we have services, which anybody looking at the age of these children should, by virtue of just basic common sense, know that the situation has to be very individually assessed and that the emphasis should be on services, not incarceration or punishment, because it's just not going to solve the problem. And we're in there every day. We don't need 9-year-olds. We don't need 10-year-olds. We don't need 8-year-olds in these facilities. So let's offer services. And I think this bill is a good step. Excellent. Thank you so much.
Thank you very much. Thanks for your testimony. We have one question from Senator Sidnor. So.
Thank you very much. And again, I appreciate your family's testimony. I do recall when the incident transpired, you all being on the news and sharing your story. But what I'm curious, Miss Struder's uncle,
yes.
You said this is a good first step. I mean, is there something else that you would be looking for? Because if I remember correctly, the young boy's relative was, I believe, arrested and is going to be prosecuted, correct?
Yes.
Sir, if you could come to the podium, please. Thank you very much. Thanks.
Sorry.
No.
Yes, you are correct. She was actually indicted in November. And again, with advocacy from the family and being in partnership with the Baltimore City Police Department, Mayor's Office, Sheriff's Office, it took the family advocating to expedite that process. Again, she was indicted in November, and just last week they served her, which meant that they held on to it for 2 months. And so when I state that it's a start, what we want to see in addition is some legislation that will increase the penalty for adults who allow children to access a firearm that lead into death. It's totally negligent, and we need to do more.
And I certainly hear the grace that your family is giving to the young boy who did this. And again, I appreciate your advocacy and look forward to supporting this legislation. Thank you.
Thanks.
All right, further questions from the committee? Seeing none, I'll just say thank you so much for taking the time to come down here and to share your story and your perspective. And obviously, we're all tremendously sorry for your loss and supportive of your efforts. So thank you. All right, Senator Carter, thank you. I think with that, that'll conclude the testimony and the hearing for Senate Bill 15. We'll now move on to Senator Jackson, who's here with Senate Bill 115. Senator Jackson, You're up.
Afternoon, Mr. Chairman, members of the Judicial Proceeding Committee. Mr. Chairman, may I bring up my panel? I think it's going to be virtual, I believe. I hope they're virtual. Now we'll handle it. Yes. All right, I'll get started.
Yeah,
Yes.
we've got Christopher Arnold.
Okay.
So we'll bring him in, but go ahead and
Ms. Cash. All right, thank you. Thank you, Mr. Chairman, Vice Chairman, members of the Judicial Proceedings Committee, Senator Michael Jackson representing District 27, and also in my capacity as the Chair of the Senate Veterans Caucus on behalf of Senate Bill 115. Senate Bill 115 is a very direct bill designed to better serve our juveniles in our court system by establishing a mechanism for concurrent jurisdiction with our federal courts. The bill would establish concurrent jurisdiction for the federal courts sitting here in Maryland over proceedings related to the violation of federal law committed by children who are at least 13 years of age on Maryland military installations if the federal court waives exclusive jurisdiction and the violation is also a crime under Maryland state law. This legislation is pretty straightforward. Without concurrent jurisdiction, juvenile misconduct in children and youth is adjudicated in the federal court system, which lacks the appropriate juvenile-focused resources and wraparound services that, as you know, Mr. Chair and two other members on this committee, when I was in the House, there was an establishment of the Juvenile Justice Reform Council, which addressed the needed wraparound services. If concurrent jurisdiction is established, offenses could be adjudicated through the state juvenile court system, allowing for a more appropriate sentencing and case management outcomes. Historically, the federal government has either obtained exclusive federal legislative jurisdiction over land by agreement with the states or maintain exclusive federal legislative jurisdiction. But this legislation is not a new concept, as 46 installations across the country and 17 of our states have concurrent jurisdiction. As many installations have begun to house more civilians, the federal government have sought to retrocede jurisdiction to the states, thus altering the jurisdiction from exclusivity to concurrent to enable state law enforcement authorities to enforce state laws on the base with respect to civilian families. As someone who spent the majority of my professional career in public safety, as well as a short period of my life with the military, issues relating to juvenile justice are of particular interest to me. When offenses are committed by young people, it is a clearly different circumstance than it is with adults, and we need to keep it as such. Our state courts in Maryland are simply better equipped to handle these incidences that the federal court system than the federal court system, and they're better equipped to adjudicate and often rehabilitate the young people involved with those wraparound services. So with that, Mr. Chair, members of the committee, I would ask you and the committee for a favorable report. I'd be happy to stand by for questions. And I believe Christopher Arnold is on the screen here. We may have one more as well, but with that, we'll turn it over and I'll stand for questions.
Excellent. Thank you, Senator. We'll now go to Mr. Arnold and then got a couple questions from the committee, but Mr. Arnold, you're up. Welcome.
Good afternoon, Chairman. Great to be back at Judicial Proceedings. I'm Christopher Arnold, the Mid-Atlantic Region Liaison at the United States Department of Defense State Liaison Office. Our shared mission is to ensure military youth on military installations receive the same protections under the law that they would living in civilian communities by working to remove the barriers to concurrent juvenile jurisdiction. The policy proposed in Senate Bill 115 adds clarity to the state's authority to adjudicate juvenile misconduct arising on military installations. It provides a retrocession option for areas acquired by the federal government prior to 1941, where there currently is none, and provides for an alternative means of relinquishment when a retrocession has not yet occurred or is infeasible. Research provides evidence of a critical period of neuroplasticity in the frontal cortex during the teenage years, a time at which risk-taking behaviors and mental illness risk peak. Risky behavior presents more frequently during adolescence, and only a small percentage of young offenders escalate their behavior, committing crimes during adulthood. Increased awareness of the teenage brain, supported by neuroscience, has demonstrated a capacity for change and rehabilitation thus impacting and influencing juvenile justice policy. At the moment, there are a large number of civilians, both adults and juveniles, with a tenuous military nexus, traversing areas of federal exclusive legislative jurisdiction on our installations, where delinquency offenses are referred on a case-by-case basis to the county. There were 59 more serious cases in the federal exclusive areas from 2017 to 2021, and the federal government does not have the personnel, programs, or established procedures to address these offenses, which is why we generally defer to the state. Senate Bill 115 creates a vehicle to get us past these barriers, providing statutory authority for the federal government to relinquish jurisdiction and the state to accept it back. I am happy to answer any questions you may have.
Excellent. Thank you, Mr. Arnold. Good to see you again. We have a question from Senator Sidnor.
Thank you very much. And Senator Jackson, you can answer this, or your witness can. I'm assuming the bill is drafted in this manner because of the supremacy clause and us not being able to tell the federal court that they have to waive jurisdiction. So it's you can if you want to.
Yes, sir.
Got you. Will there be any how would we get them to want to do something? Is there a desire in these federal courts to kind of send the children to the state courts?
I will actually, I'll say something and then I'll defer to Mr. Arnold. Look, not all jurisdictions and law enforcement have a relationship, or the judicial system have a relationship with the military installation. In Prince George's County, we did, because we had Andrews Air Force Base sitting right in the heart of our county. And so, as well as some of the military installations in the District of Washington. And with more schools being built on the fringes of the military institution, and those young folks are working there, so that interaction has grown. I believe that if you don't have that relationship, there's no other way of achieving this. So I'll let Mr. Arnold elaborate a little further with that, but that was part of our experience.
Well, I like the idea, and I'm wondering, do we have some sort of attorney some sort of a conversation with the U.S. attorney? And I mean, I'm just curious the mechanics behind this.
Yes,
you're right. It's a number of military installations, and I hadn't thought about this. I think it's a great idea.
Yes, sir. Thank you.
Roger that, Senator. And Congress has recognized these jurisdictional underlaps and directed the department to relinquish its jurisdiction. The Deputy Secretary of Defense has directed the military departments to remove barriers to the appropriate investigation and adjudication of these matters, and to address juvenile misconduct in these areas of federal exclusive legislative jurisdiction with the probability of youth presence. The cleanest, easiest way to do that is to clearly authorize that to happen. Although the federal government has the authority in limited cases to handle juvenile offenses, it has not exercised jurisdiction over juveniles for crimes occurring on military installations anywhere in the United States in recent memory. And the threshold for the Department of Justice to exercise jurisdiction is extremely high, requiring Attorney General certification that the state does not have adequate services for the juvenile, or that a felony offense is of substantial federal interest to warrant federal jurisdiction. And as the Department of Defense is constitutionally prohibited from prosecuting individuals not subject to the Uniform Code of Military Justice, the appropriate adjudication of behavioral problems in juveniles on military installations is severely disadvantaged by our inability to lawfully leverage state and local resources.
So again, do we go? I mean, do you all have? Let's say the legislation passes. Do y'all start having conversations with the U.S. attorney?
Roger, and they are already involved in those conversations. So, and I can give it to you on an installation by installation breakdown, if you will, the process of formally retroceding our jurisdiction, but we're not even allowed to do that everywhere within the state due to, for example, the second section of this bill, where lands acquired prior to 1941 don't have a retrocession vehicle in place. But that's not always going to be the answer, sometimes due to military admission requirements. So we'll still have these referral agreements. But under that authority paragraph, there's no clear statutory vehicle for the state to accept back jurisdiction from the federal government. Right now, it's just an informal attorney general's opinion saying, yeah, we think we can do this. It doesn't conflict with any other law. So the Deputy Secretary of Defense has essentially directed us to codify that opinion.
Thank you very much. I appreciate it.
All right, thank you very much, Senator. Seeing no further questions, that'll conclude the testimony and the hearing for Senate Bill 115.
Thank you.
All right, you're up next again, Senate Bill 203. Senator Jackson.
Thank you, Mr. Chair. Members of the panel, Mr. Vice Chair, and members of the Judicial Proceedings Committee. If I might bring up my panel. For the record, Senator Michael Jackson, representing District 27 on behalf of Senate Bill 203. Senate Bill 203 is a piece of legislation that is drafted to help stop the spread of the crime of human trafficking in our communities and to bring about an end to the suffering endured by its victims. This bill would do a few straightforward and simple things. It will require the Maryland Department of Transportation to put into place both a human trafficking recognition education program, training program curriculum, offering guidance to employees and contractors of Maryland transit agencies on ways to recognize and respond to signs associated with human trafficking, and a reporting procedure to when such crimes are recognized. The training program would be required for state employees working at transit stations, airports, port facilities, and highway rest stops, as well as state employees providing transit service or employees employed under contract to provide transit service. Elements required in this training program would include video presentations defining child exploitation and human trafficking and offering guidance as to the recognition of potential victims of such crimes. Additionally, it will require the development and implementation of human trafficking related signage and audible public service announcements throughout Maryland transit stations, airports, port facilities, and highway rest stops. Incidentally, such programs and announcements are readily available through the United States Department of Homeland Security. And for that matter, also, Mr. Chairman, and members of the committee, some of the local Homeland Security officers also have that information available. This legislation piggybacks on some legislation that Delegate Ebersol and myself put into place last year, which created similar benchmarks for the hotels and establishments here in the state of Maryland. As you all may be aware, again, my professional background lends to me to have a keen interest in this challenge that we continue to have. And the more folks that recognize the signs of this deplorable activity, the better off we will be in our society. Ensuring that law enforcement officers have the most useful tools at their disposal to stop the suffering endured by those victimized by human trafficking is a priority. I believe we can all get behind this. I'm confident that this legislation will achieve that and aim for that reason, achieve that aim. And for that reason, I brought forward this legislation with the panel that you see before you. With that, Mr. Chair, members of the committee, I would ask you and the committee for a favorable report, and I'd be happy to try to answer any questions as well as the panel after they testify. And I'd like to note as well, Mr. Chairman, we have a few clarifying amendments that if you don't have it in your packet yet, what those amendments do is one is changing the name of the bill, and the other is and the others are designed to help make the requirements placed on the corresponding agencies less stringent. So with that, I'll stand for questions or for our panel to proceed as you wish. Thank you.
Thank you, Chairman. Yes, sure.
Come on. Sorry about that.
Okay. Chairman, members of the committee, I'm Amy Blank and I'm the chair of the Baltimore County Commission for Women. Many of you may know that human trafficking is seriously on the rise. It is the largest illegal enterprise in the world. It is 27 million victims at $150 billion in profits. Sadly, many of the people that come to our shores, 14,000 to 17,000 people, are from other countries, but the majority of them, 200,000, are citizens of the United States. Those that are trafficked for sexual exploitation, on average, are now girls ages 12 to 14 years of age. Many of these victims are caught in the intersectionality of poverty and trauma, racism and sexism. And so that allows human traffickers to easily identify them, entrap them, transport them, and exploit them. So Maryland is in the intersection of human trafficking in the United States. All of the major thoroughfares, I-70, I-95, the Port of Baltimore, Amtrak, BWI Airport, all of the bus stations and truck stops, as well as the ride shares, conveniently merge into our hospitality district, which is the block, the ballparks, the casinos, the conference centers, and the hotels, which make it very easy for perpetrators to easily access services. The majority of individuals that are reported for human trafficking are along the thoroughfares of those different transportation routes. So again, I worked on the bill last year with Senator Jackson on the innkeepers bill, which was successfully passed. And we're just asking to do the same type of training for our transportation employees. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Rosalind Berkowitz. I'm a retired forensic nurse examiner. I am Vice Chair of the Baltimore County Commission for Women. I serve on state and county domestic violence advocacy groups, and I also serve on the Baltimore County Human Trafficking Work Group. I want to tell you about a patient that I saw before I retired. For the sake of this, I'm going to use the name of Mary. Mary was 17 and lived on the West Coast with her family. She didn't get along with her family, not uncommon for teenagers. Mary met a boy online who we will call Mark, who she thought was 19, but he was in his mid-20s. Mary drove an hour from her home to meet him, and after 3 or 4 meetings, Mary agreed to go on a trip with Mark and his friend. The farther east they drove, the more coercive Mark became. Mark eventually forced Mary to have sex with his friend. And by the time they arrived in Baltimore, Mark was forcing Mary to have sex with strangers for money. He took her phone, he took her car keys, and her money, so she couldn't call home. Eventually, thankfully, a human trafficking task force officer picked the two of them up in downtown Baltimore and brought Mary in for a safe exam. Mary was a typical victim. Human trafficking can have long-term effects on those targeted. Women, girls, and boys forced into sex trafficking experience higher levels of depression, anxiety, isolation, and trauma. They sustain physical assaults, resulting in serious injuries. Birth control and gynecological care are often withheld from victims, making them susceptible to lifelong and life-threatening infections, such as sexually transmitted infections, HIV and AIDS, unwanted pregnancies, and so on. On behalf of human trafficking victims, I ask for a favorable report on Senate Bill 203. Thank you.
Good afternoon. I am Sarah Curry, a senior in the Law and Public Policy program at Eastern Technical High School and the intern for the Baltimore County Commission for Women. As a young woman entering college, I have a firsthand perspective into just how vulnerable women can be within this world. That is, a world that views us simply as easy targets. Seeing as I will be on my own within the next few months, I recently began looking into issues that could impact me. Now, it was of no surprise to me that human trafficking has been proven to disproportionately affect young women. However, what did surprise me was finding that Maryland lies precisely at the center of this organized criminal activity. It is this discovery that led the Commission and I to take action. Alongside Commissioner Amy Blank, I assisted in drafting this legislative initiative in order to combat human trafficking at its root, transportation. We wanted the bill to include all communication strategies necessary to make it as effective as possible. So we contacted the National Conference of State Legislatures and thoroughly analyzed every bill in all 50 states pertaining to this issue. Then we created an all-encompassing bill requiring transportation employees to be trained on identifying and reporting human trafficking, visible signage, and frequent announcements instructing victims of human trafficking on how to seek on-site and online assistance within transportation facilities. This effort is reminiscent of the See Something, Say Something public awareness campaign, which has been in effect for 21 years. This movement has taught all of us how to identify and report suspicious activity. So if we can do this to fight terrorism, it should not be difficult to do the same for human trafficking. And although there is some national human trafficking training, which is administered to flight attendants and others, in the end, the Maryland Department of Transportation is responsible for educating its own state employees who may otherwise be untrained. So it is essential that the concepts within this bill be put into place, as its simple, successful, and cost-effective strategies will train us all to see someone and ultimately save someone. Thank you.
All right, thank you all very much. Seeing questions from the committee? Seeing none, thank you all very much. Thank you for coming down to testify today. Yes. Thank you, Senator. Don't you miss us, Senator Jackson? Come on. I know you missed us last night.
You see me back here often. I thought about you last night.
Yeah. We thought about you too, enjoying life. Yeah. All right.
Take care. Thank you.
Have a good one. Thank you. All right. So that'll conclude the hearing and testimony for Senate Bill 203. We'll now move on to Senate Bill 227. Is that Senator Bidle? You have the next two for the Arundel County Senators and your own bill. So Senator Bidle with Senate Bill 227. Welcome.
Thank you, Mr. Chairman and members of the committee. I just miss you all so much. I have to come back every day. Thank you for hearing Senate Bill 227 for the record, Senator Pam Bidle, District 32. And I bring this bill to you for the Arundel County Senators. So thank you for the opportunity to bring the bill. Last year, members of the County Council began looking at options to deal with vehicles that are being operated illegally within the county. Currently, if an individual is found operating a vehicle illegally, the vehicle is generally towed, but it is immediately released to the individual. So after looking into options and looking what other counties are doing, Anne Arundel County Office of Law advised the county does not have the authority to adopt stronger impoundment laws because the state does not provide Anne Arundel County the same authority as they're providing on other counties. So Senate Bill 227 is enabling legislation so that the Senate law will authorize Anne Arundel to do what Baltimore City, Montgomery County, and Prince George's County are already doing, and to recover the cost of impoundment and storage of a vehicle and sell the vehicle if it goes unclaimed. Senate Bill 227 is an attempt to provide Anne Arundel County with the same authority for stronger impoundment, and the Anne Arundel County Council and the County Executive very much appreciate your support for Senate Bill 227. Thank you.
Good afternoon, Mr. Chairman and members of the committee. I'm Major Ross Passman on behalf of the Anne Arundel County Police Department. We'd like to thank the senator for her sponsorship. We'd like to thank our council members for helping to push this expanded authority. Our county gets a lot of complaints about vehicles, and this bill would be another tool for us to address the issue. We look forward to working with the sponsor and the Office of Law and the council members and others to help make changes to the bill needed to ensure that we're accomplishing the sponsor's intent. Thank you.
Good afternoon, Mr. Chairman, members of JPR, Matthew Bennett, Legislative Council of the Anne Arundel County Council. The council hasn't taken an official position on the bill, so I'm just here for information. The Office of Law did a deeper dive into the authority that's needed on Monday afternoon. So there's some other amendments that are currently being worked on by the Office of Law. This is one component of what the county needs as far as the authority goes. There's some additional authority that the county will need with regard to the bill. The amendments will be we'll provide Senator Bidle with the amendments as soon as they're done. They're being worked on as we talk. Thank you.
That was my next question, whether is that a different bill or is this the Is this the vehicle for that vehicle? This is the legislature. All right, terrible joke. All right. All right. All right. All right. Thank you very much. All right. With that, that'll end the testimony in the hearing for Senate Bill 227. We'll now hear from Senator Bidle for Senate Bill 229.
Thank you again, Mr. Chairman, members of the committee. This Senate Bill 229, Vehicle Laws Noise Abatement Monitoring System. I was shocked when I was asked to cross-file this bill because I didn't know that we could have noise cameras. And Mr. Chairman, I know that you have issues in your district with the noise from illegal mufflers, loud noises on vehicles. And so some states have already tried this. There's been pilots in California and New York launching pilot programs. And it would be a civil ticket, just like when you have a speed camera or a red light. It would be a civil ticket on the vehicle, but it would this legislation would enable local governments to use noise cameras to detect and ticket vehicles that exceed Maryland's noise threshold. The legislation is based on our speed camera program, and a local government would need to authorize the use of the sound cameras, provide public notice, and hold at least one public hearing. So that would be up to each jurisdiction to do that. And then they would have a first offense, would probably be a warning, and the second offense would be a civil penalty. But anyone receiving the citation can either pay it or contest it in court. It's very, very similar to our speed cameras and our red light cameras. So Senate Bill 229 prohibits the camera's vendor's fee being contingent on a per ticket basis. And I think this could be a lot of help to our communities that are tolerating noise pollution. And I respectfully request a favorable report on Bill 229.
So thank you very much, Senator. Appreciate this. We've been looking for an artful solution to this problem, and I like it because it doesn't involve an officer. It's not a criminal, so it's great. All right. No questions for the sponsor, but you have a panel you'd like to bring up. So, sir, come on up.
Thank you. Excuse me, I'm sorry. Thank you. My name is John Becker. I am a member of the Maryland Coalition for Roadway Safety, a board member, and also a homeowner and resident in downtown Rockville, Maryland. I live along Route 355, Rockville Pike, across the street from the metro station in Rockville. Our organization and myself personally urge a favorable report for Senate Bill 229. In an outline form here, walking across from the parking garage on Clay Street, I'm going to say today, I witnessed a vehicle doing its thing with its modified loud exhaust at every stoplight, every stop sign between here and there. And it's a pandemic that's happening even here outside this august body. The Specialty Equipment Marketing Association, SEMA, has already sent a note to Delegate Layman's office for her bill HB 304 in support of that bill. So there is movement on that end. One thing you need to know is that people cannot enjoy, whoever modifies their vehicles with an exhaust system that's louder than manufactured, you can't enjoy it unless you're speeding. If you're at a stop sign or a traffic light, it's pedal to the metal. And then you're driving faster and faster above the speed limits that are posted in a lot of our cities and even rural areas. You have to have a high rate of speed to enjoy this thing. And that's one of the problems we have in Rockville. As alluded to by the sponsor here, the sponsor senator, New York City is already assessing penalties. Washington, D.C. on the local TV station is already implementing a test program. And with that, I would like again to urge a favorable report on this bill. And thank you, Chair, Vice Chair, members of the committee, and especially the sponsor. Thank you.
So thank you. We'll take questions from the committee. I think Senator Washington's got a question, and then we'll go to the rest of the panel.
Yeah, just a quick question, Senator Bidle, or maybe the gentleman can explain too. What is this technology that allows for it? And also, is it recorded? Is it a picture?
It is recorded.
Okay.
And there has to be a picture of the tag. I mean, you have to identify the car that was making the noise.
Right.
But I don't know, have you ever been driving on like 97 or one of your major beltways and you hear this thing come up behind you? It really is scary to a driver to hear that. And so I think we're hearing that on our private streets. As the gentleman said today, he heard in Annapolis. Officers don't have the tool to check the decibels. So this is only one way that we could at least try to limit the amount of the noise.
Yeah, I just never heard of this technology, so it sounds great. So
I had not
I wish you
either.
would have brought a video like the first that can show us.
Thank you, Senator.
Yeah, right. Yeah, I just want to be able to see it. So if the gentleman or someone can just provide us with like what the technology looks
Okay,
like, would be
I
great.
think I can get that over for you.
Thank you.
Thank you.
We'll look into it too. I'm sure someone's gonna make some money off of this, so. Anyway, Senator McKay and then Senator Muse, sorry.
Thank you, Mr. Chairman. So more about how this works. So it's a sound. How does it differ from other sounds that are at the decibel high? A good example is we have a dirt track racetrack that in the manner in which it is in the mountains, the sound carries. So you could put this on 220 and I can guarantee you that every car that's going to go through 220, which is the most heavily trafficked area in Allegheny County, because of the mountainous terrains and in the valley where it's at, that's going to pick up, I would think, because I get many calls from all the residents that live there within a mile and a half of it, of they can't go outside. It's so loud they can't enjoy their pool. So I don't know how it works. So you may not know the answer right off the bat, but if maybe whoever has this technology would be willing to reach out to me, it'd be great.
Yeah, and I don't know the technology, but there's a recorded image as well as a recorded sound. So, if it's not coming near the sound camera, it's not going to pick up a tag number, an image in order to issue
But in my
the-
hypothetical, it is the most traveled road in Allegheny County.
Okay.
There will be vehicles going back and forth. How does it know that it's not the sound that is bouncing back and forth between the hills and the mountains and in the valley and coming from that particular car?
I think we're going to try to get you a video explaining the sound. So
thank you.
I don't know the technology side.
Let me ask a question, just because I'm trying to just understand the technology. Does it mean that almost like speed cameras, something is in a neighborhood somewhere that picks it up, or it's at various lights throughout, like a speed camera, it picks up the sound, it takes the picture of the license plate, and there is no interaction with police, that is to say, police aren't pulling people over trying to, that's not another another reason for police to pull someone over for a situation like that. It's purely, you mail it, you get it, you send it back, or you go to court. Is that how the process works?
Exactly, Senator. It is a civil fine. So it's basically on the vehicle, not on the driver. The driver doesn't get the fine. The driver doesn't get the points. The owner of the vehicle that's captured would either pay the fine or contest it.
And there are points involved or not?
No, no
Okay.
points, because it's not on a person.
Okay, great.
It's on a vehicle.
Okay, great. Thank you. Thank you, Mr. Chair.
Thank you.
Thank you.
All right. 16-year-old me hates this bill. 40-year-old me loves this bill. All right. All right, we have one more, is Sarah Sample. Yes, I think Sarah was here. Yes. Come on up, and then we'll switch to our virtual witnesses.
All right, thank you so much for having me. Thank you to the chair and members of the committee. My name is Sarah Sample, and I'm here from the Maryland Association of Counties, and we are here in support of Senate Bill 229. And so this bill, as you've heard, would allow counties to install noise monitoring systems on our county roadways. And so this, enables us with another tool to make sure that we can secure our communities and make sure that they're safe and make sure that individuals are following all the motor vehicle laws that we have in place. The other thing that I would add to this is, the automation does add, a supplement to public safety budgets, but at the same time, it diverts cost away from having law enforcement officers making these stops actively and any of the other complications that come up with those kinds of stops. So again, counties welcome the ability to have these systems in place. And so we would urge a favorable support on Senate Bill 229. Thank you.
All right, thank you very much. And we'll now switch to our virtual witness, Councilmember Kabir. Welcome, you're up.
Hello, can you hear me?
We can, yes.
Okay, thank you. Thanks for having me. It's members of the committee, and my name is Fazil Kabir. I'm a city council member of the city of College Park, and I have the pleasure to represent District 1, which is in North College Park. So I'm here to speak in favor of Senate Bill SB 229. And our residents in College Park, they have been complaining for many years now about extremely loud noise caused by modified exhaust systems and mufflers on our roadways. And for many of our residents, this has become a quality of life issue and honestly speaking, it's a health issue as well. And we have heard from residents who have been waking up in the middle of the night from their sleep because of this loud noise on the roadways. Our city of College Park has paid our police overtime to address this problem. And despite numerous citations, the problem still continues. The city has posted several signs on our roadways reminding the motorists against such practices. It has become apparent that the current enforcement is not sufficient, and we need new tools to address it. Many of us like to see noise cameras installed in College Park and the neighboring towns, and unfortunately, we don't have the enabling legislation that will allow a town like College Park to install these cameras. So this bill, SB 229, will help a city like College Park to install these noise cameras. Thank you for giving me the opportunity to speak, and thank you for listening.
So thank you, Council Member. All right. Seeing no questions from the committee, that'll conclude the testimony and the hearing for Senate Bill 229. Thank you, Senator Vital. All right, we'll now switch over to Senator Hedelman. I thought I saw her here. Senator Hedelman can come in for Senate Bill 87.
Good afternoon, Mr. Chairman. Which bill did you call? Sorry. 87. Okay,
Yep.
Great. So that is the Correctional Ombudsman bill. Great. And if I could have my panel come up. All right. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the Judicial Proceedings Committee. Thank you for the opportunity to be here today on Senate Bill 87, which would create within the Office of the Attorney General, the Correctional Ombudsman position. This is a bill that we had an excellent hearing last year before this committee, and we come back to you with slightly, substantially the same bill, but I think a slightly different environment in which we're working. I would argue that the need for this bill has only increased, and I'll tell you a couple of reasons why. I am just going to raise, these are 3 articles that have from just in the last couple of months about people who have died in our prison system. And this is, some of it is in the city and elsewhere, but is within institutions that are managed and run by the Department of Corrections. We really need some independent oversight of our correctional facilities, which is, in my opinion, long overdue. We need, this is nothing to be afraid of for the department. It is, and you'll hear from a similar sort of system we have within the Department of Juvenile Services that works really well. What we will do through this bill is investigate complaints concerning incarcerated persons' health and safety, welfare, and rights. We will provide important, pertinent information to the prisoners and their families. We will identify and make public systemic issues that do exist, and we'll monitor the department's compliance with relevant statutes and policies. would be a position within the Office of the Attorney General. The Attorney General did provide supportive testimony that you have, I believe, in your written packet. Right now, there is an insufficient mechanism for families and people who are incarcerated to express their complaints. We know, and this committee knows all too well, and now I'm on the Budget and Tax Committee, and I just had the opportunity literally this morning to look at the DLS budget analysis of the department, which we all know this, highlighted the need for more correctional officers. I will say the department has been doing an excellent job of hiring. However, the net is still, DLS says they'll need in the near future 3,000 more correctional officers. So that is concerning. While offender on staff assault rates have declined, offender on offender rates have increased. We just know that there have been an insufficient bounce back from COVID to providing learning opportunities and other kinds of supportive services that are so desperately needed for the men and women behind bars. So I am going to turn the microphone now over to my panel. You will hear from some folks who have also had personal experiences behind bars, who can share with the committee what their experiences have been, what they have seen, and why this independent, transparent, accountable position is really necessary within the Department of, within the Office of the Attorney General. Thank you very much.
Good afternoon. My name is Olinda Moyd, and I am a clinic professor at the American University Washington College of Law. For the last 4 decades, I've been a prisoners' rights attorney in Maryland and DC. I stand before you today as co-chair of the Behind the Walls work group for the Maryland Alliance for Justice Reform. It is an all-volunteer, nonpartisan collection of residents from throughout the state of Maryland, and we all support a favorable report on this bill. Today, you will hear from other advocates, you will hear from family members, you will hear from formerly incarcerated individuals, some very recently released, and you will hear from some former Department of Public Safety employees who will all talk about the need for independent oversight. This office, the Correctional Ombudsman Office, would have the authority to inspect facilities, help resolve prisoner, staff, family member concerns before they become systemic issues. Many other states have created such an office. Virginia recently in their state legislature passed a similar bill. Now is the time for Maryland to follow suit, so that people like Ms. Deborah Shipman, who is with us today, can have an avenue for redress. So that people like the gentleman who I wrote about in my written testimony, who needed to have medical follow-up after surgery and didn't have it until 8 months later. So that people who are behind bars can have a voice. The Correctional Ombudsman Office will be the office that will hear them and resolve issues. The department will probably come before you today and talk about the fact that they have a grievance process. You will hear about how lengthy that process is. Transparency and accountability are essential to institutions where daily operations are kept from the public eye, and we urge a favorable report. Thank you.
Chairman Smith, Senators, I'm Phil Karoum, speaking today for Maryland Alliance for Justice Reform, not for the Maryland court system, although I am in my day job a senior judge. The elephant in the room as to this bill is that our state prisons are too big, too crowded, and do not work very well. As a trial judge and formerly being a prosecutor, whenever we would send someone to state prison, the great concern always has been that they will not get the assistance they need. There are many reasons for this. Again, one is the immense understaffing of the prisons. Another is that although the average person, Marylander entering prison has a 5th grade education, only about 300 GEDs per year are earned even before the pandemic. Although 85% of our prisoners have substance abuse problems, there are between 3 and 6 substance abuse counselors for 15,000 residents in our state prisons. We also have a huge problem with employability, but less than 10% of our prisoners are able to participate in the Correctional Enterprises program. And again, despite the prevalence of substance abuse, drugs are smuggled in commonly, even during the pandemic, by correctional officers. There are overdoses. There are huge numbers. Well, there are many deaths which are not publicly disclosed or investigated. As in the joke of the elephant and the blind man, for us to truly understand all the problems, we need to have a clear vision of what's going on in the state prisons, and the Correctional Ombudsman bill would help us to get that. Please give a favorable report to SB 87.
Good afternoon again. Chair Smith, Vice Chair Will Stryker, members of the committee, Nick Maroney with the Juvenile Justice Monitoring Unit, independent monitor umbrellaed into the Attorney General's office. And we are set up somewhat similarly to what's prescribed to happen with the ombudsperson in this bill. So we were formed on the back about 20 years ago on the back of widespread systemic abuse, physical abuse that was happening to kids in Maryland in and around the late 1990s, early 2000s, when the state decided to buy into a quote unquote boot camp military style model for kids to quote unquote shock them out of their bad behaviors. What happened subsequently was in closed facilities, you had situations where staff were beating up kids and without any kind of comeback or any kind of external investigation, even though the department had, what was the equivalent of what is now their internal inspector general. They had a monitoring unit, they had a licensing unit, they had an auditing unit. But in the wisdom of the legislature, the legislators at the time, they decided that, well, whatever you guys have, it's not enough. You need something outside of that. And so we ultimately were statutorily enabled, and that's where we are today. And what we try to do is to make sure that physical abuse does not happen, and that restraints, physical restraints for compliance and seclusion, which some of you may have heard other terms for, isolation, the whole, does not happen, and that people cannot be, kids cannot be incarcerated, people cannot be punished for non-compliance. In order to have a properly transparent system, and I think the juvenile system is far more transparent than the adult system at this point, and in order to also, most importantly, protect public safety and prepare people for re-entrance into the community, you have to have proper mental health systems, you have to have proper physical health systems, and somebody needs to be keeping an eye on this for the legislature and for the public in general. And that would be why I would strongly encourage you to support this bill. And I'll just finish by saying, you have almost $1 billion spent every year on this agency. Really, you need to have a small unit that takes a look at what's going on for your almost $1 billion. Thank you.
Good afternoon, Chair Smith and members of the committee. My name is Gregory Brown. I'm the policy counsel for the ACLU of Maryland. The ACLU in Maryland urges a favorable report on SB 87, which would create a correctional ombudsman within the Office of the Attorney General. Maryland's correctional facilities are in need of an ombudsperson to increase accountability and transparency, remove access barriers in the grievance process, improve prisoner health care, and the overall upkeep and cleanliness of facilities. This bill would increase accountability and transparency by allowing the ombudsman to conduct unannounced inspections of facilities that have already been sent a letter of reprimand by the Corrections Commission. Unannounced inspections are vital to the effectiveness of the oversight of corrections facilities. The audits currently conducted on corrections facilities, including internal audits, have proved ineffective, as many of the same institutional issues, such as lack of access to physical health care and grievance reporting issues, persist. Having an ombudsman to submit complaints to is critical to the oversight of corrections because it would give the incarcerated community an external entity to complain to. Often inmates are not able to see their complaints addressed during the grievance process because those complaints do not even make their way up through the process. Relying on corrections officers and prison administration to adequately vet and address grievances made by inmates is one of the many reasons that the current process is ineffective. Black incarcerated people face the brunt of this problem, as Black Marylanders make up 70% of our prison population. SB 87 would make sure that the complaints of Maryland's incarcerated population, specifically its Black inmates, have a real opportunity for their concerns to be voiced to an external entity. For these reasons, we urge a favorable report on SB 87.
All right, thank you all very much. The committee for questions. I said a couple quick, sorry, go ahead, Senator Sidner.
Thank you. And this is a question for Judge Karoon. Would you mind telling us or sharing with us the difference between what's being proposed and the current investigatory unit that already exists?
Thank you for that question. It's our understanding, having spoken to the head of the internal investigation and program 3 years ago, as we were beginning this drafting process, is that it's a very different focus. That internal investigations unit, to our understanding, is primarily looking at allegations of criminal conduct by correctional officers and prosecuting them. It would not generally investigate the conditions, the complaints of prisoners that would be short of crimes committed against them, or the lack of services, medical treatment, and so many other things that the ombudsman would do. So we were told that by the person then in charge of that office that he believed there would be no conflict.
Thank you.
Thanks. I'll follow up with this later, but for Ms. Maroney, we're trying to do a crosswalk between your office and kind of the proposal before us today. And so this has, I think you have three pins. How many pins do you have under you?
Well, we've lost about half our people along the way with all the budget crunches of the last 15 years. So when I started, we had about 6 monitors and an AAG and an administrative person. We have 4 monitors, including me, total at this point.
Got it.
And we look at the whole state. But we're conducting unannounced visits pretty much every day of the year, including holidays. We can speak to anybody we want, from the secretary on down to on-site administrators, down to the kids, down to line staff, down to teachers, down to the medical folks, down to the folks who are doing therapy. So we find out an awful lot. And we also have full and unfettered access, as would the ombudsperson, to the internal agency case notes and the internal agency incident reports. And we've also managed to get cameras into every facility. We have unfiltered access to the footage that is captured on those cameras also. So we have found that although we could always do with more people, and
I'm not going to ask you to tell you. Yeah, I got you.
It's made a huge difference, and that's this is not a big office that's being contemplated here. This is just a way in to start with Jessup and figure out what the heck is going on, because nobody knows at this point what's going on. And like I said, it's almost $1 billion agency.
No, this is, I mean, it's this is not an adversarial line of questioning. I just wanted to see, and I'm not going to ask you to,
Sorry, I feel strongly.
value yourself by saying, you've got enough resources, but we're going to do a crosswalk of kind of the statute and the proposal here to see how they're similar and a little
Sure.
different. It seems like this is a little bit more expansive.
Yes.
And with not only pins, but the power that they have.
I would agree.
A different
although-
mission. I get the mission's different, slightly different.
Right. I would agree, but with the, at the same time, I would say that two of the most important strengths of the proposed office we already have, and those are very unusual. Don't know anybody else in the country that has it in these kinds of situations. The ability to come to the place and they got to let you in unannounced. That's important. We use that every time. Used to do a mixture. Since I took over 10 years ago as the director, we do unannounced visits 100% of the time, unless we're going to troll through an enormous amount of documents or video footage. We'll give them a heads up, but otherwise we're there unannounced. You got to let us in. So that's number one. Number two is public reporting and reporting to you guys. In addition, those are the two most important strengths. Yes, they would have, in addition to that, the ability to subpoena. That's about it, really. They have a lot of responsibility for a very big system. But again, you could see the success that I think they're going to have within the first year, concentrating on Jessup with a small crew of people.
No, certainly supportive of the efforts and further support for your office as well. The senator was a member on JPR, is now a member of what committee? Yep, and there's a fiscal note. So your work here is good. Your work there is unfinished. All right. Okay, I appreciate it.
Yep.
We'll go to Senate.
One other quick thing, in case because something that was brought up in the House was how does the independence work?
Yep.
So it's umbrellaed into the Attorney General's office. We're umbrellaed into the Attorney General's office. Are we really independent? Is there some kind of wall between us and the Department of Juvenile Services? And would there be, between corrections and the ombudsperson? And is there a wall between the Attorney General and the proposed ombudsperson? And is there one, between the Attorney General's folks and us? The answer is yes to all the above. So we are there. We are able to take advantage as the reprehensible types we are of all of their administrative help and that kind of thing.
Yeah.
But you'll find when we come here each year, sometimes we're on the same page as the Attorney General's folks with regard to legislative initiatives. Sometimes we're in opposition, and the same goes for our daily type of activities. The Attorney General is obviously that has an office that has so many units that are obliged in all cases to defend the state and the state agencies. We don't have that obligation. In fact, we're not adversarial with the Department of Juvenile Services, and I don't think the ombudsperson would be with corrections. It's all about trying to get on the same page and working with constructively to make the system better, which will both help people to come out in a way that helps them individually and helps public safety. And also incidentally, or maybe not so incidentally, I think will save an enormous amount of money, because when you're inefficient and when you end up doing things that probably you shouldn't, or neglecting, probably more commonly neglect than abuse, you're going to end up not just tragically badly affecting individual incarcerated people, but you're also messing around with your staff, and you're also costing people money you don't need to spend.
I appreciate that. So we'll be enlisting your help just to complete our crosswalk.
Yep.
But the bottom line up front is the piece that I just mentioned before. So we'll work on that. I have a certain amount that I can allocate from here without approval from B&T and from budget and tax. And so, the work here is good, but, all right. So let's go ahead and switch over to Senator. Thank you very much. Thank you, Senator Muse.
Thank you. I wanted to ask you just one question. Hello, and
hi, Senator Muse.
Thank you, Mr. Chair. We worked a number of years on a number of issues relative to juvenile services.
Strip searching and shackling, indiscriminate strip searching and shackling, for example. Right.
And it was the reports that you would often release that either it went someplace or it did not. I've not been, because just coming back, I'd like to get a copy of some of your reports relative to that to see if we've made progress or what's different about it. I would like to do that. I have been talking to the governor and others about, what did exist and how we can bridge that. in an amicable way and still provide the services to children. I did do some of the visits, and I just want to see what the status of it is now from your perspective. If you can do that for me.
Yeah, absolutely. And anybody who wants to look at our public reports, which always include a response, a formal response from the department, can look at, just Google JJMU, which is Juvenile Justice Monitoring Unit, OAG for Office of Attorney General, and lo and behold, then the web page will appear. It is a web page, dedicated web page on the Attorney General's website, and you can click on all of our public reports right there. But you know what's happened basically is that we have far fewer kids in the deep end of the system at this point. Far fewer. You know, when I started, Cheltenham in Prince George's County, your home turf, had upwards of 200 kids, 240 kids. When I first started working as a monitor, I was pushing my kid on a swing in a park, and there was another guy who looked like he'd been through the wars, who was doing the same thing with his kid. And he said, "What do you do for a living?" And I told him, and he said, "Oh yeah, do you ever go to Cheltenham? You know, Boys Village, as it was called then." And I said, "Yeah, I do. I monitor Cheltenham." So he said, "You know, what's it like?" It was an absolute horror. I've been through adult corrections facilities, prisons, and it was the worst place I've ever been. And at that point, it was. At one point, they had the National Guard bring in tanks there. It was ahead of my time, and they used to let the things would get so out of hand and be so understaffed that they would close the gate when a fight broke out, and the staff would let the fight go on until it ended one way or another. All that's gone. All of that is finished. There's far fewer kids in the deep end of the system. It's not a perfect system, but they're getting much more of what they need. So that's where we are today.
Thank you. Thank you.
Thank you very
For
much.
the work that you all do.
Excellent. Thank you, Senator. All right. Seeing no further questions from, sorry, Senator James, go ahead. Sorry.
To anybody, because I'm not sure who would answer the question. Just, first of all, is this bill modeled on bills in other states? I know you referenced Virginia, but it's a very, lengthy bill. So is this model language about how to create an ombudsman in this context?
There's an organization called the American Association of Ombudsmen, and they have in fact, a model ombudsman act. And that was our starting place. From there, we did compare the statutes of many other states and also the Juvenile Justice Monitor bill. We spoke to Mr. Maroney of the JJMU, who told us, certain features were indispensable. So we put all those in and tried to make it the most comprehensive we could.
And then this allows the ombudsman to subpoena witnesses giving sworn testimony and evidentiary. So, and there is a possibility that the ombudsman can refer something criminally. So does the individual that subpoena or interview have a right to counsel?
I personally, the statute doesn't specify that, but certainly any individual would have the right to invoke the Fifth Amendment, not to testify, and the right to counsel before any testimony possibly could be compelled. I believe the court would take, into account those basic principles if it was necessary to go to court. We hope that it never would be necessary for them to go to court. But in the event that there became an adversary relationship for some reason, we thought it was better to put that in than not to have it.
I don't know if it would make it better or clear, but you might want to consider just making it clear that nothing in this act, alters that particular relationship that an individual has with counsel and the right to remain silent. And then there's we can do this later. I don't want to make any hearing very long, but the judiciary has a memo that goes into some detail about some drafting issues that make parts of this ambiguous. And also
they had made that same suggestion last year, and this year they sort of amplified it. It is, I think, our intention to make it very clear that the ombudsman is not to be going through judge's office or courthouse. We're really strictly concerned with what's going on in the Division of Corrections.
So you would be amenable with
I think we have no problem with that amendment.
Amendments that would make them comfortable. All right. Thank you, Mr. Chairman.
So last question, and this for Ms. Maroney, just a number of very succinctly. How many how many facilities do you cover?
We cover all the DJS facilities, so all of their large congregate detention facilities, which would be the equivalent of adult jails in the state, and all of their placement facilities. And again, they're pretty large and congregate because unlike a lot of other states, the agency DJS basically operates directly those places.
Roughly how many?
I think it's about 12 total.
All right, what, and for the jurisdiction for this, how many prisons and facilities would this cover, this bill? Physical locations?
Right now, we just cover Jessup. The intent over time, once it bolsters its staffing and gets its legs within the year, would expand. Do you know, Judge, precisely how many? I mean, I think it's the whole system.
How many in Maryland are there? Sorry.
Yeah, I think it would expand the whole system.
It would expand statewide. So they would also be in Hagerstown and the Eastern Shore, and the total number of institutions, the hardest to count is Jessup.
Okay.
Because there are so many sub-institutions, but I think it would be more than a dozen. It technically would also include the Baltimore City Detention Center because that is within
Maryland.
the definition.
Yeah.
But another important thing with there is there's a filtering mechanism, which the ombuds bill includes, which we don't have. We tackle everything, but the ombuds bill talks about a kind of a committee behind the ombuds person that sort of looks at this stuff and then passes these complaints on. So
You see where I'm going though with this, right? I mean, so if I can't get the 500 and I have to tinker a little bit with your jurisdiction or staffing levels, the money is really for the pins. And
yeah, I agree. And I think though that the Attorney General has expressed that he's very supportive of this, but it really needs those pins. And in fact, he would like an accelerated, it talks about over a number of years, you'll get these pins.
We've all got a Christmas list, but
but like it's almost $1 billion situation.
I get it.
So we're talking about $500,000, they probably saved that this year in
I'm trying to help you out. All right. Thank you very much.
Thank you.
Appreciate it. All right. Seeing no further questions for this panel, let's go to the next round of guests. You want to come? Are you on this bill? Come on up. All right. Annie Kirsch, Margaret Berry. Is Miss Meadows here? I saw Lila here. Miss Meadows, I saw you. Come on up. And then Miss Haven. Yeah, Kim. If we can't all fit, then we could just. Kim, I'll call you the next one.
Thank you, and good afternoon, everyone. My name is Margaret Martin Barry, and I'm an emeritus professor at Vermont Law School, longtime resident of Montgomery County, and former director of the Reentry Clinic at American University, Washington College of Law. I'm here today on behalf of the Montgomery County Women's Democratic Club in support of SB 87. We've also submitted written testimony. Passage of this bill is one of WDC's legislative priorities for this session. Despite the congratulatory awards that the Corrections Commission has given to our correctional facilities, the following abound, and you'll hear more about it today: unhealthy sanitation, poor health care, unfair work conditions, limited work opportunities, limited or no educational opportunities, difficulty in staying connected with family, broad and extended use of solitary and other abuse. Facility personnel and incarcerated people who want to shed light on what's happening in the facilities do so at considerable risk to themselves and with little effect. Expectations for effective prison management can only be met when we have independent oversight. The independent oversight that this bill would assure and establish. We need our institutions to return people to the community who are rehabilitated instead of suffering and disoriented. This is what we expect as taxpayers and as citizens. It is the humane thing to do, and it makes for safer and healthier communities. WDC urges you to favorably and expeditiously report this legislation. Thank you for your time.
Good afternoon, Elizabeth Hilliard with the Office of the Public Defender, Chair, Vice Chair, members of the committee. Thank you for having us. I'm going to start by answering some questions that were asked previously, just to give a little more information for the comparison between the JJMU function and the Correctional Ombudsman function. I'm looking at the annual ADP from the fiscal year 2022 from DPSCS. There were 17,299 people in custody. There are 31 facilities listed. My understanding, and I was briefly trying to skim through GJS facilities because that is not my wheelhouse, they have 12 and they are always below 3,000 persons who are incarcerated at a time. So just a few more adults in the DPSCS system. You're going to hear from my colleague, Vanita Taylor, about the general need for this bill. I'm going to speak to you specifically as someone who has spent a significant amount of time in Maryland facilities. I have had family members call me after their child has passed away because he could not receive his inhaler while he was having an asthma attack for hours. I had no one to direct them to. I have been inside the medical facilities in Jessup. I hesitate to call them medical facilities. I am allowed to make unannounced visits in the sense that they cannot keep me from my clients. So I see what Patuxent looks like when it hasn't been cleaned and polished, when we're not being led through the facility and shown the gardens and the grounds. It is not humane. In addition to those conditions, we also need more information about the programming, the mental health care, and the physical health care being provided in these facilities. We urge a favorable report on this bill, and thank you so much, Senator Weston and Senator Huddleman, for bringing it in.
Good afternoon, Senators and Chairman. I'm Vanita Taylor from the Public Defender's Office, and we request a favorable report on this bill. What you heard today is that there's a need for transparency and there's a need for accountability from the Department of Corrections. What happens behind the walls, if you don't see it, if you don't report it, if you don't hear it, how can you make any kind of reforms? The only time that we hear about incidents, Department of Corrections, is when it hits the press, when it's on the news, as in when we had the COVID outbreak and people were not being served, people were thrown in together, and there was a video made about the situation in Prince George's County facilities because of the lack of medical treatment and isolation for people who were encountering the symptoms of COVID. In Maryland, we don't want that. We want there to be transparency. This bill allows for anyone to make a report. It allows for an inmate, it allows for a family member, and it allows for a community person. People don't always complain to the facility because of current practice. You make your complaint to a CO and then it's passed on to a grievance commission. But a lot of times it's not about grievances. What the people who are incarcerated behind walls want are services. It's not a grievance about a CO or someone else. It's about receiving services. And it's also about transparency. Everybody has a supervisor. Everybody has someone that evaluates them. There's no evaluation process for this whole complaint system that they have developed within the Department of Corrections. There is none. This bill has, they have to make a report to not only the governor's GOCAP office, but they also have to give a report to you members of the House that service our tax dollars. So we request a favorable response. One more thing, Senator, is that there are times when you guys visit these facilities, but I've been told by my clients that, yes, that they allow you, when you come visit, it's a dog and pony show. And then particularly the women at Jessup tell me there are places that they never take visitors, never. So you don't know what really is going on behind these walls. An ombudsperson will be allowed that unfettered access. Good afternoon, Senators. I'm Michelle Kennedy Quadio. My son has been at the Eastern Correctional Institute for about 7 years. He was 26 when he started serving his time. He's a person in prison. He did not become a non-person when he went to prison. I believe that the Ombudsman office could make a difference. It could have made a difference in the illustrations I'm going to give you of what happened in the past few years, and it would make a difference. I think it would make a difference in humane treatment of people who are still human in prison. After being in prison for 4 years, my son finally received a dental assessment that revealed he had 2 to 3 cavities. 2 years later, he was finally seen for treatment and is still pending additional dental services. He had finally brought the complaint after the process to the warden. People in prison don't like to rock the boat for fear of retaliation. Also, since COVID, my family and I are allowed 1 in-person visit a month. Although the visit is supposed to be 1 hour, the guards start the check-in process during that hour, permitting my family only 45 minutes. I brought this to the attention of the warden's office several months ago, yet without result, because 2 months later, I was still only allowed 45 minutes to visit. I drive 6 hours round trip to see my son. This Sunday, February 12th, I will visit my son with his 13-year-old daughters. They haven't seen their father in 3 years. We have not kissed or hugged my son in over 3 years. It's still not permitted. A final example. In 2022, I called the Office of Corrections and Public Safety, spoke to their policy officer regarding insufficient cooling in the ECI cells. Although people at the ECI prison complain that the cells reach above 90 degrees, almost 100 degrees, the prison staff simply responded that the AC was on. Nothing was done to address this. The policies resultant from COVID about 3 to 4 years ago regarding visits contact need to change. I believe the various prison commissions and prisons themselves will be more responsive to issues raised by people in prison and their families through an independent office of the Ombudsman and the Attorney General's office. This additional oversight will better assure evidence-based services and results in the prison systems throughout Maryland. I don't believe this is a savings. I believe it's an investment in human beings in prison. Michelle Kennedy Quadio, mother and family representative, Montgomery County voter, homeowner, and taxpayer. Thank you.
Thank you very much.
Good afternoon, members of the committee. My name is Lila Meadows, and I'm a faculty member at the University of Maryland School of Law, where for a number of years, I've had the privilege to represent men and women who are serving long sentences in the Department of Corrections in Maryland. I want to speak to a specific aspect of Maryland's system that I think this bill really helps address, and that's medical care. And you've heard a little bit about sort of the poor medical care that people receive, but I think this is so essential because Maryland has made the choice to outsource medical care in the Department of Corrections to a private contractor. And the result of that is the existing grievance process really is inadequate to address those issues. So for example, I have clients who need chemotherapy. It is not uncommon for those clients to not be transported to those chemotherapy appointments at outside institutions. They can't do it in-house. And so I get a call from the doctor at University of Maryland, Lila, client didn't show up today, what's happening? I call the warden's office. The warden's office says this isn't a custody issue. This is a Corizon issue. I call Corizon, they say this is a custody issue. They didn't put in for transport. And we go round and around and everyone points fingers and clients can file a grievance. But at the end of the day, nobody's left holding the bag. I'm an attorney. I'm trained to go through the process, right? File the grievance, do the ARP, but it's not responsive when there's a disconnect between the state and a private contractor. And for that reason, there needs to be an independent place to go in these cases. And so for that reason, and because my clients often won't let me intervene, even in an ineffective way, because they're afraid of retaliation, I urge you to issue a favorable report. Thank you.
All right, thank you all very much. Questions from the committee or the panel? All right, seeing none, thank you all very much. All right, next we'll hear from did Annie Kirsch come up? All right, what about Anita Weist? Miss Haven? Come on up. And is Miss Farrell, Sarah Farrell from WCL? And all right.
Hi, I'm Ann Bocchini Kirsch, and I am a returning citizen who has come out, and I am now Director of Advocacy for Prepare. I've seen this system from all sides, and one of the things that I've learned in building a collaborative organization is that communication is critical. It's that working together is critical, and it's that collaborative processes work better than adversarial ones. The current administrative remedy, I'm going to call it the ARP process for short, is an adversarial one. And it's one that at its lowest levels is staffed by people that have a lot of other jobs, sergeants and lieutenants that are custody, people in headquarters who have other things to do, administrative law judges that have tons of responsibilities. And so the timelines that are in COMAR are not the timelines that are kept to. These are adversarial processes where dismissal is the goal just because you're talking about people being inundated. And what you need for efficiency and what you need for everybody. I mean, this isn't good for the incarcerated people. It's not good for DPSCS either. We need to fix problems, not just put them off. And that's where I think the ombudsman could come in. The ombudsman can be a place of collaboration, a person who's speaking to all the silos and allowing the communications to happen that can build the solutions to problems so that those problems don't keep recurring and recurring and recurring. You need somebody who can go straight to the top and fix it. A sergeant can't do that. Even if they agree with you, even if they see the problem, they can't go straight to the top and fix it. Even a warden doesn't have power against somebody like Horizon, but an ombudsman could. And that's why I urge you to give a favorable report on this bill, because I think we need to start working together. And I think this is the first step. Thank you.
Good afternoon. My name is Anita Weist, and I'm retired from the ECI, Eastern Correctional. And before I actually start to talk, I just want to make clear that none of the housing units at ECI have air conditioning, far from it. I've been in those housing units, and I would say temperatures go up to close to 100 degrees. They're intolerable. I think we treat our dogs and cats better than we do our human beings that are incarcerated. It's very hot. It's very, very hot. If anything, they're lucky when the toilets don't overflow and back up all over the tiers. That institution was built in 1987. It's housing 3,000 people right now. It's the largest in the state of Maryland. I'm a licensed clinical social worker as well as a licensed addictions counselor, and my job at ECI was as the addiction supervisor. You may remember in 2015, then Governor Hogan appointed the task force on heroin and opioid overdose task force for this state. One of the proposals that came out of that task force was a pilot program that I started at ECI in December of 2015. So I applied for and received funding from the Governor's Office of Crime Control and Prevention to train and supervise incarcerated persons in recovery to provide peer support as a treatment adjunct. Despite statistically significant results and a promise from GOCOP to fund the program for another year, headquarters did not support this initiative. They redirected $48,000 to a staff training and purchased hundreds of boxes. I saw them, I helped load them, of DVDs and workbooks that were shipped to all the prisons in the state. There was no follow-up on this training. And I'm sure the workbooks are still in the cardboard boxes in which they were shipped. And we lost the funding from the governor's office that was promised to us for the following year. Over the past year, representatives from Major and myself had met on 3 occasions
Your time's expired. If you could just conclude.
with
Thank you,
department administration. Treatment is a passion. In 2020, when I first testified on this bill, there were 6 addictions counselors in the entire state. They are down to 3, and there's no long-range plan for improving addictions treatment services. As a member of the community, I'm sure all of you would agree, we want people returning with the treatment they need and desire. Thank you.
Thank you very much. Thank you. We have one more witness to test, 2 more, and then we'll have questions from the committee. I see you, Senator Muse. Okay.
Good afternoon, Mr. Chair, members of the committee. My name is Kimberly Haven. I'm the legislative liaison for Interfaith Action for Human Rights here today in support of SB 87. Over the past decades, advocates have worked to highlight the abuses and the conditions and the need for reform within our correctional systems, but have met with pushback and smoke and mirrors. Family members and legal advocates have experienced frustration and repeated dismissals, if not complete disregard for their concerns. Legislators, such as yourself, routinely receive letters from incarcerated individuals and family members seeking assistance, begging for help. And what can you do? You contact corrections and ask them to do something, and there's no follow through. Or you contact advocates like me, who then come to Annapolis every year. People that we incarcerate should come out better than when they went in. But we know of too many incidences where the opposite has occurred. We as community members must be able to hold corrections to that ideal. As you heard, corrections is one of the biggest budgets. It is also an agency that has been allowed to operate without oversight and accountability. I'm frequently heard saying we can't fight what we can't see, and we can't see what they won't show us. SB 87 would provide an independent set of eyes and ears for the public. It would open up the otherwise closed world of corrections and will shine a bright light on the conditions and concerns that you're hearing now and that have only deepened over the years. SB 87 would provide a mechanism for investigation into the concerns that we raise here in Annapolis every single year. The costs, both human and financial, associated with the lack of oversight are many and high. Because the Correctional Ombudsman would be independent from and external to DPSCS, it would ensure both objectivity and credibility and allow for holding our system up for investigation and scrutiny. SB 87 would provide balance. I know, I got one more line. SB 87 would provide balance, critical transparency, which would create accountability in an agency where there is none. For these reasons, IAHR urges a favorable report on SB 87. It was 1 sentence. I just didn't use punctuation. It was a run-on.
You're lucky we have a good relationship. Yeah, all right. Yeah, but honestly, in all fairness, look, like the reason why I try to keep it to 2 minutes is not because, I don't want to hear everything you have to say. It's because we're just trying to be fair to everyone else, and so that everyone gets the same amount of time. So we've got a lot of witnesses and want to make sure that we hear from everyone. So we really appreciate you working with us. Thank you. Thanks.
Good afternoon. My name is Sarah Farrell, and I am a student at the American University Washington College of Law, testifying on behalf of the Reentry Clinic in support of this bill. Our clinic represents men and women who have served decades in Maryland's prisons, and we advocate for their release in Maryland circuit courts and at parole hearings. The Department of Public Safety and Correctional Services does have a formal process for inmate complaints currently. As outlined in the flow chart attached to my written testimony, the Code of Maryland Regulations sets out this process, which can take months to reach the inmate grievance office, and that is before a hearing is scheduled for an administrative judge to review the grievance. After a judge independently reviews the complaint, that decision is then forwarded to the secretary of the department, who makes the final determination. So in the end, the final decision still falls under this department. If a person then decides to challenge a matter further, the challenges that arise with judicial review are that state employees acting in their official capacity are immune from liability under the 11th Amendment. This often leaves individuals harmed by the system very little avenue for redress. For these reasons, the presence of an ombudsman is so critical. Accountability means nothing if it is not wholly independent from the very institution and people it is holding accountable. Inmates with grievances will be able to file them directly with the ombudsman's office, and the office will investigate and conduct independent reviews as a response.
Staff will be restricted from interfering with the investigation or processing of a complaint and will be penalized if they attempt to do so. The state currently has a lengthy, time-consuming process in place that lacks complete independence until it reaches the court system. And once it reaches the court system, employees of the state are protected from liability if acting in their official capacity. Even if a resolution is enacted, the process can be so exhausting that by the time a resolution is met, a situation, especially if medical, can become more severe or even dire. Many of our clinic clients have expressed this frustration. Under the current process, accountability does not mean what it should. Providing accountability is why the Reentry Clinic supports this bill and urges a favorable report. Thank you.
Thank you very much. The question maybe to you, yes, ma'am, was something that you said. Let me, as you're getting up, preface it by saying the reason this is so important to me is because part of my job has been assigning pastors as chaplains to various places throughout the state. I did it before I was in a position to assign them. And the stories that I've gotten back from the human perspective were horrible. And there was very little to be done about it. I wasn't, but I am very much concerned, and I do want to do something. You mentioned that the governor's office canceled the funding.
Oh.
Who was that? Yeah, I'm sorry.
That was-
Yeah. Oh, yeah, that they canceled the funding. My understanding was it was doing well. Why was it canceled?
The governor's office didn't cancel the funding. They were going to refund the program for another year.
Okay,
However, headquarters
got you.
redirected the money.
That's what I wanted to know.
So they took it away from the program. I don't know why they didn't move forward on the program.
Then I'd like to talk to somebody at some point. You can see someone in my office. Let me talk to them or any of you about it, and let's see what we can pull together. Thank you for letting me be a co-sponsor on this bill. All right, thank you. That was my question. Thank you very much.
Additional questions from the committee? All right, seeing none, thank you all very much. Did we have Gordon Pack? Is Gordon Pack? Come on up, sir. Dahlia Inabet? Inabet, yeah, there you go. Ashley Egan?
Speaking for her, she's a director of our Unitarian
Okay.
Universalist Committee.
Come on up. And then
Clark.
Donald Bavello. Is Donald Bavello? There you are. All right.
Good afternoon, Chairman and distinguished senators. My name is Gordon Pack. I'm a resident of District 41. I'm also a recipient or beneficiary of the Juvenile Restoration Act. I'm a returning citizen, having served 42 years in the prison system. I'm all too familiar with failures of prisoners, failures of correctional staff, failures of contractual services, and failures of the policies and procedures within the Department of Public Safety and Correctional Services. I support the Ombudsman bill for the simple reason I think it's the best thing for public safety. First of all, at some point, everybody in prison is going to get out at some point. Also, I believe that people who go to prison should have the opportunity to reside in an environment that's productive and conducive to their growth and development. I also believe that correctional staff should be able to work in an environment that's safe for them as well. Unfortunately, because so many problems take place in the prison system, conflicts are always there, it doesn't always pan out the way it's supposed to. And sometimes you try to get issues resolved by the administrative remedy procedure, and they don't get resolved. Sometimes we need quick solutions to problems and they come too late. I have witnessed firsthand medical staff taking a position because this guy comes up here all the time and cusses us out, let him stay in that bullpen and die. We're not going to see him. I have witnessed peers, friends who have been stabbed and it takes so long to come get them. We have to get blankets and 4 of us and run them up to the infirmary. I have witnessed correctional staff who have been overworked so much that they fall asleep at the post, and you got to go, that man, wake up. I have witnessed so many things that are atrocities to me, but the reality is the only way this can become better if we can have someone that's not involved with or get their paycheck from the Department of Public Safety and Correctional Services. Without an independent person that can mediate, investigate, and deal with these issues that come up, they're going to continue. And believe me, I could go on with all of the things that I've witnessed. But I support this bill because it's a public safety issue. And I am ashamed to have to come up here after all the stuff that I've been through, but I feel obligated because it's too many people that's still in prison and too many staff workers that I care about that's stuck in that situation. And it shouldn't have to be. Thank you for your time.
Appreciate it. Thank you very much.
Chairman Smith and Vice Chair Waldstreicher and JPR members. I am Karen Clark, the Criminal Justice Lead Advocate for Criminal Justice for By Faith, the statewide Unitarian Universalist Legislative Ministry, and we strongly ask for your support. Maryland's police accountability reforms recognize the outside oversight contributes to restoring trust and justice for victims of officers' inappropriate use of power, and this bill will do likewise. These stories, I won't even list them, say them, demeaning treatment and in-house scandals and other issues slip out from behind our prison walls. Last Sunday in church, after we had our annual UULM statewide Zoom on issues, one of our members shared that while he was in a Maryland prison, the administration accused him of being in a prison gang. He swore it was not true. It took him 2 years and a lawsuit to clear his name. We can do and we must do better. And by establishing this impartial, independent oversight, the knowledge and about the conditions and situations behind the walls will be more reliable, no rumoring. Our correctional institutions should be that positive environment where offenders are offered a chance and opportunity to learn and transform, so they will not need to resort to crime to survive upon their release. And again, everything else has been said. We now have a juvenile system and the adult system needs the same. We ask for your support. Thank you.
Hello, my name is Dahlia Abnett, and I am a student attorney testifying on behalf of the American University Washington College of Law Reentry Clinic, which is a clinic that represents individuals who are housed in many Maryland prisons. We support this bill because it mirrors our goal to change the focus of Maryland's Department of Public Safety and Correctional Services from punishment to rehabilitation. Through the clinic's look into the decades that our clients were sentenced to spend behind bars, we often find misconduct by correctional officers who are exposing our clients to the same criminal acts that led to their incarceration and who are using excessive and sometimes malicious force. There have been at least 6 major scandals over the past decade, which are cited in my written testimony, that involve drugs and other contraband being brought into Maryland prisons by officers and that involve assault by officers. There's also a lack of resources that should be provided to help our clients work towards rehabilitation while they are incarcerated. The creation of a reentry plan should start as soon as someone enters prison, but that isn't the reality. Instead, these men and women have sat in prison for years with little help from staff and had to design their own makeshift plan for rehabilitation. It's like sending a child to school with limited materials and no teacher for guidance. The Correctional Ombudsman bill supports rehabilitative reform that addresses these issues because an ombudsman would be able to enter any facility unannounced and get an accurate and timely feel for how correctional officers are conducting themselves. They would be able to see what rehabilitative services are not being adequately offered, and then they would bring that knowledge to the public so that changes can be made. We are all products of the chances that we were given. It is time that we ensure that incarcerated individuals in Maryland are given a chance to grow in an environment that is conducive to rehabilitation. We urge a favorable report.
Good afternoon. My name is Donald Bovello. I served over 35 years in Maryland prisons, 33 of those years at Patuxent Institution, where I first met you, Mr. Chairman, when you came in with Delegate Queen. Prior to your coming in, I was told by a sergeant that you would not be allowed in. I believe Kathleen Dumais was also supposed to enter with you, and she spoke to the secretary, and that's how access was granted. But it was not an easy fight. They did not want you coming into that institution, and your access was limited. In the time that I've been there, what I'm going to tell you are things that I saw with my own two eyes and I experienced. I personally witnessed correctional officers brutally beat inmates in that facility. I watched them extract inmates out of cells who did nothing more than say some words to them, handcuff them, put them on the ground, beat and kick them. That is inhumane. It is unconscionable that a human being would do that to another human being. And the fact that the DPSCS has the ability to hide their actions for so long is unimaginable. How can that happen? Oversight is necessary to ensure that the human rights of human beings being housed in Maryland's prisons is preserved. It is necessary so that the individuals who are in those places of incarceration are able to receive rehabilitation instead of punishment and can come out better, less likely to be a recidivist. And they can become a contributing member to society instead of being a problem to society. I urge you to please give a favorable report for this bill. Thank you.
Questions from the committee? All right, seeing none, thank you all very much. Thank you. All right, is Margaret Stokes. Mr. Rudy. Yep. Catherine Abrams. Marsha Briley or Briley? Marsha here. All right. Whoever would like to start.
Good afternoon. Members of the committee and to Senator Hettleman, thank you for being a part of this bill. I want to stay in here and just say that this piece of legislation is very important to me for today's society more than ever before. We have witnessed too many unfortunate situations dealing with hidden corruption that finally have been exposed. The prison system should not be exempt. Human lives matter even in the system. With social media and cameras everywhere, corruption has been exposed with factual evidence. The world has witnessed many incidents with their own eyes. The sad part is the prison has no way to really show what is going on behind the walls. Having an incarcerated family member has been a challenge for my family. Some of the things I've heard that goes on behind the prison walls is unimaginable. I realize that prison is not a nightclub to go and enjoy entertainment, but the conditions inside should be evaluated. There are no cameras and true evidence behind the walls to show what really is happening. This is why this bill is very important. Independent agencies from outside will be able to see and witness what is actually happening. There are little to no education or trade classes offered, jobs available, or honesty by some of the staff. What the staff say goes without any exceptions. The decisions are final. Here are some of the common complaints that I have heard. No drug treatment. Food has sickened the inmates on a daily basis. Guards using unnecessary force to restrain inmates, which includes bodily harm beyond necessary. So this is why this bill is very important. Time to curb the corruption.
Thank you very much.
Chairman Smith, committee members, Senator Hillman. I'm Bob Rudy. I'm here on behalf of Maryland Alliance for Justice Reform. We got about a dozen people here from Major in support of this bill. I'm on the board and on the executive committee. I also want to state as background of my testimony, my personal support for this legislation, and some of my personal experiences with the prison ombudsman system, and my work in professional mediation, and my service as a Quaker in Quaker ministry in prisons in Maryland. I'm an attorney, admitted to practice in Iowa in 1974 and Maryland in 79. I was in private practice in Iowa during 74 and 78 when I came to Maryland and worked for Maryland Legal Aid as their chief attorney and legislative counsel. I served as executive director of Maryland Legal Services Corporation for 17 years, and I've self-worked primarily in various mediation capacities, serving as creator and director of the Maryland Court of Special Appeals Mediation Program during 2009, 2012, before returning to private practice. In Des Moines, I served as the president of I was in private practice, president and legislative counsel for the ACLU. In that capacity, I had a lot of interaction with the Iowa Office of the Ombudsman that was created in 1970, one of the earliest in the United States. And it was created by the General Assembly as an independent body that conducted investigations, sought to settle disputes, made reports and recommendations annually to the General Assembly. If it was unable to resolve a complaint but found a merit, or especially when it found a pattern of such complaints, that provided information and recommended remedies to the General Assembly for change. Among the state agencies it had oversight for and ombuds functions were state prisons and eventually local jails in their 99 counties. I found it to be a highly effective program. They have, I've got their annual report. They've took over 6,000 complaints in FY 2022. The types of complaints are pretty consistent with what we would expect in terms of 32 complaints of the total 6,484 were in the prison area. They cover all of state government now and all of local county governments and independent schools. They're 32% of their total, 6,000 were from prisons, 16,000 from county jails. The top 5 prison complaints were health services, discipline, conditions of custody, and classification, property, and mail. We've got some more information that I've shared with you. I'd be happy to on what's happening around the country in this area.
Yep.
How the ombudsman work. I highly support this legislation. I think you'll do a service to the state. Thank you for your time.
Thank you very much. It's always awkward to, end a testimony with someone you know so well. I'm sorry. Welcome.
Good afternoon, everyone. My name is Catherine Abrams, and for the past 6 years, I've been a clinical employee in DPSCS, and I have loved my job. I have been called to work inside the institutions and with this population, and it has truly been a passion of mine to bring light to those that most people can't work with. I fully support this bill because I have seen what DPSCS has tried to hide. And I know from the employee side where our failings are and where we need the most help. For the past 2 years, I've sat in over 60 mortality reviews and not one where DPSCS found fault on their own. After filing a sexual harassment report against a DPSCS employee, it took over 9 months for our internal investigation review team to even investigate. After one housing unit experienced an unusually high amount of deaths within 2 weeks, The officers inside who asked for help and support were told, this is normal. Death of an inmate is an everyday occurrence. Get over it. DPSCS lacks the ability to hold their staff accountable, support us, and give us an environment where we want to work. I have loved my job. I have loved the job that most people can't do. And I sat in my car most nights crying after telling someone's mother that their son was killed inside due to negligence. And it's not okay. It's time for the state to do something. We need to start changing because this can't be our legacy here in Maryland. Good afternoon, Chairman and everyone on the committee. I'm Marsha Briley. I am a former DPSCS employee. I think everyone in this room already knows what I do now as far as reentry efforts in here in Arundel County. I'm here today you have my written testimony, so I will not go into that, but I do want to highlight the fact that you cannot expect what you don't inspect. And you can't inspect something that someone doesn't allow you to inspect. So, working for so many years behind the fence, and then I was a correctional case manager. I was a parole and probation agent. I held 2 leadership roles. I was oversight of the parole and probation comment unit sex offender. I was the deputy administrator, and my last position was director of reentry and transition services. So I had oversight of staff, contracts, MOUs, partnerships, budgets. So I was able to see, firsthand things that were inappropriate, that if you questioned, you become ostracized. So I feel like this legislation is so important. Everything that you heard today, these are just symptoms of a bigger problem. You have an agency that is decayed. It is decayed, and you need the body, the legislative body, the taxpayer. We owe it. You owe it to the state. You owe it to the taxpayers. You owe it to the employees. You owe it to the individuals that are incarcerated to pass this legislation for independent oversight.
All right, thank you. Questions from the committee? Seeing none, thank you very much. Thank you for taking the time. All right, is Jennifer Beskid? Hey. David Green. Cleveland Friday. And then we will switch to our virtual participants.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the Judicial Proceedings Committee. My name is Dr. Jennifer Beskid, and I'm the Director of the Office of Government and Legislative Affairs for the Department of Public Safety and Correctional Services. With me today are Assistant Commissioner of Correction Cleveland Friday and Warden David Green. I'm in front of you this afternoon to discuss Senate Bill 87, Office of the Attorney General, Correctional Ombudsman. The Department of Public Safety and Correctional Services operates the Division of Correction, the Division of Pretrial Detention and Services, and the Division of Parole and Probation. The department is subject to oversight by the American Correctional Association, a national accreditation entity that ensures the integrity of the standards and accreditation for participating correctional agencies and processes, and develops standards that are based on valid, reliable research and exemplary correctional practices. The department is a participating agency with the American Correctional Association. Within Maryland, the department is subject to thorough and routine internal and external audits conducted by the Maryland Commission on Correctional Standards, the Office of Legislative Audits, and the Office of Performance Evaluation and Government Accountability, which was established in 2019. Each of these oversight entities ensures compliance with standards and audits. In addition to the oversight the department is subject to, there are pathways within the department for the incarcerated population to utilize in order to file complaints and concerns via a fair and equitable process. Warden Green is going to provide an explanation of the robust administrative remedy process.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. My name is David Green, and I'm the warden for the Maryland Correctional Pre-Release System. I've held many positions throughout my career with the department, including as the program coordinator for administrative remedy and inmate grievance. I was also the director of case management, and this role included oversight of all aspects of administrative remedy and inmate grievance to include training, policy development, and audit. As has been stated, the department is subject to the oversight of several legislatively established entities. The department has also been making strides to improve our transparency, including the availability of tip line, dashboards, and increased use of our website and social media platforms. The department has a number of resources, both formal and informal, available to our incarcerated persons so they may file a complaint. The administrative remedy process is a formal resource available to every incarcerated person, and they may file a request for administrative remedy for concerns about conditions of confinement as outlined in our written testimony. An incarcerated person initiates a request for administrative remedy by obtaining a form which is available in every institution and submitting it to a staff person who signs for it, acknowledging receipt. The staff person submits it to the administrative remedy coordinator, who assigns it a case number and moves the complaint forward for investigation. Upon conclusion of that investigation, the warden reviews the outcome and signs the formal response, which is returned to the incarcerated person. If the individual disagrees with that formal response, it can be appealed to the Commissioner of Correction. With that, I'll turn this over to Assistant Commissioner Friday, who will speak about the next steps in that process.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Cleveland Friday. I am the Assistant Commissioner for the Eastern Region of the Division of Corrections. I have been an employee with the Department of Public Safety and Correctional Services for over 25 years. And at one point, I was the Administrative Remedy Procedure Coordinator for one of our facilities as a sergeant. As Warden Green stated, when an incarcerated person is in disagreement with the formal resolution provided by a warden, they may appeal the decision to the Commissioner of Corrections. The appeals process includes providing all of the documentation from the original ARP, along with a statement describing the reason for the appeal or the basis of the disagreement. The appeal is reviewed for validity, and an additional investigation is conducted to determine if the original complaint was meritorious or if there was an error in the decision. The findings are then submitted to the Commissioner of Corrections for review, who signs them, and then it is returned to the individual. Should the complainant remain dissatisfied with the decision of the Commissioner, they may appeal to the Inmate Grievance Office. Complaints filed with the Inmate Grievance Office are heard by an administrative law judge. The ARP process can continue until a resolution is reached, and in some cases may result in an appeal to the circuit court. Another option available is for the incarcerated population to file, in other words, another option is available for the incarcerated population is the Investigative and Intelligence Division. When a complaint indicates an incarcerated individual is being threatened or is at risk or harm, detectives assigned to the Intelligence and Investigative Division are notified and an investigation is conducted. Excuse me. As our testimony has stated, the department is subject to both, state and national oversight. Therefore, I ask the committee members to consider the information provided in our testimony and the impact of an additional level of oversight being implemented, debating Senate Bill 87. Thank you for your time, and we are available to answer any questions.
Thank you very much, and thank you all for coming down and for sharing your side to this. I appreciate it very much. Just some questions. You initially, what you said, just so I can have clarification. I've done this many years with the juvenile, Department of Juvenile Services. I just want to know more about how you handle it. You said that this isn't needed, this legislation is not needed because you are monitored by, well, you said the American Correctional Association, is that right? And when they do an evaluation, who do they report to? Their findings, their reports, to whom do they issue it in terms of the state? They're evaluating you. We have a human interest and also a financial interest. So when they evaluate you, to whom do they issue those reports?
The department enrolled in a memorandum of understanding with the American Correctional Association, which allows them to come in and audit us. As a result, we agreed to meet their standards and to provide things like additional training for all of our staff. It actually increases the level of training from 18 hours annually to 40. If we fail one of their audits, they can send back corrective action. If we fail a second audit, they simply can end their MOU with us.
In terms of the state, because we're providing billions of dollars.
The agreement between the American Correctional Association and the department could be ceased because we fail to meet their standards.
Okay. Then can you give me just when you have complaints, you said those complaints are filed and then there's what happens after they are filed? Do you have information so that I just want to look at the percentage or the number of times that you agree with the inmate as opposed to, is it 10% of the time, 5%, 50%?
We would have to look into that.
Yeah, I'd like to know that as opposed to having the complaints and saying, well, it's dismissed, it's this, it's that. I know that it's difficult when we talk about an agency like that having oversight, but I agree with the bill. I'm going to support the bill because of personal knowledge and all else, because we all want to see it become better. And I don't know if I don't think it will be, and you can help me with this. Here's my question. Will it be some hardship or cause a disruption to your service, to what you do if we pass this bill? What's the issue if we do that?
So the issue that the department is concerned about is there is a definition of an ombudsman. An ombudsman is an advocate on behalf of the incarcerated individual. If you look at the conditions of the bill or what's being proposed in the bill, it seems to go beyond the scope of what an ombuds is. I also would like to indicate in my testimony, I spoke about OPEGA, which is a newly established office that is auditing, and they're under the Department of Legislative Services. They were established in 2019. COVID came in 2020. It, of course, impacted the ability to do audits, but we've already been audited twice by OPEGA, and they do a very deep audit when they come in and do it. They have audited the Division of Parole and Probation, and we did receive responses from that. And I believe that's public. If not, I believe the report is public, but I don't have it with me. I could get it to you.
Okay. And then my last question. Thank you, Mr. Chairman, for your patience. Out of those reports, I'm sure that, and I'm really interested in saying, thank you, encouraging you for those things that were positive. What happens, and are there often concerns, negative things in those reports of things you have to fix?
I would have to send the report to you. I did not get a chance to review the reports that were out before we came over.
Thank you all very much for hearing. I appreciate it. Thank you, Mr. Chairman.
Thanks, thank you very much. Senator, I was curious about this too, like the Maryland Correctional Association, like you said that if you don't, they'll terminate your MOU or your agreement.
It's the American Correctional Association. They're a national body.
Yes.
Yes.
So I guess, I'm not familiar. So just wondering why, as a state senator representing my constituents, do I care if you lose your MOU with that?
I understand why you wouldn't care about the MOU.
No, yeah. I mean,
okay.
Yeah.
So at the state level, I can understand that. But when it comes to accreditation and boards and affiliations that can do that accreditation, they set national standards that apply to all.
So it's an accreditation that you would have.
Yes.
Okay, got it. There's certain standards and expectations that fit with that. I mean, I get it. All right.
All right.
So no further questions. Thank you very much. Thanks. All right, Ms. Pruitt, you're up.
Good afternoon. My name is Lauren Pruitt, and I am the Legal Director of Free State Justice. We provide legal services to LGBTQIA+ Marylanders. I'm here today in support of Senate Bill 87. This type of direct and independent oversight will directly impact our most vulnerable clients, those who are incarcerated. While statistics about criminal justice and LGBTQIA+ people in general are lacking, we know that our community members are disproportionately likely to come into contact with the correctional system, particularly our youth and transgender individuals. We receive regular requests from family members and friends looking for assistance navigating the bureaucracies of DPSCS. Complaints such as the lack of access to basic health care, prescriptions, improper and unsafe housing, sexual harassment, sexual assault, extended periods of solitary confinement, and fear of retaliation and abuse if they attempt to voice those concerns. Getting assistance through the court takes time and money, and going through DPSCS requires them to submit a complaint to the very same officers for which they are reporting violations of regulations and/or constitutional rights. The Ombudsman, a neutral third party, will allow the reporting to be free from retaliation or coercion, can ascertain systemic problems, and can expeditiously implement solutions. This could affect positive change that results in an overall reduction of the complaints, as opposed to the limited effects of the case-by-case grievance process currently used. Similarly, futile calls made to hotlines typically do not receive a response, and the caller is not made aware of whether issues are being investigated or resolved. This is in stark contrast to the reporting and notification requirements proposed in this bill. Due to the investigative and subpoena powers, we envision a vigorous oversight process resulting in decreased violations and a more positive rehabilitative environment. We are confident the office will create a heightened awareness of the condition confinements experienced by LGBTQIA+ populations and take corrective actions desperately needed. And I'm not speaking to you today just as a civil rights attorney, but also as a former Maryland corrections officer, and I've seen the corruption, harassment, abuse, and systemic dysfunctions. And so for these reasons, Free State Justice urges a favorable report on Senate Bill 87. Thank you.
Excellent. Thank you very much. All right. It looks like I missed a witness. Is it Carolyn Carter? Did I miss Carolyn Carter?
Thank you. Good afternoon. I'm Carolyn Marie Carter. From 1987 to 2020, I served as a social worker and social work regional supervisor in the Maryland Department of Public Safety and Correctional Services. During those 33 years, I observed the extreme challenges facing those living and working in Maryland's prison system. I also observed people who use their position to violate the rights of others, as well as the infringement of organized criminal gangs, which increased drastically over the years. The COVID pandemic brought many restrictions that unfortunately increased the tendency of some staff to shirk responsibility. Over the years, I encountered prison system administrators, officers, residents, and non-custody staff in various roles. Many of these individuals wanted to do what needed to be done to keep the facility safe, perform their work, do their time, and go home safely. However, the very nature of the system creates opportunities for people with illegal or inhumane practices to operate with little or no restriction or consequence. Accountability is virtually meaningless when only people within the system have responsibility for auditing and reporting on the state of operations. Aside on that, the ACA audits are very superficial. I've witnessed them. They get paid to have prisons in their system, and so they don't do a very thorough job. Self-preservation prevents people from reporting crimes and negligence and truthfully reporting the problems. This is why I urge you to report favorably to establish the Correctional Ombudsman in the Office of the Attorney General. Thank you.
All right, thank you very much. All right, with that, that'll conclude the testimony and the hearing for Senate Bill 87. We'll now move on to Senate Bill 98 with Senator Hedelman. Senator Hedelman, you're up.
Thank you very much, Mr. Chairman, members of the committee. My name is Shelley Hedelman, Senator from District 11.
And I am here before you today on Senate Bill 98, which would reform our geriatric and medical parole system. You will hear from individuals today who have experienced and personally witnessed why our medical and geriatric parole systems are incredibly flawed and in need of fixing. Last year, this committee held a hearing on this bill, which was in somewhat of a different posture than it is now. And last year in this hearing and in this committee, a longtime and well-respected chair of the Maryland Parole Commission, David Blumberg, declared our system of medical and geriatric parole unworkable. And I'm sorry to say he had a serious family medical issue to address today and couldn't be with us. And unfortunately, he had sent David Law, who was also supposed to be with us today. And I think we should all take a couple minutes and say a little prayer for David because he is facing a medical emergency right now. And we're very pleased that that Dr. Jennifer Beskett is going to stand in and speak for both Davids today, representing the Parole Commission. So why is the system broken? The medical parole system only provides, the prison healthcare provider only provides scant information that doesn't really demonstrate the person who is incarcerated's full health condition right now. Commissioners are provided an outdated and inefficient Karnofsky score, and that was meant to measure cancer patients and actually doesn't effectively describe a person's physical impairments and limitations. Prisons are ill-equipped to provide medical care to individuals with very serious illnesses and conditions, as Professor Meadows described earlier on the other bill. So how will this bill change this? It will streamline the process for getting an independent medical evaluation, and it puts that medical evaluation on an equal weight with an assessment that is provided by DPSCS. It also provides an opportunity for those who are sickest, who reside in the infirmary or in and outside hospital, or who frequent these institutions often, with the right to request an in-person hearing. And it raises the standards by which medical parole will be assessed and brings them into line with nationally recognized standards and clarifies and specifies what physical and medical limitations are to be assessed. It balances the very serious medical needs of the individual with public safety. Now, with regard to the geriatric parole system, the bill fixes a quirk in current law that allows geriatric parole only to offenders who have committed multiple violent offenses and who are not otherwise parole eligible. Right now, there are under 10 individuals who might qualify for a geriatric parole in its current construct. You must be, under the bill, you must be 60 years old and have served for at least 15 years, not be a registered sex offender. You will be permitted to have a parole hearing every 2 years once you hit the age of 60. Maryland has had, we've piloted this in effect with the Unger decision a couple of years ago. These older inmates whose average age was 64 years and who had served an average of 40 years behind bars were released by a court ruling. And this demonstrates, and they have been studied and followed in the interim years, and it demonstrates that as individuals age, the risk to public safety is minimal. In other words, most people age out of criminal behavior. I want to reiterate what I began with. Our geriatric and medical parole systems are broken. A national criminal justice organization that you'll hear from in a little while recently gave Maryland an F score for its unworkability. We have worked diligently over the last year and respectfully with the department, with the Parole Commission, with advocates. Not everyone got what they wanted in this bill, but this bill is a good piece of legislation that represents a consensus for how best we can provide a humane and just and safe medical and geriatric parole system that will reflect best practices. So I want to thank everyone and thank the department and thank all stakeholders for really working hard over this past year and for coming up with this product. And I urge a favorable report. Thank you.
Good afternoon, everyone. I'm Shakina Braveheart, Advocacy Associate with the Justice Policy Institute. According to JPI's forthcoming comprehensive report on the Maryland parole system, 6% of the Maryland parole prison population, or 3,324 individuals, are over the age of 50. Additionally, Maryland has 2,341 people serving life sentences, suggesting that the aging population will continue to grow. A 2019 JPI report found that nearly 8 in 10 of these individuals serving the longest prison terms are Black. In our state, parole grant rates decline with age and decline as time served increases. Those 25 years of age and under report a grant rate of 37%. The rate increases to 43% for people between the ages of 31 and 35. Then it steadily declines as individuals age. People over 60 are paroled at a rate of 28%. This runs counter to everything we know about trends in offending. By age 50, most people have outlived their years of likely committing crime. Arrest rates drop to around 2% at age 50 and are almost at 0% at age 66. Older prisoners pose low risk to public safety due to their general physical deterioration and low propensity for recidivism. Medical parole programs should be open to non-terminal patients over 50 who have health conditions that render them unlikely to pose safety risk. Senator Hellerman talked about the Unger case, where 2012 case where over 200 long sentence individuals were released. Their cohort is about average age 64, and they have a 3% recidivism rate to this day. This shows that we can release without a major risk to public safety, of course, but it also shows that release can be an investment in public safety as many Ungers are shifting the trajectory of youth in their communities. While Maryland law has a geriatric parole provision specifically intended to benefit people over 60, we know it doesn't work. Senator Hellerman talked about that as well. Without substantial reforms, the aging and ailing population will continue to grow, and prisons are ill-equipped to downright hostile for those suffering from chronic or terminal illnesses. Please issue a favorable report on Senate Bill 98. Thank you.
Good afternoon again. Lila Meadows with the University of Maryland School of Law, where again, for a number of years, I've had the privilege of representing men and women in the parole process, including medical parole. I'm happy to take questions about any specific provisions of the bill and what that would look like in practice. I think Senator Hedelman did a really nice job of outlining them. What I want to emphasize is that this bill doesn't create new mechanisms for release. All we're doing here is fixing systems that this body has already adopted so that they work for some of the sickest, most vulnerable people in the Department of Corrections. You're actually not entitled to counsel in parole. Very few people in parole proceedings have a lawyer. And so this is a system that has to be able to work for people who are navigating it on their own, for people who have a mother who's working to secure their release, but doesn't have the benefit of an attorney. I want to encourage everyone. The Baltimore Banner ran a piece on January 30th, which I think was circulated to you, about the failures of Maryland's medical and geriatric parole programs. It profiles the case of Donald Brown, who I had the privilege of representing in his final 6 weeks of life. Donald Brown would not have been released, but not for having an attorney. And there are too many men and women who can't make this system work for themselves as it stands. And so again, this bill is not revolutionary. It doesn't do anything that this body hasn't already intended to do. It defines key terms and makes the system workable for people who unfortunately have to navigate it alone. And for that reason, I ask you to issue a favorable report.
Good afternoon, everyone. The reason why I'm asking you all to issue a favorable report is because my lived experience. My name is
for the record, what is your name?
I was going to say my name is Willie Hamilton, and my lived experience is that I just served 30 years, 110 days of incarceration, and what I've seen of men deteriorating in prison who were not sentenced to life or death because of medical conditions that cannot be adequately treated is horrible. I currently work for a prison advocacy organization who I'm trying to advocate for a guy who has blood diseases. He has deteriorated heart that he has to wear a life vest. And the medical staff said there's nothing else that they can do for him. His health is so deteriorated that he can't even go to court. So I urge you all to support this bill, issue a favorable opinion. That's it. Thank you.
Are you representing Maryland prisoners' rights?
No.
You're not? Okay.
Good afternoon, Mr. Chairman and members of the committee, or Mr. Chairman substitute for the moment. My name is Rachel Kamens, and I'm here on behalf of the Maryland Public Defender's Office asking for a favorable report on Senate Bill 98. As an attorney who has filed many applications for medical parole, I'm going to be focusing on that language in the bill and three particular features of the bill. First, the bill expands eligibility, but it does so in a way that's both humane and fiscally prudent. Contrary to the opposition testimony that we heard last week in the House, Senate Bill 98 does require people, in order to be eligible for parole, to be physically incapacitated or chronically debilitated. And that determination has to be made by a medical professional, or they have to be terminally ill with medical needs that are best met outside in the community rather in the pathetic prison health system, or they have to be physically incapable of posing a danger to society. Suffice it to say, these are very, very sick people who cannot harm us out in society. Senate Bill 98 also allows for a meeting to take place between the commission and the incarcerated person. This shouldn't really be a very controversial point. For the commission to make an informed and reasoned decision, it seems to make intuitive sense that a meeting take place where the commission can get to know the individual and see firsthand the individual's circumstances and medical conditions. This definitely creates a more comprehensive picture of the person and his situation. Senate Bill 98 allows, as was referenced previously, for an independent in-person medical examination. I think this is also not controversial. Rather than just relying on existing medical information in a paper file, this bill allows for an actual dynamic medical assessment of the inmate and reveals a lot more information. Lots more to say, but I strongly urge on behalf of the Public Defender's Office a favorable report on Senate Bill 98. Thank you.
Are there any questions from? All right, thank you all. Let's see. Is someone from the Maryland Prisoners' Rights?
Yes.
All right, that's you. Miss Moyd. Miss Egan. Mr. Sexton. And Miss Gill. All right, and I ask before you speak, or once you speak, please share with your name for the record.
Sure.
You may begin.
Okay, well, thank you, honorable members of the committee. My name is Chris Morton. I'm representing the Maryland Prisoners' Rights Coalition, an organization working to improve the conditions of confinement for the incarcerated in Maryland correctional facilities. Over many years, we have identified many risks to prisoners' health and safety consistently. The worst of these is the availability and quality of healthcare services provided in Maryland correctional facilities. As part of our intake process, we ask clients to complete a request for information form, which is submitted to DSPCS for our clients' medical records. We have found that DSPCS lack proper medical records and clear policies. Our interrogatories receive vague responses. Further, we have discovered egregious practices and an inadequate standard of care. Our clients return home from incarceration and often have a myriad of healthcare problems requiring specialized care, sometimes with catastrophic consequences that they would not have had, that they would not have suffered if cared for adequately in prison. We have found that the healthcare provided by DSPCS's vendor YesCare, formerly called Horizon, is self-regulated with no compliance standards. And they have been cited in many states for failing to uphold their contract of care and have had those contracts terminated. In Maryland, Yes Care, when they were called Corizon, won the healthcare vendor contract for $680 million, but that falls $132 million short of providing adequate care for the contract period. Providing those with terminal and debilitating conditions in Maryland correctional institutions with greater opportunity for parole is an important first step in correcting Maryland's long history of healthcare neglect. It allows for greater opportunities for more access to proper care for the incarcerated. This legislation is vital to the process of reforming the accessibility of quality care in Maryland correctional facilities. This is a legal, social, economic, and moral problem. For these reasons, we implore you to unanimously return a favorable report on Senate Bill 98. Thank you.
Thank you.
Good afternoon. I stand before you again. My name is Olinda Moy, and I am here on behalf of the Maryland Alliance for Justice Reform. As an attorney who has practiced before the U.S. Parole Commission, the Maryland Parole Commission, the D.C. Parole Board, I don't always agree with the decisions made by the parole agencies, but I do know that for people who are seeking medical and geriatric release, that it is often the only viable avenue that they have access to. As indicated in my written testimony, I mentioned that this bill, as it relates to the geriatric portion of the bill, will just allow the Maryland Parole Commission to consider the totality of the circumstances, including the age of the individual with other parole factors. People do age out of criminality. The Unger people who were released under the Unger decision, which was previously mentioned, are a perfect example of that. Age does reduce recidivism, and as indicated in the report by JPI, there are somewhere around 6.4% of individuals who are behind bars who are over 50. So when I graduated from law school, one of the first jobs that I had was with the NAACP. We opened the first NAACP chapter behind the walls at the Maryland State Penitentiary, where I met many of the men who are still serving life sentences. So I know I'm telling my age, but I am 60 years old, and I can say that the men and women who have been behind bars for the time span that I have done this work, their 60 years old looks very different than my 60 years old. And so I implore you to pass this bill on behalf of the individuals who need to have an opportunity, a meaningful opportunity for release. Thank you.
Good afternoon. My name is Mary Price. I'm here on behalf of FAM. Molly Gill sent my testimony, but it's my testimony that you have. Sorry. On behalf of FAM, we're a national sentencing and corrections reform organization. For more than 2 decades, I have conducted research and evaluated programs and advanced measures that allow for the safe release of people whose continued incarceration no longer meets the purposes of punishment. At a minimum, that should include people who are dying, people who are advanced in years, and people who are so chronically debilitated that they cannot offend, they're too compromised to benefit from rehabilitation, and they may be too impaired to even be aware that they're being punished. I conduct and publish comprehensive reviews of every state compassionate release program in the nation. And we describe everything from eligibility to criteria to who gets to apply for compassionate release to data reporting and decision-making standards. Based on that research, we published the report card that Senator Hedelman referred to earlier that ranked Maryland the 3rd from the bottom in all states. Maryland was the 3rd worst program with compassionate release in the entire nation, and that is included in my testimony. SB 98 contains sorely needed reforms. Among other things, it would revise and standardize eligibility criteria, involve agencies to make conforming changes to rules and regulations. You know the devil's in the details when it comes to regulations. Require data reporting that you will need to have the information that you need to have to know that the programs are working as you intended them to work. And of course, it would build out geriatric parole. Of the many very good features of this bill that Senator Hedelman and others referred to, one of the most important ones is its reform of eligibility criteria. including definitions of chronic debilitation and incapacitation that mirror a number of those from around the country that right now are not a part of the current legislation. And I have examples from Alabama and Georgia of ones that would be mirrored in this bill. My time's up. I hope that you send this with a favorable report. Thank you so much.
Good afternoon, members of the committee. My name is Jay Sexton, and I'm a University of Maryland law student practicing with the Gender Violence Clinic, which represents criminalized survivors of gender-based violence. Our clinic enthusiastically supports the reforms in SB 98, and we urge you to favorably report this bill. Now, it should come as no surprise that prisons are not adequately equipped to handle the needs of the elderly or the infirm. And I would like to illustrate that point with the story of a client from our clinic. Over the years that this person has been incarcerated, their health has deteriorated rapidly. They suffer from several chronic conditions, and due to inadequate prison health care, these conditions have only worsened. Today, this person is wheelchair bound and almost entirely blind. To make matters worse, the prison is not handicap accessible, which means this individual spends most of their day confined to their room due to fear of injury. On top of the isolation they face, this individual requires around-the-clock assistance with daily self-care, as they are incapable of independently eating, bathing, dressing, or going to the restroom. This prison, like any prison, is not equipped with medical professionals who can handle this level of attention. The result is that this particular person receives most of their assistance from other incarcerated individuals. This person needs the assistance of trained medical professionals outside of the prison walls, not the assistance of a rotating group of cellmates. While the Parole Commission has recognized the merits of this individual's medical parole request, the governor denied release, and unfortunately, this individual continues to struggle to navigate the prison environment today. This person is chronically and permanently so debilitated so as to be incapable of posing a current or future threat to public safety. If the point of prison is rehabilitative, this person has already been rehabilitated and is incapable of participating in further activities towards that goal. If the point of prison is incapacitation, this person is already incapacitated by their medical condition. To conclude, this bill would not open the floodgates. It simply gives the Parole Commission the necessary tools to make a well-informed decision concerning parole for geriatric and sick incarcerated individuals. Thank you.
Ms. Gill, did you say that Ms. Egan had submitted your testimony, or did I hear you correctly?
Yeah, my name's Mary Price. The testimony was submitted by Ms. Gill, I think through her.
Okay.
I don't know how it's done.
You're Ms. Price.
Yeah, I'm Ms. Price, sorry.
All right, thank you.
You bet.
And I see no questions. Oh, we do have a question.
The committee, so I'm just a little unfamiliar, but having read what I think the current law is, and I support the concept of what you're doing, but just to make it clear, doesn't make sense to use these categories and then require all of them to say and no longer poses a danger to society. I mean, the way it's drafted, that doesn't seem entirely clear to me. In one of the people are chronically debilitated or incapacitated. And I think you could assume that's true, but we could make it clear just from anybody reading the statute would understand, or even when this suffers a terminal illness, no longer poses a danger. And then the third category is physically incapable of presenting a danger to society. So I'm wondering, because I know the existing law requires that particular element in all of the medical early releases. So is there I'm just talking about clarity in the drafting, because I think that's your intent, right? That you would want people who are very sick, but also anybody that, make sure that anybody released could no longer be a danger to society. Does that make sense?
Yeah, that's the point of it. It's not like a mandatory release situation. All cases will still go in front of the Maryland Parole Commission. So they would still make that determination.
Right,
It's just changes, specifically medical changes, the criteria for that as far as the evaluation medically. It's more about meant to be more holistic. I don't know if they've actually decided through the regulatory process and what they're going to do, but
arguing you improving the system.
Right.
I'm just saying that it would make sense to me from a drafting that if you're going to put these categories in for all of them, you would also have, as opposed to having only one of them, and no longer poses a danger to society. I think that's just clearer. And that's sort of what the law is. I get the other problems with how it's,
No, that's,
happening, being used and all that, which I support completely.
no, it's super important to get the public safety screen built right in, and it's really in the very beginning of the bill. Each hearing examiner and commissioner determining whether an inmate is suitable parole has to consider a number of circumstances, and two of them are and now on page 2, whether taking into account the totality of the circumstances, if released on parole, the person will not recidivate. And then right after that, they also have to consider public safety. So that's right in front,
I'm sorry,
front and
what
center.
lines are you reading from?
Sorry, I'm on page 2.
I got that. 10 through 15.
14 through 15.
14.
Well, in totality, it's 10 through 15. So there are two different public safety screens written right into the beginning of the bill. Yeah.
Now, again, being new is not recidivate.
Not
identical-
reoffend.
Is that identical to no longer poses a danger to society?
Not recidivate means, I think, not reoffending, not committing a new crime or a new offense.
Right, but.
And then public,
You could commit a crime and not, I think, I just don't know if they're identical.
both of these, no, they're not, I think.
Right,
They
they're
could be,
not.
well, sorry, of course they could be, depending on the nature of the crime. But these are two separate considerations that the commissioners have to take into account: recidivism risk and public safety risk. And I should defer to somebody else who's, okay.
Okay, I guess it's the way it's draft, I see.
Yeah.
Whether the release of the inmate on parole is compatible with public
Precisely.
safety. All right,
Precisely.
thank you.
And
very much.
you've given the parole commission such good direction in this bill, so many, so much good guidance, so many guardrails. And it ultimately is obviously the decision based on whether or not the person meets the criteria, but also whether public safety would be implicated.
Okay, now I understand it. Thank you.
All right, seeing no further questions for the committee, thank you all very much. Elise. All right, is Elise Desiderio and you are favorable, and then we'll switch over to the opposition panel after you all finish.
Good afternoon, all. I am Elise Desiderio, a post-conviction attorney with the Office of the Public Defender. I'll be talking about the geriatric parole aspect of SB 98, and we urge a favorable report for 3 reasons. First, seniors are far less likely to reoffend after release than younger people. Second, incarcerating seniors is more expensive than incarcerating younger people. And 3, seniors have particular health and safety concerns, even beyond the medical parole aspect, that living in prison makes worse. I go into much more detail about those 3 points in my written submission, which I urge you to review. But here are the other nuts and bolts that I want to remind the committee of. As was stated before by Ms. Meadows, this bill makes workable this body's already stated intent. The bill doesn't remove public safety considerations because 7305, the general parole provision, remains intact. And that provision requires the commission to consider whether there is a reasonable probability that the person will recidivate if released, and whether release is compatible with public safety. The bill requires a person to be over 60, have served at least 15 years already, and not be registered or eligible for registration as a sex offender. It moves the geriatric parole provision to the correctional services section rather than as an unworkable piece in the crimes of violence statute under the current rules, as Senator Hedelman described, maybe 10 people might be eligible. Then it's up to the Parole Commission to determine suitability at regular intervals every 2 years, giving weight to the person's age and what that age means for a person's recidivism rate. This bill is not a guarantee of release for our incarcerated seniors, but it does construct a humane and thoughtful path towards that possibility for our most vulnerable people in prison. This bill expands options for parole release in a modest, workable way, and OPD urges a favorable report. Thank you.
I think you were calling Ashley Egan. I'm here representing her again. She is our staff person for the Unitarian Universalist Legislative Ministry. So I am Karen Clark. I am lead chair for the criminal justice issues. And I'm here to speak in favor of SB 98. So let's see, the bill upholds one of our basic beliefs to honor the inherent dignity and worth of every person. And our prison system, its purpose is twofold: to ensure a safe environment, as we've been saying, in which our communities can function and thrive, and to remove people who are illegally disrupting this environment and who are a threat to others. Our aging population is not characterized by these issues. Most are, as we've said, 60 years plus. They have characterized by lengthy prison sentences that extends their stay way beyond the age range in which crimes are less likely to occur. And has been mentioned, our famous Maryland Unger case, where the average age release, as was said, 64, their recidivism rate was only 3%, compared to 40% of younger offenders who are after 3 years on the outside. Upon release, our elderly are in the correctional system under a management of the parole. So no longer a dangerous threat. Our faith calls for compassionate release to process our geriatric citizens. And last year, the JPI, the Justice Policy Institute, published a policy brief evaluating the geriatric and medical parole process. Many of the noted faults in this brief are addressed in this bill. I won't go through them all, and one has been mentioned about needing currently there's no in-person medical examination required to determine the state of a person's health. It is done by a professional response to medical records. Is that it? Okay. All right, we ask for a favorable report. Thank you.
Good afternoon again, Jennifer Beska with Department of Public Safety and Correctional Services. I'm here for David Law, who should be signed up. I just wanted to say that the Maryland Parole Commission did work with sponsor Senator Hedelman and is in agreement with the language that's in front of you.
Thank you very much, Ms. Beska. Seeing no questions from the committee, thank you both very much. All right, now that concludes testimony for the proponents of the bill. We'll now switch over to the opposition panel. And if Mr. Katzif is here. You're all coming up. Mr. Kroll. Lauren, go first. Lauren Lipscomb.
Thank you. Good afternoon, Mr. Chair and members of the committee. My name is Lauren Lipscomb, and I'm a prosecutor with the Baltimore City State's Attorney's Office. I'm here testifying on behalf of the Maryland State's Attorneys Association. My testimony is presented to draw attention to the need for exceptions for crimes of violence and to prevent the elimination of the physical incapability requirement, which in fact, there is a loophole where the physical incapability requirement is not in fact required. There were two concerning cases in my career as a prosecutor, which involved the current medical parole system. First, we had a defendant who had been charged with sex abuse minor, though the defendant should have been in DOC on another sex abuse minor. Further review revealed that the defendant had in fact been released on medical parole. Secondly, we had a defendant who had beaten a store owner unconscious with a bar stool. I looked into why the defendant was on the street, again, medical parole. Any victim harmed by violence while supervised by the state is too many. I raise a few main concerns in bulleted form. Physical capability to do harm to another must remain a required consideration. Without it, there's a large hole for fraudsters to run through to secure release and continue criminality. Proposed age for geriatric consideration is age 60. 60 is a below retirement age that typically involves persons physically capable of committing crimes of violence. It is not the highest age group prevalence of what we see, but violence committed by this age group is not entirely absent. The types of convicted offenses matter. It is critical that the type of offense and the attendant specific facts inform eligibility considerations. Generally, a sentence of 15 years DOC or more served is the result of a murder or another crime of violence. Any parole effectively reduces time served on a sentence, and the considerations on whether to grant parole are almost exclusively predictive in nature. Ensuring as many safeguards, such as using the Karnofsky score to review physical functionality in cancer patients, is key to making a better predictive assessment to protect our community from violent offenders. Thank you, Mr. Chair and members of the committee.
Chairman, members of the committee, good afternoon, or should I say good evening. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland and the Executive Director of Maryland State's Attorneys Association. I've been prosecuting cases since 1984. To my good friend, Senator Muse, I will tell you that this bill needed to be updated, and we agree with that. And we're glad. But to Senator Hedelman, we were never contacted at all to give our opinion on this bill at all. To my senator, please contact us. We want to give our opinion on it. And our opinion would have been the following. 2 years is not fair to the victims and witnesses to come back every 2 years on medical parole. Should be longer than that. It's really not fair to the victims and witnesses. And are they going to be contacted? Because on medical parole, many times they are not contacted, and there's no guarantee they would. So to protect victims and witnesses, we asked for a longer stint between parole hearings for anyone who's asking for geriatric or medical parole. Ms. Lipscomb did go over a 15-year sentence. That's for the most serious crimes, And you got to take that into consideration. We're saying this needs to be updated, but remember, as Mr. Cassis will tell you, and Ms. Lipscomb tell you, these are the most serious crimes they are. So in conclusion, as the Senate Bill 98, we incorporate Ms. Lipscomb and Mr. Cassis' testimony and say 2 years is not enough. 15 years is a major crime that's been committed. But I will tell Senator Hedelman what I told Delegate Moon. I think we can work together and come to the conclusion on this bill, and I look forward to it. But at this time, we're asking for an unfavorable report as the Senate Bill 98. Thank you.
Mr. Chairman, members of the committee, my name is William Katzeff. I'm an Assistant State's Attorney for Arundel County, here too on behalf of the Maryland State's Attorneys Association in opposition to Senate Bill 98. We're concerned about the fact that this would seem to significantly broaden the class of individuals who would be who could potentially have their sentence reduced by a medical or geriatric parole. This would seemingly include those who are serving a sentence of life without the possibility of parole, which is available for those people who have been convicted of first-degree murder and in some instances first-degree rape. I don't think those people should ever be released from incarceration. Clearly, if you look at from the standpoint of the victims were of the opinion that when that person was sentenced to life without the possibility of parole. Okay, that there would never have to be a situation where they would be called upon to have to attend a parole hearing with the possibility that the person responsible for the death of a loved one is eligible for parole simply because of his medical condition or the fact that he's reached a certain age. I would also remind some people who may harken back to a case in Baltimore County many years ago. It was an incident that occurred at the Warren House where two people were shot. They were shot to death. The defendants were Anthony Grattison, who was the person that basically took out the contract, and the shooter Vernon Evans. They were originally given the death penalty. At some point later on, it was converted to life without the possibility of parole. Neither one of those people should ever see the outside of a prison. Anthony Grattison is around 70 years old now. Given what he did back in 1981 or 82, same would apply to Vernon Evans. They should never, ever see the outside of a prison. I would certainly ask you to give the bill an unfavorable report.
Excellent. Thank you very much. All right.
79? Okay, I thought it was.
Sure, yeah.
Well, at least it was 40 years ago.
Senator Muse.
Thank you very much, and I appreciate again you being here, and I hear you, and I heard you again. The law says that there are times when, or the law does not say that a murder or rapist can never see the light. I realize that's your opinion, and I know you've seen some things in your day that really hit you. This person should never see the light of day. I fundamentally disagree with that. But in the bill, basically what it's saying is that the person is chronically debilitated, incapacitated, suffers from an illness, and likely to die within 6 months. Rendered physically incapable of presenting a danger to society by physical or mental health condition, disease, or syndrome, etc. Pretty much it's saying you're going to die, and they can either die at our expense for the next 6 months and we try to take care of them, or they're going home to die. In my position, I have to also look at compassion with law. I'm not just where you are, just law, let them go, they're worthless, to heck with them. I have to look at it from the other perspective, and because the law allows it, I can never take your position, never. That's why we have a parole board. That's why we've had this in place, even as we're trying to perfect it. But I don't think it should ever be, and I'll stop with this and just ask a question that I asked yesterday. Is there anyone of the 10, they talked about 10 persons this law would affect? Any of them you think sick enough to ever go home, or you just think they should all die in jail no matter what?
Well, you're, Senator Muse, if you're asking with regards to Vernon Evans or Anthony Grandison, they should die they should die where they are currently located. Okay.
Okay.
I think that
I don't agree, but
the family members of the people that were murdered, they're no longer around, unfortunately. Those two guys have survived virtually everyone else associated with the case. Okay. There are and it just seems to me that the legislature some years ago, particularly as an alternative to the death penalty, created the sentence of life without parole, with the understanding that juries should be, or judges should be able to make the determination as to whether the death penalty should be imposed or there should be life without parole. Life without parole was with life without the possibility of parole. That was a sentencing option. It was exercised in these cases. And I think that the fact that it was exercised, they benefited in some instances by not getting the death penalty, that the consequences should be that they remain in prison.
You and I have always, and we agree on so much more, but there's one thing we'll not agree on.
Well, we always agree, at least we were respectfully, right?
That's right.
Disagree respectfully.
That's right. Thank you very much, and thank you for.
Isn't that so nice? I appreciate the love there. I appreciate that. All right, Senator James.
Trying to get caught up here. So this bill doesn't just allow for a new system for people getting released with these incapacitating or terminal conditions. This bill also changes fundamentally the law and opens up medical parole for people that are otherwise ineligible at the time they were sentenced in sex offenses. Is that what you're saying?
It's not. So the bill only applies to people that are eligible for parole.
So I just would like to better understand the question, and I have my phone here because I have the bill on my phone. So that's what I'm.
I thought he said, sorry, my colleague's testimony says current law enables anyone to apply for medical parole except those sentenced for sex offenses and those ineligible for parole. I got the sense from you all that you're saying that the bill would change that in the sense that people that are not eligible parole would be under this new law. Is that correct? You know, people life without possibility of parole and maybe some other situations. Is that?
It does appear that way. And that's what Mr. Katzif was really testifying about was that category of individuals. It doesn't seem to preclude those individuals who were sentenced to life without parole. Is that, am I correct?
And the same with sex offenders.
No, I'm trying to understand the question as well as.
Yes.
Oh,
That's what I heard.
The Senator, here, just let's
Sorry.
keep it. You had senators directing her question to the panelist, and then
Yeah.
let's keep it there. Side commentary, please, you know, just remain respectful, have some decorum. So Senator, yeah, again, if you could, I think for medical clear, geriatric, maybe not so clear. Right, so
Right.
I think, so just if you just hone in on page 7,
yes.
okay,
Okay.
that's where it's not so clear. And then you can focus in on that and we can keep the discussion going there.
Well. So my question is, does a bill allow for people to be paroled under this new system? For people who are if we don't pass this bill, would not be eligible for parole?
I would have to defer.
That's what I thought I heard
believe that that's.
you testified to, and that's what I'm trying to understand.
So
You can get back. You know, I think it's a good question that I'd like to have answered. And
I would defer to my the other panelists because that was not part of the bill that I was focused in on.
I'll
And
get
so-
back to you on it, Senator, and we'll have a nice discussion on it.
Right, and then, ma'am,
Yes.
one thing
yes.
you spoke quickly and I'm new,
Sure.
so I was trying to keep up with you, but I thought what you were worried about was something I was worried about, which is just making sure that whoever we do release is in no way a danger
Yes.
to society. And I got I'll have to get your testimony and read it, but I got the sense that you were pushing back and saying you too were worried that people could be released under this bill that could pose a danger to society. And then, of course, that gentleman brought up. So
That's correct. So where I was concerned was actually on page 3
Okay.
of the bill. When you look at, even taking into account the definitions that we see on page 2 and page 3, where chronically debilitated or incapacitated, as well as in that sections or subsections 1 and 2, even taking into account those definitions, when you go down and look at proposed language C, if you look there, it says an inmate, and it takes out the physical incapability part. An inmate may be released on medical parole at any time during the term of an inmate sentence without regard to the eligibility standards specified in 7301 of the subtitle. If a licensed medical professional has determined that the inmate, and there's a construction here that I'm concerned about. The construction would be, and of course, legally or and are pivotal words, right? So the construction of is chronically debilitated or incapacitated and requires medical management with healthcare needs that would be better met by community services. So I'm concerned about that particular construction, and that particular construction, from what I read, suggests that there is a possibility that physical incapability is not considered when you're using that construction. So I see a path, and that's my concern.
And
I see
that was my earlier question, but the response given to me, if you go to page 2.
Yes.
So I'd like your response to this. The response was, look at lines 13 and 15. You might want to look at the ones before and after, but basically the response to me was, look, we are protecting public safety. These people would no longer pose a danger because of the language. They're not able to recidivate, or and then secondly, whether you have to take into account whether the release of the inmate on parole is compatible with public safety. So the bill sponsors reply is that kind of language should, allay our worries that someone would pose a danger. What is your reply to that?
So my reply would be that it's not saying the same thing. My concern is that we're removing the language as to be physically incapable of presenting a danger to society and not replacing that language. Compatible with public safety does not mean physically incapable of, being physically incapable of committing a violent act against another human being.
And I tend to agree with you, but I'm not an expert and
Sure.
and so all I can say is, I think, Bill, if everyone agrees you don't want people out who pose a danger,
Right.
it would be very easy to amend this bill to make that crystal clear. All right, thank you,
Absolutely.
Mr. Chairman.
Thank you.
And thank you. As one who's co-sponsoring the bill, I think, again, we are about to have our first agreement of the year.
I look forward to it.
The bill was not intended to release people who fit the categories of rapist, murderer, and we will, and an amendment, if an amendment is done to that effect, and if that is in fact your objection to it, and it was, and in fact, if you read the sponsor's testimony, it says so right there, that this is not the intention of changing that. But if the wording is changed and you're happy with that, meaning life without parole, etc., this will not touch them at all. It leaves it as is. If we have that amendment and that amendment is put on the bill, would you agree to that? And if so, we're going to go out and celebrate. I'm just
Not with victims and witnesses coming back every 2 years, Senator.
no.
We're not going there, so I'm not agreeing.
No, it doesn't intend to change.
I'm looking at Senator Hedelman and saying, I'm looking forward with the opponents, with the proponents of working to get a better bill, which I think we can get a better bill. So I'm smiling. I said to Delegate Moon, he and I can't even agree on the date. So I'm saying we can't actually work this bill out, my opinion.
And I'm sure it will. And when it does, we're going to go celebrate our first of the year.
Senator, the major concern is the part that deals with geriatric, but that's all new language. The other part is existing language for the most part that's, significantly amended. And there's some issue with regards to the lifers without parole. But clearly the new language, I don't think that part dealing with geriatrics, I don't think excludes them.
And for the record, that's our private joke. I agree with him on minimum, both of them, respect and agree with you on many more than where we disagree. I just want things done right, and I think that we can work to get that done. Thank you very much, and thank you, thank you all. That's our private joke.
Excellent. Thank you all very much. Appreciate the dialogue. All right. Thank you. Thank you. So now we'll switch to the virtual witnesses. We have, is Stanley Mitchell here? Who's Stanley's not there? And yes.
Stanley's been trying to log in. He's actually trying to testify from his hospital bed. He's had bypass. He's having technical issues, but he didn't want you to know he was attempting to get into the game.
Excellent. Okay. We'll try to get him in if he's got the right link, but thank you for that. Thank you. And then is Raya is there? Okay.
Yeah, can you hear me?
Excellent. We can.
Wonderful.
Please go ahead.
Yes, thank you for this opportunity. My name is Raya El-Fadel Kurbeck. I'm speaking in favor of geriatric and medical parole on behalf of the incarcerated patients under my care as Chief of Geriatrics and Palliative Medicine at the University of Maryland School of Medicine in Baltimore, as well as Professor of Medicine. I have a duty to relieve suffering, uphold human dignity, and protect and care for patients based on an evidence-based clinical assessment. I have cared for dying prisoners. Our team across the medical center scrambled through administrative hurdles to fast-track compassionate release, but often we fail to ensure human dignity and unite inmates with their loved ones. No one deserves to die with their feet shackled to a bed, accompanied only by 2 fully armed police officers in the room. Compassionate release is often the most humane and ethical course of action for elders and terminally ill inmates. These individuals usually carry a low public safety risk a low rate of recidivism due to accelerated biological aging, advanced illness, and poor physical health. They could be released to the care of their loved ones or local community programs, including hospice, inpatient hospices. Incidentally, it would be at substantially less cost for Maryland taxpayers. Our seeming indifference to the healthcare needs of incarcerated persons is a violation of the 8th Amendment of the United States Constitution and is cited in Duval versus Hogan. Within the Maryland correctional health system, access to geriatric care for inmates is limited at best. The same is true for palliative medicine and hospice care. It simply doesn't exist. Appropriate access for care for inmates is both a moral obligation and a legal requirement. Thank you for allowing me the time to speak. I have also submitted written testimony for your consideration.
All right, thank you very much. Questions from the committee? Seeing none, that will conclude the testimony and the hearing for Senate Bill 98. Thank you very much, Senator Hedelman. We'll now hear from Senator West with Senate Bill 190.
Mr. Chairman, Mr. Vice Chairman, who's leaving the room, members of the committee, it's a pleasure to raise my voice, I think for the first time this afternoon, and to be able to present Senate Bill 190, which I believe will be a much shorter bill than the one we just heard. According to a September 28th, 2022 AP story, a woman incarcerated in the Washington County Jail in Hagerstown was left to give birth to her baby alone on the dirty concrete floor of her cell. Pregnant women represent a unique population for correctional facilities and require specialized care, especially if concurrent opioid use disorder is present. Senate Bill 190 requires substance use disorder screening to be provided at intake to pregnant women who are incarcerated. If the woman scores positive on the screening, the bill requires her to be referred immediately to a licensed behavioral health care provider and a reproductive health care provider. And if appropriate, the initiation or continuation of medication. Senate Bill 190 further provides that a pregnant woman who is receiving medication for opioid use disorder prior to incarceration must be provided the equivalent medication without a break in care once she's incarcerated. The bill explicitly states, however, that the woman has the right to decline or terminate treatment. Before a pregnant woman is released from prison, the bill states that she be provided with health insurance coverage, that she be referred to a qualified reproductive health care provider, and that she be referred to a community-based mental health and substance use professional for treatment and medication continuity. And finally, the bill provides that within 5 business days after her release, the woman's obstetric and behavioral health providers, after the woman gives her consent, would be provided with a complete copy of her medical records upon her release. So Senate Bill 190 will ensure that pregnant, incarcerated women receive the appropriate care to maintain a healthy pregnancy and the greater likelihood of a healthy birth. There is an amendment, which I hope everybody has in their packets, which I worked with representatives of the Department of Corrections to adopt. It contains the concerns they had with the original bill, and I feel comfortable recommending it as an amendment. And with that, I conclude my testimony. Thank you.
Excellent. Do you have so if we, who would you like to go first? So we get Kim Haven, Larry Polsky, Vanita Taylor,
Good afternoon, Mr. Chair, members of the committee. I'm back. This time, my name is still Kimberly Haven, but I'm the Executive Director of Reproductive Justice Inside. We are the only organization in the country that focuses on the entire reproductive lifespan of incarcerated individuals. We have convened, consulted, and worked with leading national experts and medical professionals to develop best practices for the care that we provide our incarcerated pregnant population. SB 190 is one of those best practices. Pregnant incarcerated individuals who are preparing for release lack the support upon reentry for their unique health needs. They must be afforded continuity of reproductive health care upon release, and there should be a relationship for this care in the jurisdiction they will return to. This continuity of care would help prevent adverse health outcomes as well as prevent unnecessary pregnancy complications. Currently, there is no consistent or comprehensive care coordination, and the transition time between release and accessing reproductive health care represents a high-risk period for these individuals. SB 190 will ensure that there is a clear process that will create a pathway that can lead to improved maternal health outcomes. It is good risk management for our state. Pregnant individuals have healthcare needs that are at best minimally met by our prisons. Many of these mothers have high-risk pregnancies due to the economic and social problems that led them to be incarcerated: poverty, lack of education, inadequate healthcare, and substance use. In a study published in 2017, it was reported that 80% of the people who were released without medical records. Now, let me pause and point out that we are not talking about hundreds of pregnant individuals coming in and out of our system. We don't. And this is a critical point, though. Those medical records would represent the tests that were done with results that were not shared with the individual. So when they go seek their care, they can't respond to what the results were. We recognize that the department has done some work in this area to address the concerns this issue. Okay, bottom line.
You're for the bill.
This is this is simply best practices. This would position Maryland as a leader again on how we provide pregnancy-related health care. It is just a simple codification. The department already maintains that they do this. Let's codify it.
Thank you.
Administrations change, leadership changes, best practices don't.
Thank you very much.
Thank you. I know that it was under 2 minutes when I practiced this at home.
Looks like a long day on top of a longer day. My name is Larry Polsky. I'm here on behalf of the Maryland Association of County Health Officers in support of SB 190. I'm also a board certified obstetrician with expertise in treating substance use disorders. I chose to specialize in OB because pregnancy motivates people to improve their health like no other time during their lives. A decade ago, when I shifted my career from practicing obstetrician to lead a local health department, the first new program that I created was a multidisciplinary effort to provide care for pregnant and postpartum women dealing with substance misuse. That included a partnership with our local detention facility. Over and over during the past 9 years, we've seen pregnant women who have struggled their entire adult lives with drug dependence, finally able to maintain sobriety with professional support. Postpartum, most of these women have continued with treatment, proven to be good mothers, and with ongoing support, have gone on to find employment or complete their education. The individuals impacted by this bill represent a medically high-risk population. When given the opportunity for proper treatment, we can see dramatic results. SB 190 will ensure that any pregnant woman with drug dependence who enters a correctional facility will have the opportunity to initiate timely and appropriate care in keeping with the recommendations of the American College of Obstetricians and Gynecologists. The reality is, if medical care isn't provided soon after an individual is incarcerated, both baby and mother's health are at increased risk. This bill will also accomplish two major statewide goals. It will ensure entry into care for those in rural areas where access to community care is more limited, and SB 190 will play a role in decreasing disparities in maternal mortality, particularly among African-American women. SB 190 has drawn bipartisan sponsorship because it closes important healthcare gaps regardless of your jurisdiction or political party. On behalf of the state's health officers, I ask for your support and welcome any questions. Thank you.
Hi, good afternoon. I'm Benita. Oh, it's almost evening. Benita Taylor from the Public Defender's Office. I represent for years, women who struggle with substance abuse and child welfare cases. I'm on the executive board of the Family Recovery Program in Baltimore City, which is has a transitional housing for women with substance abuse. I'm going to shift my testimony because I had someone with life experience, Ms. Martine Hughes, who was going to be here today, but she had a family emergency with a child, so she had to rush to her child's school for a meeting at 1 o'clock as opposed to being here. I believe she submitted her testimony, and she told me, she gave me permission to tell her story. And I will tell you that Ms. Hughes didn't suffer some substance abuse, but she was incarcerated when she had her next to the youngest child, who will be 6 years old in August. At the time that she had the child, she was shackled to the bed when she had delivery. Maryland has since been a leader and changed that law where we no longer shackle women to the bed when they deliver. Where are they gonna go in your middle of delivery? So that has been changed by Maryland. Maryland can become a leader again in really doing something that not all states are doing, which is to look at the unique needs of women that are different from men. They have unique needs because women give birth to children. And because of that, giving birth to children, we have medical needs. Ms. Hughes told me that not only was she shackled and unshackled and reshackled, but that she also was in solitary confinement afterwards because she had issues a part of her pregnancy. But what's more astonishing to her, and what she told me to ask that this bill definitely be passed, is that she received a bill for her delivery. A bill. Can you imagine that? She received a medical bill for delivery. And she says, I still don't know who do I contact to say, I don't have the funds to pay this bill. And why did I receive a bill for my pregnancy, my delivery? And importantly, what she also said is that she never received her medical records. She never received any assistance in getting medical assistance so that when she got out of jail, that she could immediately go to a doctor in the community, give her medical records and receive appropriate care. That didn't happen for Ms. Martine Hughes. And so we say that this bill recognizes the differences between women and men and pregnancy and substance abuse. And I will tell you that one of the biggest things that I see with women who are pregnant and who suffer from substance abuse, they want treatment because they want healthy babies and they want to be able to keep their babies. They don't want their babies to come into the system and for the child welfare office to take their children. They want treatment. This is an opportunity in the life of a person who's addicted to substances to get treatment and be able to try to move forward in leading a healthy life. Please support this bill.
Thank you very much. Thank you. Seeing no questions for the committee, thank you all. Oh, sorry, yeah, Senator James. Sorry.
I applaud the intent of the bill, but I'm just thinking about how it works. So on page 3, D1, you're going to require the correctional unit to make sure the woman has coverage to become effective no later than 24 hours after release. There was a pushback on, the Department of Corrections that that's not feasible. And it surprised me. I mean, I'm for the idea of it, but I don't know, where do we come up with 24 hours? And is that like, you feel like you have to require that particular 24 hours, and how is it feasible?
So this is already feasible.
Okay.
And I'm answering because local health departments oftentimes are the ones that enroll people in insurance. So we work with our local detention center when they have someone who qualifies for whether it's Medicaid or a qualified health plan, they reach out to us and then we proceed. Now, in pregnancy in particular, women are granted temporary insurance before the full Medicaid policy is enacted. So as long as that woman has that, then her coverage is essentially immediate within the 24 hours.
So whoever put this in, Department of Public Safety, they don't.
And
they
And
should know
Department of
this,
Public
but don't?
Safety, I'm sorry, I didn't mean to interrupt.
That's
The
okay.
Department of Public Safety does not actually enroll the pregnant individual. They just forward the information over, in our case, to our health department. We're the ones that actually do the enrollment.
And then the last question, and I, in my prior life, did work with the health budget, and buprenorphine is just an incredible drug, right? to help people with opioid disorder. The corrections people, the public safety people worry that, and I don't agree with this, but right now we require that only certain doctors can prescribe it. And there is an effort nationally to change that because it really limits access. But putting that aside, it hasn't been changed yet.
Actually, it has.
Oh, it has?
Yeah, about a month ago. Federally, they took away the need for what was called a buprenorphine waiver. So
Okay.
when 9 years ago, I had to go through coursework
Yeah.
and then I applied and I got, but no, that's been eliminated. So any licensed physician, nurse practitioner, PA who has an active DEA license can now prescribe buprenorphine.
So the Department of Public Safety and Correctional Services needs to keep up. All right, thank you, Mr. Chairman.
Mr. Chair, if I may, for just one quick second, beg your indulgence. To your first question, when people are released, we know their release dates. And so when we've been talking to the department about the reentry services that they're providing to get people ready to go, they're already doing that. So when somebody leaves, they walk out knowing that they can go to a medical provider. So I think that's just a regurgitation of last year's testimony that we refuted.
Okay.
But it is already happening, and that 24 hours is critical. And if the provider that is going to be providing their reproductive health care is part of the system, and I forget what that health system is, those records are also electronically available to that provider. But the individual would also be able to walk out with the
Right.
complete set of all of their medical health care that they can then take to the provider with test results and everything else.
Thank you.
Thank you, Mr. Chair.
No, thank you very much. Thank you. All right, so that completes the testimony for the proponents of the bill. We have one person signed up in opposition. Is Deborah Mercado here? Welcome.
I'll go to the podium. Good afternoon, Chairman and members of the committee. So I'm here my name is Deborah Mercado, and I'm here on behalf of Maryland Right to Life. I'd like to say that we oppose funding abortion services, and entities and persons promoting and providing abortion and abortion services for the pregnant incarcerated women. Incarcerated women deserve funding to promote the health and well-being of themselves and their babies. Pregnant incarcerated women can receive substance abuse treatment while receiving quality obstetric care for themselves and their babies. They can and do receive health coverage through Maryland Medicaid. And according to the Department of Health fact sheet about abortion services, abortion may be covered for reasons such as risk to mother's current or future somatic health and risk to mother's current or future mental health. We recognize the really good intention of this bill to treat incarcerated pregnant women for substance abuse, and that's wonderful. But we also look at, when we consider that mental health is sometimes used as a reason for abortion, we want to take the abortion funding out of this bill so that pregnant incarcerated women can receive proper treatment for substance abuse. We know that they can receive both, as the doctor before me said, they can successfully be treated for substance abuse while they are pregnant and incarcerated and go on to have a healthy baby. So we would like to see that removed from this bill. We feel that I learned today that this was written by the Reproductive Justice Inside, and when I look up information on their website, they seem to prioritize abortion. When you fund abortion, we feel that there could be coercion for the women who are incarcerated to feel like they should abort their children. We don't feel that they deserve that. If it's a choice, that's fine. But if their obstetric care only occurs at clinics that promote and provide abortion, they could certainly receive the subtle message that maybe they should abort their child. You know, being already in a difficult situation, being in jail and suffering from substance abuse, they already feel bad about themselves and should never feel like they have to make that choice to kill their own child. These women deserve the support for having their baby and learning how to be a good parent. So please ask for an unfavorable report on this bill.
All right, thank you very much for your testimony. Seeing no questions from the committee, thank you very much.
All right, thank you.
All right, so with that, that'll conclude the testimony and the hearing for Senate Bill 190. We'll still now move on to Senator West with Senate Bill 211.
Thank you, Mr. Chair. Can I bring up my panel? It's a little late in the day, so some of the members of the panel may have gone. I was hoping that we would have Aisha Braveboy, Gary Bear, Chair Walter, and Gabrielle Carl.
Isn't it here too?
Okay, Catherine Robinson is also here.
Judge Bear is over Zoom, Judge Gosford's over Zoom.
Okay,
So we've got a few people.
okay. So we have a few on the Zoom. We'll hear
Janice
from them
Salons
later.
is-
Great. First of all, as a preliminary matter, let me thank the chair of the committee for agreeing to be co-sponsor this bill with me. It's great for us to be together on this. This is a bill about PBJ, and that doesn't mean peanut butter and jelly. It means probation before judgment. In 1975, the General Assembly enacted the probation before judgment provision. It's intended to achieve an outcome in a criminal matter that doesn't involve a conviction. And so the current law, enacted originally in 1975, provides in relevant part that when a defendant pleads guilty or pleads nolo contendere, or is found guilty of a crime, a court may stay the entering of judgment, defer further proceedings, and place the defendant on probation, subject to reasonable conditions, if the court finds that the best interests of the defendant and the public welfare would be served, and the defendant gives written consent after determination of guilt or acceptance of a nolo contendere plea. And that's what the current law provides. But for purposes of certain federal statutes, the Maryland probation before judgment law has been held tantamount to conviction, where it is preceded by a plea of nolo contendere, or a plea of guilty, or a finding of guilt, as Maryland law provides. So as Maryland law currently provides, in order to get a probation before judgment in Maryland, which does not involve a judgment, the federal statutes say that that is tantamount to conviction. For most people, current Maryland law merely puts them on probation. And if they keep their noses clean during the period of probation, under section 6-220G3 of the Criminal Procedure Statute, a defendant who is successfully discharged from probation shall not be deemed to have a conviction, quote, for the purpose of any disqualification or disability imposed by law because of conviction of a crime. But because of the federal interpretation of Maryland's probation before judgment statute as involving a conviction for at least 4 categories of citizens, a probation before judgment can be disastrous. This is because under the federal law, a Maryland probation before judgment qualifies as a conviction with all the attendant consequences. First, so here are the 4 categories. First, a person who aspires to a career which requires a federal top secret clearance will not pass the security check screening due to the conviction under federal law, and therefore will not be able to pursue his chosen career. I know of at least one staff employee of the General Assembly who falls into this category. Second, there are several professions in Maryland which require a license as a precondition to practice that profession. These include physician assistants, pharmacists, nurses, acupuncturists, audiologists, music therapists, chiropractors, dentists, massage therapists, morticians and funeral directors, certified midwives, assisted living managers, occupational therapists, optometrists, physical therapists, doctors, athletic trainers, genetic counselors, podiatrists, professional counselors, psychologists, social workers, and environmental health specialists. A person who aspires to any of these careers will not be able to be licensed in Maryland to practice that career due to a conviction as defined under the federal law. Third, for active duty people in military service, the entry of a probation before judgment in Maryland under current law can result in administrative sanctions removal from certain assignments, a reduction in rank, and possibly administrative discharge. And then there are in the final category, there are the people who are lawful permanent residents of the United States or who have college student visas. We're not talking about illegal immigrants here. These folks fall into the category, they're all lawfully in this country, but because a probation before judgment is classified by federal law as a conviction of a crime, the entry of a PBJ in Maryland against any person in this category enables ICE to swoop down and deport the person who received the PBJ. Any of these cases, in the event the person who received the PBJ is married, perhaps with children, such a deportation would separate spouses and leave the children without either a mother or father. The purpose of this bill is to set up an alternative method of receiving a probation before judgment that is structured in a way that will not inflict on Maryland citizens who need top secret security clearances, a career-ending stain, will not tar Maryland citizens who aspire to careers in one of those many healthcare professions with an imprimatur that will bar them from their chosen careers, will not cripple the military service careers of patriotic citizens, and will not set into work the deportation of a lawful permanent resident of the United States or a person holding a college student visa. So let me summarize the provisions in this proposed alternative method of probation before judgment. First, when a court finds facts justifying a finding of guilt, there's no need for a nolo contendere plea, there's no need for a guilty plea, and there's no need for a finding of guilt. All that has to happen is the court has to find facts justifying a finding of guilt. Secondly, the court finds that the best interests of the defendant and the public welfare would be served. Third, the defendant gives written consent to the probation before judgment. Fourth, the court may make findings of fact sufficient to support a finding of guilt. Fifth, when the court finds facts justifying a finding of guilt, the court may enter into a probation agreement with the defendant, which will provide that, number one, the defendant does not admit to the facts offered by the state and pleads not guilty. Number two, the defendant accepts probation in exchange for the court expressly withholding a finding of guilt. Three, the defendant knowingly and voluntarily waives the right to a trial and the right to appeal the probation agreement. Four, if the court finds that the defendant has violated the terms of the probation agreement, A, the court may find the defendant guilty of the underlying crime as a result of the violation, and B, on a finding of guilt, the court may sentence the defendant up to the maximum penalty for the underlying crime. After an agreement made in accordance with this section is placed on the record, the court will make a finding that there are sufficient facts to support a finding that the defendant is guilty, but that the court does not do so, and instead imposes detention before judgment. Finally, the consent of the defendant to and the receipt by the defendant of a disposition shall be considered as a probation before judgment for all other purposes under state law. So this provides an alternative method of a probation before judgment, which will not involve placing a verdict on the record and not disadvantage the groups and the people in those four groups that I mentioned earlier. Now, let me just finish with amendments. The state's attorneys are requesting an amendment requiring the state to consent to this alternate version of probation before judgment. This amendment would be problematic for four reasons. First, it would limit the court's long-held authority to impose PBJ over a state's objection. Second, there's no need for this change here merely because the process of entering the PBJ has been amended. Third, consequences of and eligibility for the probation before judgment are unchanged, only the mechanism by which it's entered. And lastly, the court as the objective arbiter remains in the best position to determine the appropriate sentence and is free to follow or reject either the defense or the prosecution's recommendation, either for or against the probation before judgment. So I disagree with the state's attorney's request for an amendment. On the other hand, the Administrative Office of the Courts has another proposed amendment, and I have prepared an amendment to the bill, which I hope is in everybody's packet. It contains amendment number 1 and amendment number 2, which seeks to follow the guidance provided by the Administrative Office of the Courts. So with that, I conclude my testimony and turn the proceedings over to a very competent panel.
Mr. Chairman, Mr. Vice Chairman, members of the committee, John Giannetti, for the Maryland Criminal Defense Attorneys Association. We're putting a full court press on with this bill this year. We think it's a great bill. It's one of our primary bills. And it's in a much better form than it was last year. Last year, this committee passed it out with Senator Lee's bill, passed it out. It died. I don't even know if it got I think Senator Reedy may have put it on the table in one of the last couple of days of the session. Never really got a hearing on the floor, I don't think. But anyway, so listen, I mean, okay, some of you served with Delegate Joe Valerio. You remember Joe Valerio? I was an attorney in his office. My first day working in his office, he gives me a file. He says, you go down to Prince George's County Court, you get a PBJ on this or don't come back. You know, it's like, what's a PBJ? And the PBJ, believe it or not, is probably the most used tool in all of the criminal court system. It's used every day 1,000 times while we've been sitting here in this hearing. 1,000 times it's been used. It's a very good tool. There's a problem with it as it relates to federal law. Anyone that tells you that a PBJ isn't a legal fiction is lying to you, or they're doing it out of ignorance. The PBJ that we currently have is a legal fiction. Why? Because the judge finds a person guilty, strikes the guilty finding, and puts them on probation. They were guilty for a microsecond. But as a lawyer, 25 years of criminal defense law, I was able to legally tell my clients, under Maryland law, you were not convicted. You're allowed to say you were not convicted of that crime, even though for a moment you were. The federal courts, Fourth Circuit, has said, yes, you were. That was a conviction and it counts as a conviction. So you have to clean it up. This is a good way to clean it up. This is a way to make sure that people aren't getting deported, make sure federal law won't continue that for a top secret. And I see, and maybe somebody could ask a question, but I see an easy way for this to happen. The judge is going to make a finding on the record that there are facts sufficient to find guilt, but I'm not finding guilt. He's already pled guilty. He's already pled no contendere. If it comes back and you violate that probation, you're going to come back and the judge is going to sentence you. So you're giving up your right to trial. It works well. It will work. It'll work 1,000 times a day, and it's a good, clean bill. Thank you, members.
Excellent. Thank you. Never worked for Joe Valerio, but I was certainly on that committee.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Jer Welter. I'm here on behalf of Attorney General Brown and the Office of the Attorney General in support of this bill. You've got our written testimony, so I want to just make 3 important points. Number 1, this bill is necessary. And the reason is that we do not have a disposition in Maryland right now that will serve the purposes of a PBJ, but that will not trigger the federal definition, particularly the federal immigration law definition of a conviction. And the reason is that the federal definition counts as a conviction anything where the defendant has entered a plea of guilty or has admitted sufficient facts to warrant a finding of guilt. And that's why in the bill, you'll see that the plea is not guilty and the defendant does not admit the facts to avoid triggering that definition. So you may hear that, we should just do a guilty plea with or a, not guilty agreed statement of facts. Those won't work in this situation. The second point that I'll make is this is a probation before judgment for all purposes under Maryland law. So it won't trigger the federal definition of a conviction, but it will trigger everything that a probation before judgment would under Maryland law. You'll hear it called a PBJ light. I don't think that's accurate. This is a PBJ under Maryland law. And the third point, and this is in response to the written testimony you've received from the judicial conference, this comports with due process. And in earlier versions of the bill in previous years, our office expressed some concern in that regard. The bill's been amended, and I think the amendments satisfy due process. You've got a clear indication of what the plea is. You have what's going to be required is there's going to be a finding beyond a reasonable doubt of facts justifying a finding of guilt. And then you're going to have an agreement that's placed on the record with a detailed colloquy, just like a plea, or just like a guilty plea. So we'd ask for your support. Thank you.
Thank you.
Chair, Vice Chair, members of the committee. My name is Gabriela Carl. I'm a professor at the University of Maryland Law School Immigration Clinic, and I'm asking for a favorable report on HB 193, a bill which eliminates the unintended consequences of probation before judgment. This General Assembly passed the Maryland Probation Before Judgment Statute in 1975, and it was intended to give first-time offenders of minor crimes a second chance. They wouldn't have to deal with the stigma and the collateral consequences of a conviction. However, since 1975, the federal laws have changed considerably, and as a consequence, a PBJ is treated as a conviction by many federal statutes, including the ones that Senator West talked about, and certainly the immigration statute, which is how this problem came to our attention because it was harming our immigrant clients, lawful residents, often veterans of the United States who couldn't become citizens, or even worse, were being put into deportation proceedings because of their PBJ, which they were told would not have those serious collateral consequences. This bill proposes a simple solution, and that is just to amend the statute as the Attorney General, Jer Welter, explained, and other people have explained, so that it no longer triggers those consequences. This bill does fill an important gap in Maryland law. All other dispositions, nolo contendere, not guilty, agreed statement of facts, Alford pleas are all deemed convictions under federal law. This bill will contribute to the finality of judgment and judicial economy. There'll be no need to undo unjust pleas if we do it right the first time. And this bill before you today was developed in coalition with the Office of the Attorney General, state's attorneys, and a host of other legal experts, and is supported, as you'll see in the written testimony, by the Maryland State Bar Association and other organizations. We believe that this bill is consonant with Maryland law and due process. There are other states that have bills just like this, that this was modeled after, and the Fourth Circuit in the Crespo case, for example, about the Virginia statute, held which we modeled our bill after, that it wasn't a conviction under federal law. And for those reasons, we ask for a favorable report on HB 193. Thank you. Sorry, SB 211. Mess that up.
So Chair, Vice Chair, committee members, good afternoon. My name is Catherine Robinson, and I am a clinical law student at Maryland Carey Law here on behalf of the Immigration Clinic, the Justice for Victims of Violence Clinic, and the Gender Violence Clinic. Maryland Carey Law's clinical law program prioritizes addressing racial injustice. Additionally, as a Black woman and law student, this bill is important to me because it prevents harm to Black immigrant communities. More than half of immigrants who receive a PBJ will be detained by ICE, and 99% of people in detention with PBJs are Black. Therefore, at its core, this is a racial justice bill. There's a long history, especially for Black people, of being over-policed, prosecuted, and then deported for even minor criminal contacts. This is because Black immigrants are more likely to have encounters with law enforcement and end up charged and prosecuted for crimes which lead to deportation. While in custody, Black immigrants often face worse treatment by immigration authorities as compared to other immigrants. Black immigrants are also more likely to lose their legal cases for immigration relief as compared to other immigrants. For example, Black immigrants reported that ICE officers had tortured them into signing their own deportation orders and then deported them to countries where they were likely to be persecuted. This bill's passage would prevent racially unjust detention and deportations of non-citizen Black Marylanders. This bill will help states' attorneys and judges ensure that all people receive equal justice under the law. Ultimately, this bill is about fairness and equal treatment for all Maryland residents, regardless of their citizenship status or the color of their skin. So I therefore ask for a favorable report on SB 211. Thank you.
Excellent. Thank you all very much. I'll say that there are some excellent law students from Washington College of Law in DC and the University of Maryland. I don't know who's doing better today, but they're both have been stellar. So thank you all for your participation. So before we get started, I know Senator Carter's got a couple questions and maybe Senator Sinner, but if Professor Carl would come up, I've got a couple just to set the stage. So we've talked about this a lot over the summer, and then what the committee struggled with last year, and we talked about this, is that obviously this deals with the federal statute, which we have no control over. The NOLO, for instance, is where counts as the conviction. But we were all struggling with a couple of different things. You could help us just define them and explain why they don't apply under this federal statute. And so Alford plea, you've got a NOLO. NOLO is clear because it's in the statute. We understand the PBJ. But then stetting, like you have stets, you can do conditional stets. Can you explain why the Alford plea won't work while stetting a matter won't work?
Sure.
And then also just talk about, the mechanics of the due process vice this, because this is, due process, this is a PBJ light. And then we'll talk about due process stuff later, but it's like the PBJ light. I like that phrase.
We don't like it.
Well, it was new to me, but
Sure.
but it's not a PBJ because there's no finding that's then held conditioned to whatever the conditions are. So can you just explain all that? Alfred, PBJ, NOLO, stet, conditional stet, because that's where we were struggling. Why didn't any of these other mechanisms work?
Sure, happy to do that. So with an Alford plea, there's both an admission of guilt and an admission as to the facts. And so that triggers the federal definition of a conviction. That admission, when I say that is the act of saying guilty, and then the facts and saying like you don't contest the facts. So that an Alford plea is essentially, for the purpose at least of the federal statute, a guilty plea. And then with the not guilty agreed statement of facts, it's similar. Although there's a plea of not guilty, there's an admission as to the facts. Everyone kind of agrees these are the facts, but they differ about whether those facts really trigger guilt or warrant guilt. And so certainly for those reasons, again, it triggers the federal definition of a conviction for the various statutes that we alluded to. And a stat would in theory be fine. However, what a stat doesn't allow you to do is hold somebody responsible. And so many times a state will very reasonably not want to do a stat because they feel that this person who has committed a minor offense, who has made a mistake, needs to be held responsible and also possibly really needs the services that they could get through the court to help them be fully rehabilitated so they don't reoffend again. So really what this allows you to do, our PBJ allows you to do, is to hold someone responsible, give them the services, make sure that they don't reoffend, and at the same time not make them be haunted by this disposition and have it trigger all of these unintended consequences. And even just to give one more example, I had a client with a PBJ and this put him in ICE custody for a year before we could fix it. It was not what the state wanted. But in that year, he was held away from his family in upstate New York, couldn't see anybody, had lost his job, lost where he lived. I mean, it was a crisis. So what this PBJ would allow for is to still help someone, hold someone responsible, which a stat would not, without triggering all of these unintended consequences.
Thanks. No, no reason I'll ask him to push a little bit on the stat just because it's going to happen. We're going to talk about this and when we vote on this. So how long can you stat a matter for? And you can have conditional stats, right? So explain it because this is going to come up in our discussion.
Sure. And I would also love to invite Mr. Welter to take a stab at this question. But with the stats, my understanding of a stat, I'm not a stat expert, but that they are, there's you can do a 3-year stat. And then within the first year, I think the state would have to show that there's some reason for bringing the case back, that there's been some problem, but that for the times after that, they'd have to show that there was some good cause to sort of reactivate the case. So I think, again, like a stat is appropriate for many cases, but a state is rightfully not always willing to provide a stat because the offense, was not insignificant, was important. And again, the person might really need the benefit of certain services that they could get through a probation before judgment they wouldn't otherwise have access to. So, but I would also, I don't know, Mr. Walter, if you want to.
Sure. I guess the other thing I'd say about a stat, the problem with a stat is that a stat doesn't involve it it doesn't work from the prosecution perspective because if the defendant violates the conditions of the stat, you're going to have to come back and have that trial. Under this procedure, the judge is already going, like a PBJ, the judge is going to already find the facts sufficient to find the defendant guilty beyond a reasonable doubt. The only difference is they won't take that additional step of actually entering the guilty verdict until the defendant violates probation. So you've got that security.
No, it's tremendously helpful. And so we've talked about the due process stuff, so I'm not going to bring that up now, and I think we've got good testimony on that. So yeah, thank you for bringing the bill, Senator West, and to the panel. Thank you all. Especially the law student. You have a very talented law student there. So all right.
Hardly agree.
Yeah. All right. Senator Carter, I know you had some questions. Sorry.
So I appreciate all the work that's been done on the bill. We certainly spent a good number of hours debating this issue for the last several sessions. My question, so first of all, it's not just, this issue has affected my clients, not just with respect to immigration, but I've had college students who got PBJs who then later wanted to go into the military or even as an officer. And because no federal institution recognized PBJ, it's the same thing, whether it's immigration or whether it's just any federal institution. So, but what we were able to do in many instances, it didn't necessarily prevent them. They just had to answer more questions. And sometimes if they got an expungement, that's difficult because there's no more record of the case or whatever. I guess that my question is, are there any particular cases more often that lend themselves to this, or is it just any random case? For example, is it like driving on a suspended license, PBJ, nobody's really going to bother you, but if it's theft, then PBJ, then they may, or is it just completely random? Like, how often is this coming up, and are there particular types of cases that lend themselves more to the ICE issue or ICE detention after a PBJ? And do you have any data on that?
I don't, thank you for your question, Senator Carter. I don't have any data on that. On the issue of the military and the licenses, it's certainly come up for me anecdotally that I've had people come and have problems with the PBJ as a consequence of that. But we do have some witnesses coming up who, an attorney who practices military law, who can talk about this and answer some of your questions about, well, when that might come up. But certainly I think, you know, the principle behind the bill is just that people should be able to get probation. The spirit of a probation before judgment is certainly that someone should be getting a second chance. But if it's affecting your livelihood, your ability to remain in the U.S., your ability to naturalize and become a citizen, then it's gone beyond probation before judgment. It's not a true probation before judgment because it begins to affect your life in an ongoing way.
So I want to be clear. I'm not disagreeing. I'm actually appreciating all the work that's been done on the bill. I think earlier on I did have questions, and I don't completely agree with the position that, oh, in no circumstance could a stat work, or because sometimes stats are characterized as diversion, and there are specific programs and conditions that can be met that can be mandatory, or else it won't work. Case will be prosecuted. So it's not always. I think this is another option. I don't think it's the only option. I think there are multiple different options. I think this would present us with two different types of PBJ in the state of Maryland. This definitely be the more favorable. So, but really, this is legit curious if there are certain kinds of cases that this becomes an issue, or is it every type of case that results in a PBJ that is subject to this?
Oh, I'm sorry, I want to make sure I understand your question. Are you asking whether PBJs, the current PBJ negatively would affect anyone who would get it, or is it?
So I know it will. I just mean in practical reality, is it every single person that gets a PBJ that then is picked up by ICE, or is it very random? Is it very discretionary? Is it DUIs, but not driving on suspended? Is it driving, what are the cases that we're talking about? Is there any particular type, or is it all cases?
It's all cases. They don't distinguish between what you got the PBJ for. It is all cases. And so you will, there'll be someone testifying later on, a directly impacted person, and their family member was picked up because of DUI. But I've had clients with PBJs in ICE detention for theft, for all kinds of things. So it's really just the fact that it's a conviction. It's true
Doesn't
that
matter if it's misdemeanor, felony, doesn't matter if it's traffic, criminal traffic, just anything.
it would
Got it.
depend on many factors, their immigration case in particular, but it could be for a range of criminal charges. So it would just depend, but I've seen it in a range of cases, and none of the sort of Maryland state categories would be predictive of that. Thank you.
I answer the question. Yeah. Thank you, Senator Carter. And also, Mr. Chairman, there's an important nuance here that I think is being missed, and I want to be sure that the committee understands it. Once this passes, I think what you'll see, it's just a prediction, is that different judges will deal with it differently. Some cases right now in the courts, certain judges will give you a PBJ just by saying, I'm not disagreeing. I'm pleading guilty to my speeding tickets, guilty with an explanation. I was in front of Judge Purnell 2 weeks ago. He gave every person, all they had to do was say guilty with an explanation. He announced at the beginning, you're going to get a PBJ. That's very different from a lot of other judges. Some judges in some courts, the prosecutors do not guilty statement of facts. Some people love the stat docket. Some people never use it. I think if this goes through, you're going to see this new PBJ light, if you want to call it that. I don't want to call it that, but you're going to use it everywhere because it's actually quicker. And here's why. And here's where the due process issue comes in. Most people, if they go to court, they would be surprised how quickly a defendant is giving up his or her defendant's rights to a trial. They do it quickly for the PBJ now. See, listen, it's not going to be a conviction. They're willing to do it. They'll give you a PBJ. The judge is going to give you a PBJ. The prosecutors, and they do a not guilty statement of facts. There's no trial. It happens quickly. It's one of the ways that you move along a docket of 40, 50 cases. All right. It happens a lot every day. This is not going to be any different in the due process, because what's going to happen is the attorney is going to have a responsibility to tell the person, well, you're giving up your right to a trial. If you violate this probation that you're going to enter in after this, you're giving up your right to a trial. Do you know that? Now, you're not going to say that you're guilty now, as you would have with the PBJ, because that would trigger. We know that the reason they're not going to is a trigger. But they have, by written agreement under this bill, are going to give up their right to a trial. That's their due process. That's what they're doing for the PBJs now, but they're going to be doing it sort of in the future if they violate their probation. So their due process, they had that chance. They have the chance. They can say, no, I don't want any of this. I want a trial. You're giving up your right doing that. And the judge is not going to make a finding of guilt as he or she does now. They're going to postpone it. And so right now we actually do, our PBJ is not a PBJ because the judge finds judgment. He erases that and gives the probation before the judgment, even though it's done after time-wise. Now, exactly. And so this is a much cleaner bill. It actually works better, and it will work quickly and smoothly without a due process issue in my mind.
Oh, thank you. I applaud the intent of the bill, and the law professor and her student came to my office, and I just so enjoyed meeting both of them. I actually know of cases where this has done exactly what you all want to eradicate. So all that. My question is really just a concern about the very strong opposition memo by the Maryland Judiciary. And it's not just that they've written it. They guide the entire state. And my concern is if we don't address these, and I'm sorry, Senator West, I don't have your amendments yet, and I don't know if you are addressing the judiciary's concerns or not. And so, all right, because what I'm worried about is that when the courts are unsure, unclear, and we do not address their concerns, it's pretty serious, because I think they're all going to meet privately. They're all going to talk about this. And I think they would be reluctant to try our new system if they're not satisfied that we worked with them and alleviated some of their concerns. And quite frankly, I'm not going to delay it now. Some of their concerns are valid, and it may be how you've drafted it, or it may be that you just haven't been able to collaborate with them. But I think that
Senator,
that's a
I'll come to your
serious issue.
office. And we'll have at least as nice a conversation as with a law professor and a student. So the main concern that I saw in the judiciary's opposition was that this bill as drafted doesn't require guilt beyond a reasonable doubt.
That's one of them.
Yeah, that was the major one. And so this amendment imports beyond a reasonable doubt in numerous places in the bill. So
But you
we'll
got-
talk about any other concerns
Right,
you have.
and I want to feel at the end, if I vote for this, if I can vote for this, just because the Maryland judiciary is on board and we will not have a lot of judges so uncertain about what we've done, they won't follow it. Then it becomes ineffective. It
Right.
doesn't get used. All right, thank you, Mr. Chairman.
All right. Seeing no further questions, thank you all very much for your testimony. All right. Now we'll hear from Elizabeth Hilliard. She's still here. There you go. Hey, there you are. Erica Sutter. Is Erica still here? There she, hey, what's going on? Say what? Hide in the back. Good to see you. Is Alexis? Oh, she's going to be virtual. All right, and then I think that is it. Then we'll switch over to the virtual panel. So am I missing anyone?
I don't believe so.
We've got some folks in the,
She tested positive for COVID, so she'll be here over Zoom, and a bunch of people are on Zoom. So.
okay,
Thank you.
excellent. All right.
Good evening, Mr. Chair, members of the committee. My name is Erica Struder. I'm here in my capacity as president of the Maryland Criminal Defense Attorneys Association. Years ago, I received a frantic call from a father whose daughter had been picked up from their home by ICE. She was being held in a local jail and was in expedited deportation proceedings to a country that was beset by conflict and human rights violations, a country where she had never lived and she had no ties. She was born in a different country than the one she was being deported to, where her family had fled as a result of the conflict in their homeland. She and her family had entered the United States legally. She was a valid green card holder, and a decade earlier, she'd received PBJs in 2 minor theft-related cases. Again, she was legally in the United States. She had not incurred new charges. It was unclear what flagged her for ICE. It seemed she was moving, and it might have been a credit check that had put her on their radar. Fortunately for her, the state consented to 2 quorum notices that we had to file. The court agreed to our expedited hearing. I was able to locate the victims who consented to relief, but all the stars had to align for this to happen. The amount of resources used to fix this process, to fix this outcome, the court's time, the lawyer's time, the weeks that my clients spent incarcerated, not working or contributing to society, the costs that were incurred are astounding. Just to achieve the result that was the original intention of all of the parties. If this law were in place at the time, none of this would have happened. It's a common sense measure that will ensure that the outcome that the court intends is the outcome that is actually achieved. And for this reason, the Maryland Criminal Defense Attorneys Association would urge a favorable report. Thank you.
Good evening. I'm still Elizabeth Hilliard with the Office of the Public Defender. Well, good to see all of you again. You'll see me again shortly, I'm sure. I feel a little abashed talking about judicial efficiency at 6:30 p.m., but I would like to speak briefly to my experience as a post-conviction attorney who tries to go back and remedy these circumstances 10, 15, 20 years down the road from when the initial probation before judgment agreement has been reached. It's extremely difficult to fix something that far down the road. It makes a lot of sense to fix it the day the hearing occurs. I personally represented a client who lived in a different state, had a very, very small, low-level possession of marijuana, PBJ while he was in high school. He was assured it would not be a big deal. The state's attorney was under the impression it would not be a big deal. In fact, the judge called me back into his chambers to ask why ICE cared about this. They specifically fashioned this PBJ to avoid that. Yet, my client was calling into this hearing from a detention facility where he was awaiting deportation to Sierra Leone. This bill fixes those problems and will alleviate all of the backward ways that we have to try and fix them now. So we urge a favorable report on this. And I would also just like to note, I come from a state where this exists, Virginia, and I have personally seen a family member benefit from this who works in the federal government now, had a probation very similar to this, fashioned under this agreement, and it's really saved his life. And this will help not just Marylanders with immigration consequences, but those with serious career goals and other licensures that they may wish to pursue. Thank you.
All right, thank you both very much. Questions from the committee? Seeing none, thank you both. Good to see you both. All right, we're now going to switch over to the virtual proponents of the bill, and then we'll go to the opposition panel to wrap us up. So we'll start off with, is Councilmember Fisher in the room? We're now going to switch over to the virtual proponents of the bill, and then we'll go to the opposition. If you're on Zoom, if you could mute your feed from YouTube or to close down that browser room. Okay, so Councilmember Fisher, you're up.
Thank you. Okay, I hope you all can see me. Good evening to the Senate Judicial Proceedings Committee. My name is Wanika Fisher. I'm a Curran County Councilwoman here in Prince George's County, Maryland. I was a former delegate and proponent of this legislation in the House side when I served the last 4 years in the House Judiciary Committee. I know you've heard a lot of testimony, but I wanted to come to your committee and talk about my experience with this legislation and why I think it's so important and personal to me. For those of you who don't know, I am a daughter of immigrants. My mom is South African, fled South Africa due to the heinous actions of apartheid to our family. And my dad is Nigerian, Yoruba. They met in the United States. I was born here and have had very interesting experiences as a first-generation American. And I will tell you, before I was elected, I had a neighbor who was stopped for a local traffic stop, not a misdemeanor infraction, ended up receiving our PBJ, and long story short, he ended up in deportation proceedings, is back in his home country. And my neighbor who is here, who is U.S. citizen, and they have 2 U.S. citizen children without their father present in the home. I think there's a real economic benefit to this bill, which is when you separate families, you're also separating income from children from all backgrounds that need their parents here. And the consequence of being separated from your family and the consequence onto that family itself is extremely exacerbated, which is why I think this legislation is so important. And for me, particularly, Black immigrants in particularly are more over-policed than anyone else when it comes to the immigrant community that's dealing with infractions. And I think that this bill will really make sure that the consequences of the PBJ are what we intended. And additionally to that, I didn't realize, I should have watched online. I didn't know everything you all talked about in the previous panels, but I did want to mention that there are consequences and actions if you violate your probation with this PBJ, just like our current PBJ standing, just like if an individual was to offer the STEP docket for an infraction. So depending on what the terms are in whichever case and a defendant and the judge allows to enter into this PBJ, if there's a violation of probation that's brought back, that's the point where the judge will actually enroll a guilty verdict, and then you can proceed in whatever you think is necessary when it comes to a violation of that kind. So I just wanted to make sure that was clear. I'm here for any questions. I know it's very late to my Senate colleagues. I appreciate you all hearing this. I didn't hear a time thing. Am I still within time, Mr. Chair? I'm not
No,
sure.
You're an elected official, so we gave you some grace, but.
Oh, okay. I'm like really
Hey,
sorry.
No, appreciate it. No, it was good to see you. Swing by next time you're in town. I know Delegate Fisher would always swing by, but now you want Hollywood on us in the council. I don't see you. Maybe now that Senator Washington's over here, you'll come see us in JPR.
I will. I will come see. A lot of my favorites are on that committee, so I will be there.
All right, good to see you. Thanks a lot. All right, we'll now move on to is Alexis on? Yes, you're up next. If you can unmute yourself. There you go.
Yes, thank you, Mr. Chair. Good evening. My name is Alexis Turner-Lafing. I am a student attorney at the University of Maryland, Francis King Carey School of Law's Clinical Law Program. I'm also a business immigration professional with 4 years of experience. I urge a favorable report on Senate Bill 211 because amending the probation before judgment bill would ensure that the visas used by foreign students and professional immigrants are not inadvertently stripped away because of a one-time minor mistake. The types of individuals who could be affected includes, but is not limited to, foreign national executives, scientists, academics, outstanding athletes, computer scientists, engineers, and undergraduate and graduate students. A non-citizen resident of Maryland who obtains a PBJ may be deemed inadmissible or ineligible to obtain or maintain a visa or gain admission to the United States. This means that when a non-citizen visa holder leaves the US, they would not be allowed to return to the US. It is common for foreign students and professional immigrants to travel back and forth from the US to see family or take care of other business in their home country. Not being able to do so, or doing so and being denied entry as a consequence, would be highly disruptive and problematic for many foreign students and professional immigrants. In addition, many of the non-immigrant visas utilized by these individuals also allow for their spouse and children to accompany them while they work or study in the US. As such, if their spouse or child has a lapse in judgment that resulted in a PBJ, they would be inadmissible upon their next departure from the US and would not be able to use their existing dependent visa to return. Amending the PBJ statute will make it easier for the US and US companies, universities, and think tanks to attract and retain foreign talent. I therefore respectfully urge a favorable report.
All right, thanks a lot. So Brian, you're up next.
Thank you, Chairman Smith. Good evening. I'm Brian Zavin. I am the Chief Attorney of the Office of the Public Defender's Appellate Division. Senate Bill 211 would provide a much-needed correction to Maryland's probation before judgment, or PBJ law, and so the Office of the Public Defender urges a favorable report. I'd like to address how the law will work if enacted and how it satisfies due process and the judiciary's concerns. Under SB 211, the defendant enters a plea of not guilty. The court then hears a proffer of facts, just as it would do at a guilty plea or a trial by agreed statement of facts. If based on the proffer, the court finds there to be sufficient facts to support a guilty verdict beyond a reasonable doubt, and that a PBJ is in the best interest of the defendant and the public, the court may then enter an agreement with the defendant under which the defendant waives the right to trial and agrees that the court will defer entering a verdict in exchange for the defendant's agreement to complete probation. The defendant agrees further that if there's a violation, the court may enter a verdict and impose sentence accordingly. What ensures that due process is protected is the requirement that the defendant knowingly and voluntarily waive the right to a trial and agree that the court may enter a verdict. Other than that, it's a PBJ for purposes of Maryland law. But one final point, SB 211 does not create probation light, and I want to be clear on that. The reason is that all the same conditions of probation will apply as if it's a regular PBJ, and defense counsel would make a grave error by not informing their clients that if they violate, there are very real and very severe consequences that await. But for those who don't violate, they'll receive what this body, this General Assembly attended all along, the chance to lead a productive and conviction-free life. And for that reason, the Office of the Public Defender urges a favorable report. Thank you.
All right, thank you very much. Is John here? Mr. Gossert.
John Gossert, can you hear me?
We
Senator?
can, yes. Yes,
right.
Go ahead. Thank you.
God bless all of you senators for your long day and your willingness to continue to listen. I want to thank you for the opportunity to testify today. My testimony today is like others. It is about fairness, it is about justice, and it is about treating all Maryland residents and citizens equally. My name is John F. Gossard Jr. I'm a retired United States immigration judge. I sat on the bench in Baltimore for 31 years. I have filed with you my written testimony, which speaks about why Maryland probation before judgment, not a conviction under Maryland law, is a conviction under our federal statute through its definition of conviction. It is highly unlikely that the Congress of the United States will pass any meaningful immigration statutes in the near future. The PBJ statutes in our neighboring states of Virginia and New York and others are written so as not to incur a conviction under federal law. Maryland residents and Maryland citizens should also be treated equally. I want to share with you this story. Daryl, a lawful permanent resident of the United States, a resident of Maryland, lived with his United States citizen spouse and his 2 U.S. citizen children. They were employed, they owned a home, they paid their taxes, they were productive members of the community. Regrettably, Daryl made a mistake and was charged with a minor offense, his first and only offense. He was able to receive, the benefits of probation before judgment. But Daryl, not a United States citizen, although not convicted under Maryland law, was subject to the conviction under the federal statute. And I was required under the law to order his removal from the United States, a permanent banishment, a separation from his family and his home. How tragic, how unnecessary, how unfair, how wrong. Daryl is not alone. There are many residents who have been subjected to this. Your bill will allow a second chance for Maryland residents to equally proceed and progress in our community productively and lead productive lives. Daryl's wife wrote to me, Senator, Judge Gossard, you have ruined my life and the lives of my children. May God forgive you because I cannot. While I was correct under the law that day, I did not do justice. I thank you for the favorable consideration of this bill.
All right, thank you, Judge. All right, we're now going to go to Judge Bear. Gary Bear, you're up.
Yes, thank you, Chair Smith. And I can't see whether Vice Chair Waldstreicher is there, but if he is, I want to give my greetings to him. He's my state senator. And I want to thank particularly Senator West as well for being a sponsor this year. For the reasons stated by others, I want to join all of their policy recommendations. I am a retired Montgomery County Circuit Court judge, having served for 9 years on the Circuit Court in Rockville. I just want to emphasize and touch on 5 points that have been touched on by others, but I think deserve some special attention. One is on that issue of a stet, and I think it's really a red herring. It really has nothing to do with this type of situation. The stet merely delays a prosecution. The whole point of this is to get rid of cases, to dispose of cases. Second, this bill encourages prompt disposition of cases. And one that was touched on by a prior witness, if you go forward with this bill, it will speed cases, it will get rid of all of the post-conviction and quorum nobis challenges that occur years later. The third point I want to make is that pretty much everybody is in favor of this bill. The only entities that have expressed any concerns are the judiciary, which I think can be addressed. The state's attorneys were in favor of this bill last year. Now they're not for some reason. Fourth is the judiciary's points can be dealt with, and I think those should be dealt with pretty easily. And finally, I do want to oppose, as I think Senator West did, any allowance or amendment of the bill that would allow the state's attorneys to veto the PBJ. That is something that is really totally up to the judiciary, and neither party should have a veto power. Thank you very much.
Excellent. Thank you very much, Judge. All right, now we'll go to Miss Emerson. Jessica, how are you?
Good. How are you? It's good to
Good.
sort of see you.
Likewise.
Vice
Welcome.
Squint. Good evening, Mr. Chair. Again, if Mr. Vice Chair is there, and members of the committee, my name is Jessica Emerson, and I direct the Human Trafficking Prevention Project at the University of Baltimore School of Law, which seeks to reduce the collateral consequences of criminal legal involvement for survivors of human trafficking and those populations put at highest risk of exploitation. I am also here in support of Senate Bill 211. In the political rush to demonize undocumented criminal defendants, it is often forgotten that hidden among these defendants are foreign national victims of human trafficking who frequently have criminal records stemming from acts they were forced to commit by their traffickers, as well as the instability that so often precedes or follows a trafficking experience. Arrest, detention, and even deportation of foreign national trafficking victims is not uncommon. Victims may be arrested for working without a visa, for prostitution-related charges, or for a range of other crimes, including theft and drug sales. National data bears out the regularity with which this occurs, as indicated by the 91% of sex and labor trafficking survivors, both U.S. and foreign-born, who reported having been arrested at some point in their lives. However, while criminalized U.S.-born victims are saddled with collateral consequences such as difficulties obtaining housing and employment, foreign national victims face the additional, far more severe consequences of deportation. Allowing for some leniency in situations where a foreign national defendant is a first-time offender or where the crime is nonviolent would reduce the risk of these life-altering collateral consequences, as well as allow for the possibility of connecting the victim with service providers who can assist them with pursuing the immigration relief they so rightly deserve as crime victims. Senate Bill 211 will reduce the risk of this harm by allowing a judge to grant a PBJ, which would not be considered a conviction for purposes of state or federal law. And for these reasons, the HTPP at the University of Baltimore Law School supports Senate Bill 211. Respectfully urge a favorable report and thank Senator West for his sponsorship of the bill. Thank you very much.
Excellent. Thank you very much. All right. Is Ms. Alonso, you're up. Janice, welcome.
Thank you. Thank you, everyone, and good evening. Yes, my name is Janice Alonso. I'm a senior academic advisor and adjunct faculty at the Community College of Baltimore County. I'm also a doctoral student at Morgan State University, working on my dissertation for a degree in community college leadership. I have a bachelor's degree from Ithaca College in New York and a master's from Florida State University, and I've worked in higher education for more than 20 years. I'm fluent in Spanish and have traveled to over 20 countries. I'm also a U.S. citizen who was born in New York and have lived in 3 different states. I'm submitting this testimony in support of Senate Bill 211 because it needs to get passed so that everyone who has a PBJ is not deported. A close family member who has DACA received a DUI in 2020. After he went to court, his charge was a PBJ. He completed alcohol counseling classes even before his court hearing and is working on paying the fine still incurred by the court. He made a mistake that night in 2020, but has taken full responsibility for what happened. This family member is married and he has a small child. He also owns his own business, owns his own house, and pays taxes loyally every year. His child is the most important thing in his life, and every day we worry that this PBJ could lead to deportation and not seeing his child grow up every day. He takes his child to sports activities, indoor playgrounds, and more, and his child loves his daddy. The family member and the rest of our family treat every day as special in case his days in the US are limited. What happened almost 2.5 years ago was a wake-up call for him, and things truly got better for all of us after he realized what he had done. The fact that a PBJ could break apart this family and cause a little boy to lose his father has been very stressful and heart-wrenching for all of us. This family member has been in the US for 17 years, and this is the only incident on his record. So I am pleading to our elected officials, please, that SB 211 is passed so that no other family is affected by PBJ and no one's subjected to deportation because of the PBJ on their record. Thank you very much.
Thank you very much, Ms. Alonso. Thank you for hanging in there with us until late in the evening. All right. I think that completes the testimony for the proponents of the bill, and we'll now switch over to the opposition with Mr. Kroll. Come on up. No, my fault. Go ahead. Sure, is Mr. Gross in the room? Okay, I think he's here. So, Mr. Kroll, my apologies.
Quite all right. I'll step back, please.
All right. We're porting him into the room. I think he's in the waiting room. See.
Thank you.
No, thank you. Thanks for waited all this time. Oh, thank you. Is he coming in the room? All right.
I apologize for being late. My name's Andrew Gross, and I am a veteran, and I have dedicated my career to advocating for veterans as my job as a lawyer. And you might be thinking why we're talking about this bill in the context of veterans. First, I'd like to point out that there are currently 90,000 veterans who are lawful permanent residents who, if they run afoul of the law in Maryland and get a probation before judgment, they could be facing potentially deportation of the same consequences. But the reason I was asked to speak today is because when we talk about things like good order and discipline in the military, a probation before judgment can have effect on a soldier or sailor or airman's career, Marine, or what the case may be. And while there is a separate mechanism to ensure good order and discipline in the military, the fact that an individual would have to effectively be found guilty, that weighs against them, and that is, again, putting their career at jeopardy. Likewise, an individual who holds a security clearance, if they have a finding of guilt, that can be held against them and ultimately adjudicating the security clearance. If the purpose of a probation before judgment is to acknowledge wrongdoing and put somebody back on the path to correcting and atoning for whatever their misconduct is, and ultimately not holding it against them with a conviction, then likewise, there shouldn't be barriers put in place that, like, could risk losing your job, because that is an impediment to getting your life back on track. And with that said, removing the finding of guilt and realigning the probation for judgment will help not just immigrants who are here with lawful permanent residence, but also veterans and individuals who hold security clearances working for the government or government contractors. With that, I have nothing further, and I refer to my written testimony.
So thank you very much, Mr. Gross. Thank you. Glad we could squeeze you in. All right, now, Mr. Kroll, you're up.
Members of the committee, good evening. I'm Stephen Kroll, the State's Attorney Coordinator, Executive Director of the Maryland State's Attorneys Association, and I've been trying cases since October of 1994. First, Mr. Chairman, in the infamous words of a famous actress, do not play that gong. I'm going to have my say this evening. I've sat patiently back there. They usually say that when they play the music in the Academy Awards. So, okay, first, a stet, since none of the defense attorneys seem to know, it's for a period of 1 year where either side could open it, 3 years for good cause shown. So I just want to put on the record what a stet time-wise. Senator West, I've not received your amendments, so I can't comment on them at this point in time, but I'd love to see them when you get them, just to tell you. There is a way to do this. I've said it for 4 years. And I'm telling the AG, Mr. Welter, let's use the right language, defense attorneys. You go on a not guilty statement of fact. The problem is, under the federal law, when you say agreed, that takes it to what they're talking about. And I've said, Mr. Welter, do not say agreed statement of fact. It's a not guilty statement of fact, and that prevents deportation. Once the defendant agrees to it, that statute is enacted and bells and whistles go off. So please do not say agreed. We are not using that term, please. This bill, and if Judge Baer wants to know why we changed our opinion, he could have called me. We told the proponents why. I'm happy to explain it in an open forum. However, for my time that I have here today, the problem with this case is we said we want consent to do it. It is a defense attorney's dream. Jill Carter will have a great time as a defense attorney. on this bill because there is no entry of guilt. None. So there's a violation of probation, restitution's not made, somebody doesn't go to DV counseling, somebody doesn't do what they should do on probation. It's got to be retried and redone because there is no entry of guilt. And Juanita Fisher yesterday in her hearing said it's the same as a stet or probation light. She's right. It's got to be retried. Maybe it was a Freudian slip, but she's right. It is a stet. It is not probation before judgment. There's no entry of guilt. And in turn, it has to be retried. How is that fair to a victim or witness? A redo. There's no redos in law. There must be a finding of fact, an entry of guilt, and a period of probation or some sort of verdict afterwards. That's the way it works every day in court. Come see it work. It happens. But again, a not guilty statement of fact is the way to do it from there. It is malpractice for a defense attorney not to go on this PBJ because they can tell their client, you haven't been found guilty because there's no entry. Can't get a piece of paper that says you've been found guilty. You have not been found guilty. It is a dream for every defense attorney. We are for keeping families together. But this statute will be for every defendant, not for those that all the proponents talked about. And again, the Jill Carters in life, the John Cardins who are there in the House, defense attorneys dream. They want this to happen. What does that do for the victim or witness? It does nothing at all. There seems to be a lack of trust because the proponents fear that most certain prosecutors will not go and use this particular statute. I suggest different. It is there for that purpose and that purpose only. For those people who shouldn't be a family broken because of what someone did. And again, we want families to be kept together. In conclusion, I know it's late. I don't want to take any more time. There is a way out of it. Not guilty, statement of fact. This bill will create more problems. There's a history of PBJ law that's tried, true, and done right. Who knows about this? Oh, Mr. and Mrs. Victim, you got to come back in 2 years because we thought it was going to be that way. We thought it was, but Kroll said it wasn't, and he was right. Hindsight 2020. We don't want to tell our victims and witnesses they deserve better, and the PBJ statute should be left alone. And for that reason, Senate Bill 211 should get an unfavorable report. I know there's going to be questions for some reason. I'm happy to entertain them. Thank you for giving me the time, Mr. Chairman.
Thank you, Mr. Kroll. So just so I understand your position, so Mr. Giannetti said this bill is just a cleanup. Just a cleanup, he said. So do you agree with the statement that this is just a cleanup?
Mr. Giannetti first was the only person to say not guilty statement of fact without the agreed. He's the one who got it right. So let's make a record of that. It is not a cleanup. It is a new PBJ. So it's going to be two PBJs on the record. The PBJ where you don't entry a guilt and a PBJ where there is a finding of guilt. You're a defense attorney. What's the best for your client? The non-entry of guilt. It is not a cleanup. That is a misinterpretation of the statute.
So this is a fundamental change. So now you have PBJ and PBJ light, as someone indicated earlier. So
That's a good term.
Our PBJ is almost 50 years old.
Tried, true, and tested.
And so what I hear the judiciary saying in their opposition to the bill is that essentially you're throwing something new into our criminal justice system, replacing something that is 50 years old, and the blast radius of that new disposition is unclear and unknown.
Exactly.
So I'm trying to understand, because the advocates behind the bill were so definitive that someone who breaks the consequences or the conditions that are placed on them, it would be just like a PBJ.
It's a handshake.
Tell me about that. So can someone be accountable for the conditions that are placed on them?
No, because there's no entry of guilt. If they violate it, you have to retry the case. Then they're found guilty under the original PBJ statute. They can still get a PBJ.
Yeah.
Second time. There's a different statute from there. And in turn, then be subject to the conditions of probation and the violations thereof. But without an entry of guilt, there are no consequences at all, other than a handshake to the judge.
And so is your sense that this kind of PBJ light would be something that is rare if this statute passed? Or, well, I guess the question is, why would a defense attorney agree to a PBJ if we vote this bill out, when now a PBJ light is available in every circumstance?
They take the PBJ light any day. It's in their best interest. It would be malpractice not to.
So, I mean, what it sounds like is the 50-year PBJ essentially, for all intents and purposes, goes away after this. And the PBJ light replaces the PBJ in our statutory scheme.
Exactly.
And because of that, we have no legal mechanism to hold people accountable for the conditions of the PBJ light.
Exactly.
So like on an unrelated issue this morning, we had something related to DUIs and interlock devices. So if a condition of the PBJ light was that they utilize the interlock device because they had a significant DUI or were an alcoholic or otherwise, we needed to ensure that safety, and then they disengaged the interlock or refused to use the interlock, there would be no way to hold that person accountable to ensure that they didn't drive drunk on our roads.
Free pass.
All right. I think I'm starting to understand the consequences of this bill. Like Senator James, I just want to be clear. I support the intent of this bill.
I agree. We all want to keep families together, but it's the execution and the practicality that cannot be executed.
And one last thing, Mr. Chair, because you mentioned your proposed amendment that requires the state's attorneys to assent to this if we're going to move forward with it. And it seems like the judiciary, which wrote to oppose the bill, is essentially saying the same thing, because in previous years, this has been compared to a Virginia statute, which is intended to do the same thing. And I just wanted to read the court's opposition here, because they seem to come on board with your amendment. It says, of course, a defendant must enter a plea before the court can proceed, so the lack of clarity on the plea itself is an important area of confusion that must be addressed. The court is required to conduct a full examination of the defendant on the record to ensure that the defendant is freely and voluntarily entering the plea with a full understanding of the nature of the charge and the consequences of the plea. These are fundamental constitutional principles. Based on the language of the bill and the purpose behind the legislation, this new plea, what we're calling the PBJ plus here, that's my language, not theirs, cannot be a guilty plea or a plea of nolo, which currently have federal immigration consequences. As such, the bill beginning on page 2, line 27, through and including page 3, line 2, allows the court to enter into a probationary disposition at sentencing in which the defendant pleads not guilty. Of course, that plea and the plea litany is required at the outset of the matter. That is likely one reason the Virginia statute requires an agreement between the state and the defendant at the outset. This bill contains no such clarifying provisions nor any such requirement. Are they essentially saying their concerns, which are constitutional, and the reason this bill differs significantly from the Virginia statute is because it doesn't include the proposition that you're making, your amendment, that the state's attorney assent to this agreement beforehand?
Yes. And in turn, any plea agreement, who announces the plea? The state's attorney. They're the ones who initiate it and have to agree to it to start the proceeding. This is no different.
Got it. Thank you, Mr. Kroll.
Thank you, Mr. Chairman. Far be it from me to joust with Mr. Kroll, who's been trying cases since about when I was born. But I don't know.
84.
I find it hard to understand your objection. So there's no question that we've had a version of probation before judgment since 1975.
That's correct.
And this bill proposes to adopt a second version of probation before judgment.
Two different PBJs.
I understand. They're structured differently. There's no reason why this General Assembly can't pass an official law of the state of Maryland, which creates a second version of probation before judgment, is there?
I didn't say it can't be passed, but I'm saying it's impractical to victims and witnesses.
Why is it impractical?
Imagine you're a victim and witness of crime. Imagine that.
I'm a witness of a crime?
Victim or witness.
Okay.
Either one. If you're a witness, you have to come back again. But more importantly, you're a victim. Witnesses would have to come back a second or maybe even a third time. But a second time, and you come to court and they say you get restitution in the amount of $1,000. The defendant doesn't pay it. Judge brings that person back to court. They'd have to do it on a show cause. There couldn't be a violation of probation because there's no entry of guilt. You're not going to get your money. How's that fair to you in a redo? There are no redos in the Maryland annotated code. And what you're doing with the second probation before judgment is creating a redo. How is that fair to a victim or a witness to come back to court twice?
Stop. The bill provides that there has to be an agreement made in accordance with this paragraph and placed on the record. And the court makes the finding that there are sufficient facts to support a finding of the defendant's guilt, but that the court does not do so and instead imposes probation before judgment. There is an agreement on the record that the defendant has waived his right to trial and has waived any appeal. So then the bill provides, if the court finds that the defendant has violated the terms of the probation agreement, I read that the defendant doesn't have to be there. There's nothing in this bill that requires the defendant to go back to court on some kind of a show cause order. If the court finds the defendant has violated the terms of the probation agreement, A, the court may find the defendant guilty of the underlying crime as a result of the violation, and B, on a finding of guilt, the court may sentence the defendant up to the maximum penalty for the underlying crime. So if the General Assembly passes this language, are you saying that it's unconstitutional, that it's unenforceable? That you can't argue that it's different from what we have right now, and therefore it doesn't work. On what basis, if we were to pass this as a law, can you contend that this is not effective?
Well, let's start with the first thing, where it is unconstitutional. A defendant who does not appear in court and is sentenced. You got a bunch of defense attorneys right now who are saying, I can't wait for that to happen. So let's talk about the unconstitutionality of not being present when sentenced. That is a confrontation and must be present in order for that confrontation to continue.
Why? If the defendant has agreed on the record.
You could agree or she could agree all they want, but I'm telling you, ask any good defense attorney, and I think quite candidly, that's a non-starter for a constitutional violation. Second of all, you got a handshake agreement and no entry at all. It's a handshake agreement. It's like a PBJ. It's a misnomer. At least a PBJ, the
It's not
original
just a
one.
handshake, it's placed on the record.
But there is nothing to make it enforceable because there's no finding of guilt. The pattern is, the constitutional pattern is, there is a statement of fact, not an agreed one, a statement of fact. There is a finding of guilt and an entry of guilt on the record. There is a sentence. If someone violates it, they can go back and the judge can impose the original sentence or up to the maximum of the original sentence.
Right.
Assuming the defendant
And
is
the
there.
defendant has agreed to all of this on the record.
And now we have defense attorneys saying, I didn't understand it at that time. It wasn't knowingly, voluntarily, intentionally. I didn't agree to it. I didn't know what was going on. It was so fast because so many cases, because everybody says this is the fast way to do it. And now I don't agree to it. I don't agree to it. And I'm not going to agree to it. And I didn't agree to that handshake. So what are you going to do then? How are you going to enforce it when it's not an entry at that point in time? It's a redo. Not fair to victims, not fair to witnesses, constitutional problems on the must appear and the challenge to the confrontation.
So you're saying even though the defendant was counseled as to what the defendant's rights are and has explicitly waived the defendant's rights to have a trial and waived the defendant's rights to appeal any verdict that might be entered or judgment that might be entered down the road if the defendant fails to comply with the probation agreement, even though the defendant has agreed to all those things, there's a lack of due process when the judge actually complies with the agreement and sentences the defendant to some term in prison.
Yes, and imagine all the cases that would tumble and fall as a result of that we didn't think smarter. We thought quicker and we should have done the right thing. And the right thing is not pass the statute.
Okay. We'll talk again. By the way, I've got this amendment for you. I'll give it to you.
Good, thank you.
No, thank you both. That was good. Senator Carter.
Thank you, Mr. Chair. Mr. Cole, this might come as a surprise to you, but I don't agree with your opinion about this for a couple of reasons. One,
That doesn't surprise me.
we already have the ability for a defendant to agree to accept something in absentia. We often do that now in court. A stat in absentia, but also
And again,
they
that's
can
not
waive their
finding
right
guilt.
to be present at the arraignment. They can do that in absentia. There are many, many things in the process now that we allow a defendant to agree to without being present at court.
I'd say if someone post-convicted that particular sentence without being in court, it would be very, very difficult for me to stand up there after 39 years of doing this and say there isn't a post-conviction that shouldn't be granted.
I understand your position, but I think that Senator West actually hit it because it's something that's been agreed to on the record, and all one would have to do is go back and review the record and recall that the defendant made an averment on the record that they understood and they were knowingly, voluntarily entering into this agreement.
Well, who's going to sign the probation form if they're found guilty and there's a redo? You got to be there to sign things. You got to be there to be confronted. It's a constitutional right. Waiving still subjects a particular defendant to say, I didn't agree to that. And what are waived? Instead?
I think now they can do it into it. I just think that that's not that shouldn't be the definitive thing. I think that we have to we'll cross that bridge when we come to it. I don't think it's a real thing. One, I think we're not saying that the defendant will never be there. We're saying that if a situation occurs, there could be some occasions where the defendant isn't there. Absolutely. I think it could be the case that the court would say, you got to come back in, they get a summons or a warrant for sentencing because they violated the terms and now the PBJ is off the table. Then I think that the court is well within its rights to send out a summons or a warrant to say, come in for your sentencing, especially if the sentencing involves incarceration. So there's no way around that.
How can they issue a warrant for something that isn't there? There's no entry of a judgment to issue a warrant for.
We've been down this road before because it's
I know
already
you've
been
all
agreed to
debated
on the
it.
record that if the
I
terms
know.
are violated, that the sentence can be imposed. And the other thing I was just going to point out, I understand your point about the state must agree, but right now under the current PBJs, the state doesn't agree. What's agreed to is there will be a plea. And sometimes you have a state and defense agreeing to what to PBJ, but quite often, I'd say not more often than not, but quite often, the state does not agree to a PBJ, says that defense is free to argue for the PBJ, and then it's up to the court's discretion to enter the PBJ, many times over the state's objection right now.
What we're trying to do is make this statute work to try to keep families together. So that's why we're suggesting the state consent to it from there in an effort to try to keep families together. We're trying. In turn, we think this is the best way. We still have problems like the judiciary has about the execution of everything. But this is a way to try to say, look, we agree, we want to keep families together. And we're looking for some, I don't like to argue outside the box, I hate saying that, but some alternative ways of trying to make things better for people, if we can.
So this is exactly why I love this committee, and for the law students, this is very good. Say it's to be an education. This is so thank you all for hanging out with us. All right, Senator Folden, keep going.
Thank you, Mr. Chairman. I'm not going to belabor this issue any longer. I just want to be very clear and succinct. I've been involved in a lot of sentences with offenders. And at no time, the examples given by my good friend from Baltimore were none of those examples that were in absentia were any of those where there was a rendering of a guilt or a finding of guilt, because upon a finding of guilt, you can be abstention for a stat. You can be an abstention for the arraignment. There's no guilt finding there. When we come down to the day of sentencing, what is required of the person, the subject, the defendant, whatever we want to say, to execute, to make that an actual formal agreement that validates that part of the process?
Constitutionally, they have to be there.
They have to be there, but at the conclusion of that, do they or do they not have to sign into that agreement that they agree to the conditions of probation?
That's how we secure that contract if they violate.
Correct.
That they knowingly, voluntarily, intentionally.
And that's
that agreement.
Correct. So that's the part where I agree and I hear what you're saying, because that's the part that needs to be remedied to make this whole.
Absolutely.
Okay, that's perfect. That's just want to make sure we got that. Thank you.
All right, seeing no further questions, this has been a real pleasure. So thank you very much. This is good. This is very good. This is very good. So thank you for the proponents and the opponents. It was very good. So with that, that'll conclude the testimony in the hearing for Senate Bill 211. We'll now move on to Senator Sidnor with Senate Bill 192. Just as a look, we were here at 12:30 last night. We've got two more bills and I think a significant number of witnesses. So let's just, okay. So let's just keep that in mind. That's all.
And are my witnesses still in they're in there? Okay, very good. Shall I go ahead and start? All right. Senator Sidnor here to present Senate Bill 192. Everyone has my written testimony. This bill is familiar to most of you. For those of you who is not familiar, I'll just give somewhat of a little background. About 2 years ago, I came before this committee and we attempted to create a task force to look at the way that facial recognition technology was being used here in the state of Maryland. While that bill was able to pass this committee, it did not pass the General Assembly, but that did not stop any of our progress. So all of the members who were in that particular piece of legislation, I reached out to them and we worked over the course of an interim to talk about facial recognition technology. This particular group, it consisted of industry, consisted of educators, it consisted of law enforcement, state's attorneys, defense attorneys, public interest groups that had interest in privacy rights and the like. Anyway, fast forward, out of those months of meeting, I put forth legislation last year, which was unsuccessful in passing. So I bring back that particular piece of legislation. I believe what happened last year, we got caught up in doing a lot of other important pieces of work, so we were not able to move this legislation forth. And again, I hope that you do read my written testimony. But what I would like to do is this particular piece of legislation, it has about 10 different sections. So section 501 is definitional. Section 502 talks about evidentiary restrictions on results that are generated by facial recognition technology. In other words, that particular section, what we attempt to do is to ensure that when facial recognition is used, that we're not using it, well, it's not being introduced as essentially as evidence without a lot of prophylactic types of things or meet that it meets. 503A1 is what I would call a limitation clause. So what we do, we want to make certain that when facial recognition technology is used, that it's only used for certain types of crimes. We prohibit it from being used to stifle constitutionally protected activities, as well as being used on non-suspects. Why is that important? Back in the early 2000s, Maryland State Police, they were found to have been violating people's constitutional rights by essentially spying on citizens that were involved in that type of constitutional protected activities. We limit the uses of sketches and manually produced images. We also put a prohibition on having law enforcement that uses technology to disclose that a suspect was identified with facial recognition technology. Why do we do that? Because if for whatever reason we believe in technology, and if we say the technology said that was the person, then we're going to believe that's the person. We also prohibited it's a real-time identification. Step back again. Years ago, when I first introduced legislation dealing with facial recognition, I looked to outrightly just to put a moratorium on it because of all of the issues that I heard that were attended to using facial recognition, whether it be racial disparities that were happening or the like. I just wanted to put a stamp on it. that was, again, you bang your head enough times, you realize that wasn't gonna work. So I moved to regulation. Again, that's what this bill does. You look at on January 6th, I know on the federal level, they use facial recognition to identify many of the people who attacked the Capitol. Again, I believe that it has its utility, but it has its problems, hence the bill. So moving on, Section 503C, we have an exclusionary rule. So in other words, if you don't follow what this bill says and how you're going to use facial recognition, the only way that you keep people honest is you with penalties. I mean, that's what criminal law is all about. You don't do right, then there's a penalty that's attached to it. So in case of law enforcement, if you don't follow what we're saying you need to follow, you're not going to be able to use any of that. I'll call it the fruit of the poisonous tree. You're not going to be able to use that in court. 504, we put down a mandate for disclosure because you can ask any defense attorneys. A lot of times we find out that facial recognition is being used by happenstances, not because the prosecutors are telling you that facial recognition was used. So if you're going to be using that technology, we want to make certain that it's disclosed that you're using it. 505 is an audit and report section. 506 is a number of requirements that we have set and the responsibilities that we've placed upon the Department of Public Safety and Correctional Services. Now you'll find testimony where essentially they don't want it. But why were they included? Well, because when I started looking into facial recognition, they were the ones that had the system. And in fact, they were the ones who had participated. We had a participant from DPSCS talking about their use of or the system that was there. And so we wanted to make certain that they helped us for adopting and publishing policies, developing a training program, as well as reviewing and approving facial recognition technology used by all law enforcement agencies. With that said, I also want to point out, we want to make certain that there's one system that's being used throughout the state. So again, DPSCS would have some things to do with that. 507, I call this the in case you misunderstood section. And what do I mean by that? So it states that, I mean, and I've looked at some of the testimony from one of the opponents, and they talked about how it was going to hurt people who may be involved in human trafficking and all that sort of thing. Well, that's not true. That it's provided for within this bill. But here it states that the law should not be read to restrict usage, identifying missing and deceased persons, and 4 other things. So again, we see a utility in facial recognition. We want to make certain that there's no misunderstanding when we're saying when you can't use it, because this is when you can use it. Section 508 deals with certain mandates that law enforcement agencies that use facial recognition technology that they have to adopt, maintain, and post a use and data management policy. Section 509 allows for a civil suit against an agency to compel the agency to comply with this with the law. Section 510 is an annual report so that we know how facial recognition is being used by our law enforcement agencies. 2 other things I want to point out before I turn over to people who are much more adept at this than I am. 1, we would not be the first to do this. I had an opportunity to communicate with Nathaniel Erb, who you'll be hearing from the Innocence Project. And he says several states have passed some form of restrictions. When we talk about the non-exhaustive notes, we have Maine that banned use of other than serious crimes and limited to one system that's only used by the Department of Motor Vehicles. Massachusetts did the same temporarily and created a commission to study the issue, which has recommended institutions of permanent law with similar limitation. Washington implemented restrictions similar to this bill, not limiting to one system. Vermont also passed a ban, but has since revisited to allow for child sex crime investigations. And in Montana, Montana, just the other day, their Republican Speaker Pro Tem has introduced legislation that's very similar to this in terms of making certain that this use in this technology is restricted. What you're going to hear some of the opponents of this bill say, and I wanted to mention this because the bill talks about the database that's going to be used for facial recognition. When I first started looking into this issue, I was told that we used motor vehicle license photos, and we used a mugshot photos. Those were the systems that I was told that were being used. Those are the systems or the photos that we use here within this legislation. Last year, after introducing this, what I learned was law enforcement doesn't necessarily limit it to that. There's a company out there that collects all your photos that you put out on social media, all of your photos. And what they do is they contract with this private company to look at all of their photos, and they want to then take that and essentially create a virtual what am I thinking about? A virtual lineup of any and all pictures that you've then put on social media to determine whether or not you were the person that they're looking for. I find that unacceptable. I mean, none of us should be being used in some type of virtual lineup. So one other thing, again, and I know, and I will be quiet, I promise. We always talk about what does this have to do with the state of Maryland? A friend here, when we were talking about this bill earlier this year, found out, and I'm going to ask you all to ask because my state's attorney is going to come up here and he's going to talk about why this bill is so bad. And I even want you to ask my friend over here from the public defender's office, what happened to this man in Baltimore County with the use of facial recognition? Make sure you ask him. I mean, what I'll tell you is he was improperly identified. He ended up having to go to jail. He had to spend money in order to get an attorney to be found out that it wasn't him. These stories happen all across the United States. We've had cases in Louisiana when people were accused of crimes and they've never visited the state. This technology is something that can be useful, but we have to make certain we have some certain restrictions on it. And with that, I rest. Thank you.
Thank you, Mr. Chairman. Thank you, Senator Sidnor and members of the committee. Good evening. My name is Andrew Northrup, and I am a public defender in the Forensics Division, and our position on this bill is favorable. And as Senator Sidnor was alluding, on March 31st last year, Alonzo Sawyer was arrested and held without bond in Baltimore County for assaulting an MTA bus driver and stealing her phone 5 days earlier. This arrest was based solely upon a facial recognition hit confirmed by his probation agent, a probation agent who had met him only a couple of times before, and during those meetings, he was wearing COVID masks. He was cleared of these charges only because his wife was very persistent, would not take no for an answer, and got the probation agent to recant the faulty identification by pointing out the error of his ways. How did this happen? The fundamental problem that we have as human beings is that we believe that we are good at facial recognition. We are not. This is something that seems intuitive to us, but it is not. A 2015 study of Australian passport officers, mind you, people who pick out faces for a living, were asked to pick out a face in lineup, were wrong 50% of the time, with 80% of those errors being false inclusions. So even if the algorithm is perfect, and you're going to hear about how great the algorithms are, we are not, because the algorithm will give you a selection of candidates, but it's ultimately up to the human being to pick it out. And that's something that we are not good at. In fact, unlike other forensic sciences, analysts in Maryland don't even have proficiency tests. This bill will change that. What is particularly troubling about the Sawyer case, it occurred in a jurisdiction where the proper procedures were followed and the corroborating evidence was collected. In other jurisdictions, we've seen charges or no-knock warrants issued solely based on the hit itself. And Ms. Levy will talk more about that. This legislation will set up minimum standards for when and how facial recognition can be used in investigations. It requires additional independent evidence not somebody taking a look and saying, it looks like him. Independent evidence for establishing probable cause. It also sets forth discovery and transparency requirements. Our office still has grave concerns about the use of this technology. My personal fear is that bad facial recognition hits could conceivably replace eyewitness identification as a major source of wrongful convictions. Nevertheless, this bill is a good step forward and to regulate what is currently unregulated. Thank you.
All right, thank you very much. We're going to switch to the proponents of the bill who are testifying virtually. So we'll go with Ms. Levy first. Deborah, you're up. Welcome.
Thank you very much, Senator. As Mr. Northrop said, I litigated a case with my former and current colleagues in Baltimore City using facial recognition. That information was withheld from us for over a year. After we realized that facial recognition had been used, we queried other jurisdictions across the state to find out when is facial recognition being used and what kind of discovery is being provided. Here's what we learned in our query. We learned that folks who are not trained in facial recognition, basically administrative assistants in Baltimore City, former probation and parole officers, are making identifications that form the sole basis of charges going forward. We also learned that discovery varies from one jurisdiction to another. I didn't provide this written because I want to keep it anonymous, but this is what's called a lineup that would be produced by facial recognition. In this particular case that I just held up, the second suspect, in other words, the documents print out a likelihood of a match. The government in that case didn't pick the highest most likely suspect. They picked the second most likely suspect. There's only one case we could find where that lineup was disclosed. In other cases, we find that emails are disclosing that facial recognition was used. And I guess I shouldn't have blurred my background because this is a one-page facial recognition match report. We have two-page facial recognition reports. All in all, across the state, these documents are not being disclosed consistently, and exculpatory information is being withheld. We're asking you to support this bill because, like DNA discovery, like intoxilizer discovery, like fingerprint discovery, it's going to make a uniform requirement across the state. So if you're using it, which at base we don't necessarily support, but we support it with these regulations, let's make discovery consistent across the board, across the state. Thank you so much.
All right, thank you, Ms. Levy. All right, we'll go with Mr. Erb. Good to see you.
Good evening. Good to see you, Senator. For the record, Nathaniel Erb here on behalf of the Innocence Project in support of Senate Bill 192. Importantly, the bill restricts the use of facial recognition to serious crimes while allowing use to identify missing children, deceased persons, and for other public safety concerns. For example, the bill allows for use of tools to identify children who are exploited through human trafficking. That is of particular importance to myself as someone who spent many years representing anti-trafficking organizations here in Annapolis, or there in Annapolis. We have three primary concerns with the use of facial recognition. First, community agreement to surveillance is not often sought or properly weighed. Particularly, many systems use the images of people without their consent. Second, the reliability of the technology is often unclear. If a reliable technology is being used, it can lead to tunneling towards the wrong suspect. We see through wrongful convictions that innocent people can be misidentified and exculpatory evidence ignored because there is a belief in the means that identified the suspect. That's compounded when there is a piece of technology purported to be more sophisticated than the human eye and brain. Lastly, there simply isn't yet adequate training to ensure accurate identifications. What training exists is focused on how to use the systems, but not how to ensure the systems are functioning properly and not misidentifying innocent people. Currently, facial recognition is being used in Maryland without limits and without oversight. While we do not yet have trust in these technologies, nor the belief that communities in Maryland have been properly consulted on their use, in order to move beyond our general position of a moratorium, we support Senate Bill 192 because of a strong middle ground between all perspectives and would caution against weakening it. I want to thank the Center and all the working group members who compromised in its development. Senate Bill 192 is a good step forward, developed by many perspectives, and we urge a favorable report. Thank you.
All right, thank you. Mr. Paserno, you're up.
Good evening, members of the committee. My name is Nick Paserno. I'm a captain with Montgomery County Police Department. I'm also one of the authors of our facial recognition policy, and I maintain oversight of our facial recognition capacities. There are many facets of this proposed legislation that are in line with best practices, facets which exist within our current policy. I wholeheartedly agree that facial recognition should never be used as an element of probable cause in the charging document or search warrant affidavit. Facial recognition should only be used or solely be used as an investigative lead that requires separate independent corroboration. Essentially, it should be treated much like an anonymous tip. My concerns with legislation are limited to 3 elements, which are also concerns raised by the Maryland Chiefs and Sheriffs Association. Those concerns are the restrictions of the types of crimes where the technology can be used, restrictions on limiting the softwares that can be used, and restricting the pool from which comparison images can be pulled. Like the proposed legislation, MCP policy also limits the types of crimes that facial recognition can be used for. However, unlike this bill, our policy permits the use of facial recognition in crimes involving firearms, weapons on school property, child pornography, subjects involved in organized crime, hate bias incidents, domestic violence, cruelty to animals, certain crime trends, and identification of witnesses of the above offenses. So when a subject assaulted children hanging flyers in the Capitol Crescent Trail, or when a child was being abused in a TikTok video, or when a subject indecently exposed himself on a doorbell camera, we were able to use facial recognition to identify an investigatory lead that eventually resulted in the conviction of suspects. This proposed legislation would restrict use in those cases. Limiting technologies to one source acts as a barrier to competition. Competition between technology vendors pushes innovation, results in better products. Having technologies also meet certain standards, such as NIST validation, guarantee effectiveness, and be a much better way to ensure law enforcement is using quality products than restricting to one vendor. Finally, I want to caution that overregulation of this space could lead to a form of technological vigilantism. Facial recognition platforms are no longer costly, complex systems. Private citizens can use publicly available systems for around $250 a year. If crime victims can't rely on law enforcement with their images, the private sector will step in, resulting in unvalidated anonymous tips to police, which will not have the same regulation and validation as current best practices. I ask you to keep these concerns in mind as you consider this legislation. Thank you.
All right, thank you very much. I think that's it for the proponents of the bill. Seeing no questions from the committee, thank you both very much. Thank you all for testifying virtually. We'll now turn to the opposition panel and go with Mr. Schellenberger. Mr. Schellenberger and Mr. Parker, right?
Correct.
Yeah, excellent.
So tonight has improved. Last night I was the last bill. Tonight's the next to last. Senator Sidner, please look at me. We're close. We're getting close. Your own witness just listed some objections that I have. And so I would ask you to rely on him when he says that that we're missing some crimes. And that is one of the first problems that I have with this bill as currently drafted. He mentioned one that I have on my list, and that is child abuse. We don't have child abuse on there, and therefore we should add that because it is not a crime of violence or not one of the crimes. Your own witness also mentioned firearm possession. I think that should be on there. So I agree with your list of crimes, but we need to add firearm possession, child abuse, child pornography. What if we catch somebody on a Ring camera trying to video a child inside their own house? And I want to identify that person. We may need to work on domestic violence cases and also importantly, animal cruelty cases. I think that would be a place where we could certainly go ahead and list. So I agree with your witness when he said we need to expand the list of crimes that can be used. The other thing that I think is really important, and that is this technology was used to arrest hundreds of people in the Capitol riots, hundreds, and they weren't limited to mugshots and driver's licenses. You have to allow us to use social media because social media is where people who, one, live out of state, I can get access to that. It's a lot harder for me to go through 50 databases on driver's license. And two, a lot of those folks had never been arrested before, so there are no mugshots. And social media is where they caught a number of people in the Capitol riots by using facial recognition technology, capturing their picture as they were in the Capitol, and then comparing it to social media and pulling up the individuals who they saw. It's a very important tool. We can't limit it to just mugshots and driver's licenses. Need social media. You say no live. Why can't we have live? What if we had been better prepared at those Capitol riots to be able to identify people right away instead of 6 to 7 to 8 months later, 2 years, a year later. That's another thing that I think is important. Expand the number of laws, allow us to use social media, allow us to use live. And I absolutely agree with Ms. Levy. You know, you want discovery, I will turn it all over to you. I am a big believer in discovery. You talk to a lot of defense lawyers in this state and ask them what jurisdiction does a good job in discovery, and I guarantee you ours comes up very frequently. I absolutely believe in discovery, and I believe we can put all that in the law. Now, let's talk about the Sawyer case that was mentioned that happened in Baltimore County. And that case is problematic. Just so you know, last night when we had the briefing in the House, Mrs. Sawyer was on the call, and I did apologize to her and ask her to give my condolences to her husband, who did spend 9 days in jail improperly. The problem in that case is it wasn't facial recognition technology that failed. It actually was used the way we're going to do it in this bill. So what happened was there was a confrontation on an MTA bus. An individual stole the driver's phone and also struck her at least 4 times in the face. That confrontation was caught on the camera. They ran the picture through facial recognition, and it came up with an individual who happened to be Miss Sawyer's husband. When they finally went and got the picture and were able to identify who this individual was, they found out that the person was on probation with a probation officer. They went to the probation officer, showed him the picture, and he said, yes, that is Mr. Sawyer. And it was based upon that identification that they made the rest. Well, that's how this statute is set up. It's set up that you can't solely rely on facial recognition. You have to have more evidence. And so we followed that procedure in this case. Fortunately, Ms. Sawyer was a great advocate for her husband. She called our office and convinced one of my prosecutors that he was not the individual who did that. We did some more digging, and within 9 days of receiving her phone call, we immediately let him out of jail. And at the next available court date, we dismissed the charges. I believe that we can still use this statute to do better. And I believe that there are a number of restrictions that we can easily agree to that follow your thing. I think we just need to take those 3 parts out. And I also can tell you that Mr. Parker, who's going to come up next, has a draft of what we can live with. And I think you're going to like a lot of it. And I don't mean to keep looking at you, but I want us to continue to work together like we have. I think we can get to a place this year where we can have a working facial recognition statute that we can all live with. And thank you very much for that clock.
Hi, Mr. Chairman, members of the committee. Jake Parker here with the Security Industry Association in Silver Spring. We represent security and life safety technology companies, including the leading providers of facial recognition in the U.S. So this technology is not new, though it has dramatically improved in the last few years. For over a decade, Maryland communities have benefited from increasing the accuracy and speed of investigative work technology. Overall, we believe the effect is to help limit human bias and reduce unnecessary contact with police in our communities. I provided 30 success stories in my testimony, and that's just the tip of the iceberg. We understand the concerns raised about how this might be used in the absence of uniform rules and to make sure it's used appropriately. We support the core protections, like having a statewide policy that is the same across counties and cities, ensuring software can't be used as the only reason to arrest someone or to be used against them in court, and ensuring it will not stifle constitutionally protected activities. There's consensus on these, as Mr. Schellenberger alluded to. However, the bill would also eliminate current capabilities being leveraged by Maryland law enforcement to protect us, and that is the problem. among some others. But it's the key reason why it is opposed by the Maryland State Police and the Chiefs and the Sheriff's Association. A single platform and data source means no way to identify or help someone without a criminal ID in the state, or to simply analyze open source information that's already available to us. It also would prevent use of regional criminal record sharing systems has been leveraged successfully with Virginia and other states. The complete prohibition on minor images hamstrings investigations of child sex crimes. Also, with the unnecessary limitation to a narrow set of crimes, these restrictions would serve only to hamper and delay investigations versus provide any public benefit to narrowing that. In other testimony submitted, you'll find a letter from Becca Charleston, a sex trafficking victim, who says this prohibition on queries involving minors puts children at risk. The National Child Protection Task Force says that law enforcement only has images of helpless children's faces with no way to identify them and bring them to safety. The best source for those images is the internet and the dark web. Without facial recognition, it would take months to search this manually. Despite these concerns, I think there is a path forward to build public trust, guard against the possibility of future misuse, and fully preserve the proven benefits. Thank you.
Excellent. Thank you very much. All right. Questions from the committee? Seeing none, that will conclude the testimony and the hearing for Senate Bill 192. Thank you, Senator Sidnor. All right, we'll now turn to the final bill of the evening, Senate Bill 33, Senator Carter. Senator Carter, you're up.
Thank you, Mr. Chair, members of the committee, for your stamina. I promise to be very brief. I probably would like to go as much, if not more than many of you today. This bill is a simple fix to the law, and it shouldn't be complicated at all. Briefly, I'll call up my panel: Yannette Emanuel, ACLU of Maryland; Elizabeth Hilliard, Office of the Public Defender; Lila Meadows, University of Maryland Clinical Law Program. This is the fix. You all well remember that in the 2021 session, we passed the law to take the governor out of parole. It was an effort that had been taken the course of many, many years to get done, and finally we got it done. Well, we made an omission where there's a certain area of parole that we didn't address, which is medical parole. Now, this bill isn't creating a new standard for when someone should get released. It's not changing anything about what's already in the law. We already recognize medical parole in the law, and there's a criteria that people have to meet. All this bill does is put this in the same posture. Medical parole is any other parole, where basically it's not a decision of the governor, as we said parole should not be. And in the fact that we've made the omission, we've actually, it's been harmful to some of our Marylanders, because it's my understanding that from the time that we passed the governor out of parole law until now, there have been 5 inmates that have passed away while awaiting relief under this. And so it's just a fix. It's not changing anything. It's not adding anything. It's saying medical parole is the same as other parole. And actually, this is probably the most important one that we should have addressed. If we were going to make, a mistake, it should have been the other one, not the people that are about to be no longer with us. So with that, I'll be very brief. Hopefully the testimony will go smoothly and we will all be able to have dinner. Thank you.
Good evening, Senator Smith and members of the committee. My name is Yannette Emanuel, Public Policy Director with the ACLU of Maryland, here in support of SB 33. As Senator Carter mentioned, SB 33 would eliminate the need for gubernatorial approval for medical parole for inmates serving life imprisonment sentences, creating needed uniformity between medical parole process and all other parole processes. In 2021, the General Assembly voted to remove the governor from parole for people serving life sentences, and we are grateful to all of you who worked to ensure the passage of this important legislation. It was clearly the legislators' intent to establish that Maryland Parole Commission would be the final decision maker for all parole decisions for Marylanders sentenced to life imprisonment. And as Senator Carter just mentioned, the section of the code pertaining to medical parole was mistakenly omitted from the bill draft, resulting in a situation where only medical parole decisions require gubernatorial action. As a result of this error, medical parole decisions made by the Maryland Parole Commission remain subject to a waiting period of 6 months, which is dangerous and unfair for Marylanders who need medical parole. SB 33 would simply correct this omission. The need for the Parole Commission to be able to act expeditiously is arguably most critical in those cases where the parole candidate is seriously ill or dying. And the 180-day waiting period alone may be the difference between a peaceful death surrounded by family or a lonely death inside prison walls. And indeed, as Senator Carter just mentioned, in 2021, 5 people recommended for medical parole died waiting for the governor to act. Medical parole is awarded under extremely strict criteria. Under COMAR, only individuals who are chronically debilitated or incapacitated by a medical or mental health condition, disease, or syndrome, as to be physically incapable of presenting a danger to society, may be released on medical parole. SB 33 would ensure that a terminal illness does not bar someone from a fair and expeditious consideration of their request for release. And so for the foregoing reasons, the ACLU of Maryland urges a favorable report on SB 33. Thank you.
Good evening. Again, I'm Lila Meadows with the University of Maryland School of Law, where I teach in the clinical law program and represent clients who are seeking parole, including clients who are terminally ill and seeking release under medical parole. I won't repeat Ms. Emanuel's testimony. I'm here to answer any questions the committee has about the parole process. The only thing that I'll say is, again, people serving life sentences are extensively vetted by the Maryland Parole Commission, and we're talking about some of the sickest, most vulnerable people in DOC. I'll also say, as Ms. Emanuel mentioned, there's 180 days that the governor has to make this decision. And in my experience representing clients in that process, the governor takes all 180 days. These are decisions that need to make quickly. There's often not a lot of time by the time someone is recommended for medical parole. And so this is consistent with the actions this body has already taken. And I hope that we can finish this session. There's a real human cost here. Thank you.
Good evening for the third time today. I am still Olinda Moyd, here on behalf of the Maryland Alliance for Justice Reform. We support a favorable report on this bill. Any person who is chronically debilitated or incapacitated by a medical or mental health condition or disease should have the opportunity to seek medical parole. The Maryland Parole Commission, which bears the responsibility for making parole decisions in the state, must be authorized to consider parole release for medical parole compromised individuals without political interference. So it took us 10 years to get the governor out of the parole process for lifers. Let's not let another 10 years go by before we make this small fix and get the governor out of the decision-making process as it relates to medical parole for lifers. As was stated, this is just a legislative fix. It really just kind of levels the playing field for individuals who are medically compromised and eligible to seek medical parole. In my written testimony, I share the story of Mr. E, who was someone I met many years ago, who is still at JCI, and I share his garden variety of medical conditions and how they have worsened over the years. He too was denied medical parole by the governor. And so I ask that you do the right thing. Let's not wait another 10 years. Let's get this medical fix done. I believe for Marylanders, now is the time. Thank you.
I'm back. I do sort of wonder if frequent flyers should get like walk-up songs like we do at baseball games. I have some ideas. We are in complete agreement with everything that's been said. I will just also note that I have spent time with someone dying in the Jessup healthcare facilities. It is not a place where we can allow someone to wait 180 days for gubernatorial parole approval. It is not suited for people who are bedridden, who are dying, and who need intensive health care. We urge a favorable report, and we thank Senator Carter for bringing this bill. Thank you.
Hearing none, thank you.
Thank you. Thanks, committee. Thank you.
On to E. Mr. Parole.
Committee, Mr. Cole informed me that they withdrew their opposition to the bill. So, okay. They didn't understand
We have two virtual. They're not.
Let me just,
Oh,
let me just make sure Will doesn't have
Sure.
anything.
hold on before we leave. Hold on.
Well, hit the gavel. You know you've been wanting to.
I-
Hit the gavel. Say, see y'all.
I want to, but
Hit the
you
gavel. Hit the gavel.
good?
Dang it.
All right.
Voting tomorrow.
We got voting tomorrow, so.
That's right.
No, because Friday's a performer session. So